Lecture Roman 9, Contract Roman 3, Void and Voidable. The elements of fact necessary to call a contract into existence and the legal consequences of a contract when formed have been discussed. It remains to consider successively the cases in which a contract is said to be void, and those in which it is said to be voidable, in which, that is, a contract fails to be made when it seems to have been, or, having been made, can be rescinded by one side or the other, and treated as if it had never been. I take up the former class of cases first. When a contract fails to be made, although the usual forms have been gone through with, the ground of failure is commonly said to be mistake, misrepresentation, or fraud. But I shall try to show that these are merely dramatic circumstances, and that the true ground is the absence of one or more of the primary elements, which have been shown, or are seen at once, to be necessary to the existence of a contract. If a man goes through the form of making a contract with a through B as A's agent, and B is not in fact the agent of a, there is no contract, because there is only one party. The promise offered to a has not been accepted by him, and no consideration has moved from him. In such a case, although there is generally mistake on one side and fraud on the other, it is very clear that no special doctrine need be resorted to, because the primary elements of a contract explained in the last lecture are not yet present. Take next a different case. The defendant agreed to buy, and the plaintiff agreed to sell, a cargo of cotton to arrive ex Peerless from Bombay. There were two such vessels sailing from Bombay, one in October, the other in December. The plaintiff meant the latter, the defendant the former. It was held that the defendant was not bound to accept the cotton. When it is commonly said that such a contract is void because of mutual mistake as to the subject matter, and because therefore the parties did not consent to the same thing. But this way of putting it seems to me misleading. The law has nothing to do with the actual state of the parties' minds. In contract, as elsewhere, it must go by externals and judge parties by their conduct. If there had been but one peerless, and the defendant had said peerless by mistake, meaning peery, he would have been bound. The true ground of the decision was not that each party meant a different thing from the other, as is implied by the explanation which has been mentioned, but that each said a different thing. The plaintiff offered one thing, the defendant expressed his assent to another. A proper name, when used in business or in pleading, means one individual thing and no other, as everyone knows, and therefore one to whom such a name is used must find out at his peril what the object designated is. If there are no circumstances which make the use deceptive on either side, each is entitled to insist on the meaning favorable to him for the word as used by him, and neither is entitled to insist on that meaning for the word as used by the other. So far from mistake having been the ground of decision, as mistake, its only bearing, as it seems to me, was to establish that neither party knew that he was understood by the other to use the word peerless in the sense which the latter gave to it. In that event, there would perhaps have been a binding contract, because, if a man uses a word to which he knows the other party attaches, and understands him to attach a certain meaning, he may be held to that meaning and not be allowed to give it any other. Next, suppose a case in which the offer and acceptance do not differ, and in which both parties have used the same words in the same sense. Suppose that A agreed to buy and B agreed to sell these barrels of mackerel, and that the barrels in question turn out to contain salt. There is mutual mistake as to the contents of the barrels, and no fraud on either side. I suppose the contract would be void. It is commonly said that the failure of the contract in such a case is due to the fact of a difference in kind between the actual subject matter and that to which the intention of the parties was directed. It is perhaps more instructive to say that the terms of the supposed contract, although seemingly consistent, were contradictory in matters that went to the root of the bargain. For by one of the essential terms, the subject matter of the agreement was the contents of certain barrels and nothing else, and by another equally important, it was mackerel and nothing else. While, as a matter of fact, it could not be both, because the contents of the barrels were salt. As neither term could be left out without forcing on the parties a contract which they did not make, it follows that a cannot be required to accept, nor be to deliver either these barrels of salt or other barrels of mackerel. And without omitting one term, the promise is meaningless. If there had been fraud on the seller's part, or if he had known what the barrels really contained, the buyer might have had a right to insist on delivery of the inferior article. fraud would perhaps have made the contract valid at his option. Because when a man qualifies sensible words with others which he knows, on secret grounds, are insensible when so applied, he may fairly be taken to authorize his promisee to insist on the possible part of his promise being performed, if the promisee is willing to forego the rest. Take one more illustration like the last case. A policy of insurance is issued on a certain building described in the policy as a machine shop. In fact, the building is not a machine shop, but an organ factory, which is a greater risk. The contract is void, not because of any misrepresentation, but, as before, because two of its essential terms are repugnant and their union is insensible. Of course, the principle of repugnancy, last explained, might be stretched to apply to any inconsistency between the different terms of a contract. It might be said, for instance, that if a piece of gold is sold as 18-karat gold, and it is in fact not so pure, or if a cow is sold as yielding an average of 12 quarts of milk a day, and in fact she yields only 6 quarts, there is no logical difference, according to the explanation which has just been offered, between those cases and that of the barrel of salt sold for mackerel. Yet those bargains would not be void. At the most, they would only be voidable if the buyer chose to throw them up. The distinctions of the law are founded on experience, not on logic. It therefore does not make the dealings of men dependent on a mathematical accuracy. Whatever is promised, a man has a right to be paid for if it is not given, but it does not follow that the absence of some insignificant detail will authorize him to throw up the contract, still less that it will prevent the formation of a contract, which is the matter now under consideration. The repugnant terms must both be very important, so important that the court thinks that, if either is omitted, the contract would be different in substance from that which the words of the parties seem to express. A term which refers directly to an identification by the senses has always this degree of importance. If a promise is made to sell this cow, or this mackerel, to this man, whatever else may be stricken from the contract, it can never be enforced except touching this object and by this man. If this barrel of salt is fraudulently sold for a barrel of mackerel, the buyer may perhaps elect to take this barrel of salt if he chooses, but he cannot elect to take another barrel of mackerel. If the seller is introduced by the name B, and the buyer supposes him to be another person of the same name, and under that impression delivers his written promise to buy of B, the B to whom the writing is delivered is the contractee, if anyone is, and notwithstanding what has been said of the use of proper names, I should suppose a contract would be made. 1. For it is further to be said that, so far as by one of the terms of a contract, the thing promised or the promisee is identified by sight and hearing, that term so far preponderates over all others that it is very rare for the failure of any other element of description to prevent the making of a contract. 2. The most obvious of seeming exceptions is where the object not in fact so identified, but only its covering or wrapper. Of course, the performance of a promise may be made conditional on all the terms stipulated from the other side being complied with, but conditions attaching to performance can never come into consideration until a contract has been made, and so far the question has been touching the existence of a contract in the first instance. A different case may be suggested from any yet considered. Instead of a repugnancy between offer and assent which prevents an agreement, or between the terms of an agreement which makes it insensible on its fact, there may be a like repugnancy between a term of the contract and a previous representation of fact which is not expressly made a part of the contract. The representation may have been the chief inducement and very foundation of the bargain. It may be more important than any of the express terms, and yet the contract may have been reduced to writing in words which cannot fairly be construed to include it. A vendor may have stated that barrels filled with salt contain mackerel, but the contract may be only for the barrels and their contents. An applicant for insurance may have misstated facts essential to the risk, yet the policy may simply insure a certain building or a certain life. It may be asked whether these contracts are not void also. There might conceivably be cases in which, taking into account the nature of the contract, the words used could be said to embody the representation as a term by construction. For instance, it might be said that the true and well-understood purport of a contract of insurance is not, as the words seem to say, to take the risk of any loss by fire or perils of the sea, however great the risk may be. but to take a risk of a certain magnitude, and no other, which risk has been calculated mathematically from the statements of the party insured. The extent of the risk taken is not specified in the policy, because the old forms and established usage are otherwise, but the meaning is perfectly understood. If this reasoning were adopted, there would be an equal repugnancy in the terms of the contract, whether the nature of the risk were written in the policy or fixed by previous description. But, subject to possible exceptions of this kind, it would seem that a contract would be made, and that the most that could be claimed would be a right to rescind. Where parties having power to bind themselves do acts and use words which are fit to create an obligation, I take it that an obligation arises. If there is a mistake as to a fact not mentioned in the contract, it goes only to the motives for making the contract. But a contract is not prevented from being made by the mere fact that one party would not have made it if he had known the truth. In what cases a mistake affecting motives is a ground for avoidance does not concern this discussion, because the subject now under consideration is when a contract is made, and the question of avoiding or rescinding it presupposes that it has been made. I think that it may now be assumed that, when fraud, misrepresentation, or mistake is said to make a contract void, there is no new principle which comes in to set aside an otherwise perfect obligation, but that in every such case, there is wanting one or more of the first elements which were explained in the foregoing lecture. Either there is no second party, or the two parties say different things, or essential terms seemingly consistent are really inconsistent as used. When a contract is said to be voidable, it is assumed that a contract has been made, but that it is subject to being unmade at the election of one party. This must be because of the breach of some condition attached to its existence either expressly or by implication. If a condition is attached to the contract's coming into being, there is as yet no contract. Either party may withdraw, at will, until the condition is determined. There is no obligation, although there may be an offer or a promise, and hence there is no relation between the parties which requires discussion here, but some conditions seemingly arising out of a contract already made are conditions of this sort. Such is always the case if the condition of a promise lies within the control of the promiser's own will. For instance, a promise to pay for clothes if made to the customer's satisfaction has been held in Massachusetts to make the promiser his own final judge. One so interpreted, it appears to me to be no contract at all until the promiser's satisfaction is expressed. His promise is only to pay if he sees fit, and such a promise cannot be made a contract because it cannot impose any obligation. 2. If the promise were construed to mean that the clothes should be paid for provided they were such as ought to satisfy the promiser. 3. And thus to make the jury the arbiter, there would be a contract, because the promiser gives up control over the event, but it would be subject to a condition in the sense of the present analysis. The conditions which a contract may contain have been divided by theorists into conditions precedent and conditions subsequent. The distinction has even been pronounced of great importance. It must be admitted that if the course of pleading be taken as a test, it is so. In some cases, the plaintiff has to state that a condition has been performed in order to put the defendant to his answer. In others, it is left to the defendant to set up that a condition has been broken. In one sense, all conditions are subsequent. In another, all are precedent. All are subsequent to the first stage of the obligation. Take, for instance, the case of a promise to pay for work if done to the satisfaction of an architect. The condition is a clear case of what is called a condition precedent. There can be no duty to pay until the architect is satisfied. But there can be a contract before that moment, because the determination whether the promiser shall pay or not is no longer within his control. Hence the condition is subsequent to the existence of the obligation. On the other hand, every condition subsequent is precedent to the incidence of the burden of the law. If we look at the law as it would be regarded by one who had no scruples against doing anything which he could do without incurring legal consequences, it is obvious that the main consequence attached by the law to a contract is a greater or less possibility of having to pay money. The only question from the purely legal point of view is whether the promiser will be compelled to pay. And the important moment is that at which that point is settled. All conditions are precedent to that. But all conditions are precedent, not only in this extreme sense, but also to the existence of the plaintiff's cause of action. As strong a case as can be put is that of a policy of insurance conditioned to be void if not sued upon within 1 year from a failure to pay as agreed. The condition does not come into play until a loss has occurred, the duty to pay has been neglected, and a cause of action has arisen. Nevertheless, it is precedent to the plaintiff's cause of action. When a man sues, the question is not whether he has had a cause of action in the past, but whether he has one then. He has not one then, unless the year is still running. If it were left for the defendant to set up the lapse of the year, that would be due to the circumstance that the order of pleading does not require a plaintiff to meet all possible defenses, and to set out a case unanswerable, except by denial. The point at which the law calls on the defendant for an answer varies in different cases. Sometimes it would seem to be governed simply by convenience of proof, requiring the party who has the affirmative to plead and prove it. Sometimes there seems to be a reference to the usual course of events, and matters belong to the defense because they are only exceptionally true. The most logical distinction would be between conditions which must be satisfied before a promise can be broken, and those which, like the last, discharge the liability after a breach has occurred. One but this is of the slightest possible importance, and it may be doubted whether another case like the last could be found. It is much more important to mark the distinction between a stipulation, which only has the effect of confining a promise to certain cases, and a condition properly so called. Every condition, it is true, has this effect upon the promise to which it is attached, so that, whatever the rule of pleading may be, /to/ a promise is as truly kept and performed by doing nothing where the condition of the stipulated act has been broken, as it would have been by doing the act if the condition had been fulfilled. But if this were all, every clause in a contract which showed what the promiser did not promise would be a condition, and the word would be worse than useless. The characteristic feature is quite different. A condition properly so called is an event, the happening of which authorizes the person in whose favor the condition is reserved to treat the contract as if it had not been made, to avoid it, as is commonly said that is, to insist on both parties being restored to the position in which they stood before the contract was made. When a condition operates as such, it lets in an outside force to destroy the existing state of things. For although its existence is due to consent of parties, its operation depends on the choice of one of them. When a condition is broken, the person entitled to insist on it may do so if he chooses, but he may, if he prefers, elect to keep the contract on foot. He gets his right to avoid it from the agreement, but the avoidance comes from him. Hence it is important to distinguish those stipulations which have this extreme effect from those which only interpret the extent of a promise, or define the events to which it applies. And as it has just been shown that a condition need not be insisted on as such, we must further distinguish between its operation by way of avoidance, which is peculiar to it, and its incidental working by way of interpretation and definition, in common with other clauses not conditions. This is best illustrated by taking a bilateral contract between A and B, where A's undertaking is conditional on B's doing what he promises to do, and where, after has got a certain distance in his task, B breaks his half of the bargain. For instance, A is employed as a clerk by B and is wrongfully dismissed in the middle of a quarter. In favor of A, the contract is conditional on B's keeping his agreement to employ him. Whether A insists on the condition or not, he is not bound to do any more. Once so far, the condition works simply by way of definition. It establishes that A has not promised to act in the case which has happened, but besides this, for which a condition was not necessary, A may take his choice between two courses. In the first place, he may elect to avoid the contract. In that case, the parties stand as if no contract had been made, and A, having done work for B which was understood not to be gratuitous, and for which no rate of compensation has been fixed, can recover what the jury think his services were reasonably worth. The contract no longer determines the quid pro quo. But as an alternative course, A may stand by the contract if he prefers to do so, and sue B for breaking it. In that case, he can recover as part of his damages pay at the contract rate for what he had done, as well as compensation for his loss of opportunity to finish it. But the points which are material for the present discussion are that these two remedies are mutually exclusive, one supposing the contract to be relied on, the other that it is set aside, but that A's stopping work and doing no more after B's breach is equally consistent with either choice, and has in fact nothing to do with the matter. One word should be added to avoid misapprehension. When it is said that it has done all that he promised to do in the case which has happened, it is not meant that he is necessarily entitled to the same compensation as if he had done the larger amount of work. B's promise in the case supposed was to pay so much a quarter for services, and although the consideration of the promise was the promise by it to perform them, the scope of it was limited to the case of their being performed in fact. Hence, A could not simply wait till the end of his term and then recover the full amount which he would have had if the employment had continued. Nor is he any more entitled to do so from the fact that it was B's fault that the services were not rendered. B's answer to any such claim is perfect. He is only liable upon a promise, and he in his turn only promised to pay in a case which has not happened. He did promise to employ, however, and for not doing that he is liable in damages. One or two more illustrations will be useful. A promises to deliver, and B promises to accept and pay for certain goods at a certain time and place. When the time comes, neither party is on hand. Neither would be liable to an action, and, according to what has been said, each has done all that he promised to do in the event which has happened, to wit, nothing. It might be objected that, if A has done all that he is bound to do, he ought to be able to sue B, since performance or readiness to perform was all that was necessary to give him that right, and conversely the same might be said of B on the other hand, considering either B or A as defendant, the same facts would be a complete defense. The puzzle is largely one of words. A and B have, it is true, each performed all that they promised to do at the present stage, because they each only promised to act in the event of the other being ready and willing to act at the same time. But the readiness and willingness, although not necessary to the performance of either promise, and therefore not a duty, was necessary in order to present a case to which the promise of action on the other side would apply. Hence, although A and B have each performed their own promise, they have not performed the condition to their right of demanding more from the other side. The performance of that condition is purely optional until one side has brought it within the scope of the other's undertaking by performing it himself. But it is performance in the latter sense, that is, the satisfying of all conditions, as well as the keeping of his own promises, which is necessary to give A or B a right of action. Conditions may be created by the very words of a contract. Of such cases, there is nothing to be said, for parties may agree to what they choose. But they may also be held to arise by construction, where no provision is made in terms for rescinding or avoiding the contract in any case. The nature of the conditions, which the law thus reads in, needs explanation. It may be said, in a general way, that they are directed to the existence of the manifest grounds for making the bargain on the side of the rescinding party, or the accomplishment of its manifest objects. But that is not enough. Generally speaking, the disappointment must be caused by the wrongdoing of the person on the other side, and the most obvious cases of such wrongdoing are fraud and misrepresentation, or failure to perform his own part of the contract. Fraud and misrepresentation thus need to be considered once more in this connection. I take the latter first. In dealing with it, the first question which arises is whether the representation is, or is not, part of the contract. If the contract is in writing and the representation is set out on the face of the paper, it may be material or immaterial, but the effect of its untruth will be determined on much the same principles as govern the failure to perform a promise on the same side. If the contract is made by word of mouth, there may be a large latitude in connecting words of representation with later words of promise. But when they are determined to be a part of the contract, the same principles apply as if the whole were in writing. The question now before us is the effect of a misrepresentation which leads to, but is not a part of, the contract. Suppose that the contract is in writing, but does not contain it. Does such a previous misrepresentation authorize rescission in any case? And if so, does it in any case except where it goes to the height of fraud? The promiser might say, "It does not matter to me whether you knew that your representation was false or not. The only thing I am concerned with is its truth. If it is untrue, I suffer equally whether you knew it to be so or not." But it has been shown, in an earlier lecture, that the law does not go on the principle that a man is answerable for all the consequences of all his acts. An act is indifferent in itself. It receives its character from the concomitant facts known to the actor at the time. If a man states a thing reasonably believing that he is speaking from knowledge, it is contrary to the analogies of the law to throw the peril of the truth upon him unless he agrees to assume that peril, and he did not do so in the case supposed, as the representation was not made part of the contract. It is very different when there is fraud. Fraud may as well lead to the making of a contract by a statement outside the contract as by one contained in it, but the law would hold the contract not less conditional on good faith in one case than in the other. To illustrate, we may take a somewhat extreme case. A says to B, I have not opened these barrels myself, but they contain number 1 mackerel. I paid so much for them to so-and-so, naming a well-known dealer. Afterwards a writes B, I will sell the barrels which you saw and their contents for so much, and B accepts. The barrels turn out to contain salt. I suppose the contract would be binding if the statements touching the contents were honest, and voidable if they were fraudulent. Fraudulent representations outside a contract can never, it would seem, go to anything except the motives for making it. If outside the contract, they cannot often affect its interpretation. A promise in certain words has a definite meaning, which the promiser is presumed to understand. If a says to B, I promise you to buy this barrel and its contents, his words designate a person and thing identified by the senses, and they signify nothing more. There is no repugnancy, and if that person is ready to deliver that thing, the purchaser cannot say that any term in the contract itself is not complied with. He may have been fraudulently induced to believe that B was another B, and that the barrel contained mackerel. But however much his belief on those points may have affected his willingness to make the promise, it would be somewhat extravagant to give his words a different meaning on that account. You means the person before the speaker, whatever his name, and contents applies to salt, as well as to mackerel. It is no doubt only by reason of a condition construed into the contract that fraud is a ground of rescission. Parties could agree, if they chose, that a contract should be binding without regard to truth or falsehood outside of it on either part. But as has been said before in these lectures, although the law starts from the distinctions and uses the language of morality, it necessarily ends in external standards not dependent on the actual consciousness of the individual. So it has happened with fraud. If a man makes a representation, knowing facts which by the average standard of the community are sufficient to give him warning that it is probably untrue, and it is untrue, he is guilty of fraud in theory of law whether he believes his statement or not. The courts of Massachusetts, at least, go much further. They seem to hold that any material statement made by a man as of his own knowledge, or in such a way as fairly to be understood as made of his own knowledge, is fraudulent if untrue, irrespective of the reasons he may have had for believing it and for believing that he knew it. When it is clear, therefore, that a representation may be morally innocent, and yet fraudulent in theory of law. Indeed, the Massachusetts rule seems to stop little short of the principle laid down by the English courts of equity, which has been criticized in an earlier lecture. Since most positive affirmations of facts would at least warrant a jury in finding that they were reasonably understood to be made as of the party's own knowledge, and might therefore warrant a rescission if they turned out to be untrue. The moral phraseology has ceased to be apposite, and an external standard of responsibility has been reached. But the starting point is nevertheless fraud, and except on the ground of fraud, as defined by law, I do not think that misrepresentations before the contract affect its validity, although they lead directly to its making. But neither the contract nor the implied condition calls for the existence of the facts as to which the false representations were made. They call only for the absence of certain false representations. The condition is not that the promisee shall be a certain other B, or that the contents of the barrel shall be mackerel, but that the promisee has not lied to him about material facts. Then the question arises, how do you determine what facts are material? As the facts are not required by the contract, the only way in which they can be material is that a belief in their being true is likely to have led to the making of the contract. It is not then true, as it is sometimes said, that the law does not concern itself with the motives for making contracts. On the contrary, the whole scope of fraud outside the contract is the creation of false motives and the removal of true ones. And this consideration will afford a reasonable test of the cases in which fraud will warrant rescission. It is said that a fraudulent representation must be material to have that effect. But how are we to decide whether it is material or not? If the above argument is correct, it must be by an appeal to ordinary experience to decide whether a belief that the fact was as represented would naturally have led to, or a contrary belief would naturally have prevented, the making of the contract. If the belief would not naturally have had such an effect, either in general or under the known circumstances of the particular case, the fraud is immaterial. If a man is induced to contract with another by a fraudulent representation of the latter that he is a great-grandson of Thomas Jefferson, I do not suppose that the contract would be voidable unless the contractee knew that, for special reasons, his lie would tend to bring the contract about. The conditions or grounds for avoiding a contract which have been dealt with thus far are conditions concerning the conduct of the parties outside of the itself. Still confining myself to conditions arising by construction of law, that is to say, not directly, and in terms attached to a promise by the literal meaning of the words, in which it is expressed, I now come to those which concern facts to which the contract does in some way refer. Such conditions may be found in contracts where the promise is only on one side. It has been said that where the contract is unilateral, and its language therefore is all that of the promiser, clauses in his favor will be construed as conditions more readily than the same words in a bilateral contract. Indeed, that they must be so construed, because, if they do not create a condition, they do him no good, since ex hypothesi they are not promises by the other party. How far this ingenious suggestion has had a practical effect on doctrine may perhaps be doubted. But it will be enough for the purposes of this general survey to deal with bilateral contracts, where there are undertakings on both sides, and where the condition implied in favor of one party is that the other shall make good what he on his part has undertaken. The undertakings of a contract may be for the existence of a fact in the present or in the future. They can be promises only in the latter case, but in the former, they be equally essential terms in the bargain. Here again we come on the law of representations, but in a new phase. Being a part of the contract, it is always possible that their truth should make a condition of the contract wholly irrespective of any question of fraud. And it often is so in fact. It is not, however, every representation embodied in the words used on one side which will make a condition in favor of the other party. Suppose A agrees to sell and B agrees to buy A's 7-year-old sorrel horse Eclipse, now in the possession of B on trial, and in fact the horse is chestnut-colored, not sorrel. I do not suppose that B could refuse to pay for the horse on that ground. If the law were so foolish as to aim at merely formal consistency, it might indeed be said that there was as absolute a repugnancy between the different terms of this contract as in the ease of an agreement to sell certain barrels of mackerel, where the barrels turned out to contain salt. If this view were adopted, there would not be a contract subject to a condition, there would be no contract at all. But in truth there is a contract, and there is not even a condition. As has been said already, it is not every repugnancy that makes a contract void, and it is not every failure in the terms of the counter-undertaking that makes it voidable. Here it plainly appears that the buyer knows exactly what he is going to get, and therefore that the mistake of color has no bearing on the bargain. If, on the other hand, a contract contained a representation which was fraudulent, and which misled the party to whom it was made, the contract would be voidable on the same principles as if the representation had been made beforehand. But words of description in a contract are very frequently held to amount to what is sometimes called a warranty, irrespective of fraud. Whether they do so or not is a question to be determined by the court on grounds of common sense, looking to the meaning of the words, the importance in the transaction of the facts which the words convey, and so forth. But when words of description are determined to be a warranty, the meaning of the decision is not merely that the party using them binds himself to answer for their truth, but that their truth is a condition of the contract. For instance, in a leading case the agreement was that the plaintiff's ship, then in the port of Amsterdam, should, with all possible dispatch, proceed direct to Newport, England, and there load a cargo of coals for Hong Kong. At the date of the charter party, the vessel was not in Amsterdam, but she arrived there 4 days later. The plaintiff had noticed that the defendant considered time important. It was held that the presence of the vessel in the port of Amsterdam at the date of the contract was a condition, the breach of which entitled the defendant to refuse to load, and to rescind the contract. If the view were adopted that a condition must be a future event, and that a promise purporting to be conditional on a past or present event is either absolute or no promise at all, it would follow that in this case the defendant had never made a promise. He had only promised if circumstances existed which did not exist. I have already stated my objections to this way of looking at such cases, too, and will only add that the courts, so far as I am aware, do not sanction it, and certainly did not in this instance. There is another ground for holding the charter party void and no contract, instead of regarding it as only voidable, which is equally against authority, which nevertheless I have never been able to answer wholly to my satisfaction. In the case put, the representation of the lessor of the vessel concerned the vessel itself, and therefore entered into the description of the thing the lessee agreed to take. I do not quite see why there is not as fatal a repugnancy between the different terms of this contract as was found in that for the sale of the barrels of salt described as containing mackerel. Why is the repugnancy between the two terms first, that the thing sold is the contents of these barrels, and, second, that it is mackerel fatal to the existence of a contract? It is because each of those terms goes to the very root and essence of the contract. One because to compel the buyer to take something answering to one, but not to the other requirement, would be holding him to do a substantially different thing from what he promised, and because a promise to take one and the same thing answering to both requirements is therefore contradictory in a substantial matter. It has been seen that the law does not go on any merely logical ground, and does not hold that every slight repugnancy will make a contract even voidable. But, on the other hand, when the repugnancy is between terms which are both essential, it is fatal to the very existence of the contract. How then do we decide whether a given term is essential? Surely the best way of finding out is by seeing how the parties have dealt with it. For want of any expression on their part, we may refer to the speech and dealings of every day, /to/ and say that, if its absence would make the subject matter a different thing, its presence is essential to the existence of the agreement. But the parties may agree that anything, however trifling, shall be essential, as well as that anything, however important, shall not be. And if that essential is part of the contract description of a specific thing, which is also identified by reference to the senses, how can there be a contract in its absence any more than if the thing is in popular speech different in kind from its description? The qualities that make sameness or difference of kind for the purposes of a contract are not determined by Agassiz or Darwin, or by the public at large, but by the will of the parties, which decides that for their purposes the characteristics insisted on are such and such. One now, if this be true, what evidence can there be that a certain requirement is essential, that without it the subject matter will be different in kind from the description, better than that one party has required and the other given a warranty of its presence? Yet the contract description of the specific vessel as now in the port of Amsterdam, although held to be an implied warranty, does not seem to have been regarded as making the contract repugnant and void, but only as giving the defendant the option of avoiding it. Even an express warranty of quality in sales does not have this effect, and in England, indeed, it does not allow the purchaser to rescind in case of breach. On this last point, the law of Massachusetts is different. The explanation has been offered of the English doctrine with regard to sales that, when the title has passed, the purchaser has already had some benefit from the contract, and therefore cannot wholly replace the seller in statu quo, as must be done when a contract is rescinded. This reasoning seems doubtful, even to show that the contract is not voidable, but has no bearing on the argument that it is void. For if the contract is void, the title does not pass. It might be said that there is no repugnancy in the charterer's promise, because he only promises to load a certain ship, and that the words, now in the port of Amsterdam, are merely matter of history when the time for loading comes, and no part of the description of the vessel which he promised to load. But the moment those words are decided to be essential, they become part of the description, and the promise is to load a certain vessel which is named the Martaban, and which was in the port of Amsterdam at the date of the contract. So interpreted, it is repugnant. Probably the true solution is to be found in practical considerations. At any rate, The fact is that the law has established 3 degrees in the effect of repugnancy. If one of the repugnant terms is wholly insignificant, it is simply disregarded, or at most will only found a claim for damages. The law would be loath to hold a contract void for repugnancy in present terms, when if the same terms were only promised, a failure of one of them would not warrant a refusal to perform on the other side. If, on the other hand, both are of the extremest importance, so that to enforce the rest of the promise or bargain without one of them would not merely deprive one party of a stipulated incident, but would force a substantially different bargain on him, the promise will be void. There is an intermediate class of cases where it is left to the disappointed party to decide. But as the lines between the 3 are of this vague kind, it is not surprising that they have been differently drawn in different jurisdictions. The examples which have been given of undertakings for a present state of facts have been confined to those touching the present condition of the subject matter of the contract. Of course, there is no such limit to the scope of their employment. A contract may warrant the existence of other facts as well, and examples of this kind probably might be found or imagined where it would be clear that the only effect of the warranty was to attach a condition to the contract in favor of the other side, and where the question would be avoided whether there was not something more than a conditionae repugnancy which prevented the formation of any contract at all. But the preceding illustrations are enough for the present purpose. We may now pass from undertakings that certain facts are true at the time of making the contract to undertakings that certain facts shall be true at some later time, that is, to promises properly so called. The question is when performance of the promise on one side is a condition to the obligation of the contract on the other. In practice, this question is apt to be treated as identical with another, which, as has been shown earlier, is a distinct point. Namely, when performance on one side is a condition of the right to call for performance on the other. It is of course conceivable that a promise should be limited to the case of performance of the things promised on the other side, and yet that a failure of the latter should not warrant a rescission of the contract. Wherever one party has already received a substantial benefit under a contract of a kind which cannot be restored, it is too late to rescind, however important a breach may be committed later by the other side. Yet he may be excused from going farther. Suppose a contract is made for a month's labor, $10 to be paid down, not to be recovered except in case of rescission for the laborer's fault, and $30 at the end of the month. If the laborer should wrongfully stop work at the end of a fortnight, I do not suppose that the contract could be rescinded, and that the $10 could be recovered as money had and received. But, on the other hand, the employer would not be bound to pay the $30, and of course he could sue for damages on the contract. But for the most part, a breach of promise which discharges the promisee from further performance on his side will also warrant rescission, so that no great harm is done by the popular confusion of the 2 questions. Where the promise to perform on one side is limited to the case of performance on the other, the contract is generally conditioned on it also. In what follows, I shall take up the cases which I wish to notice, without stopping to consider whether the contract was in a strict sense conditioned on performance of the promise on one side, or whether the true construction was merely that the promise on the other side was limited to that event. Now, how do we settle whether such a condition exists? It is easy to err by seeking too eagerly for simplicity, and by striving too hard to reduce all cases to artificial presumptions, which are less obvious than the decisions which they are supposed to explain. The foundation of the whole matter is, after all, good sense, as the courts have often said. The law means to carry out the intention of the parties, and, so far as they have not provided for the event which has happened, it has to say what they naturally would have intended if their minds had been turned to the point. It will be found that decisions based on the direct implications of the language used, and others based upon a remoter inference of what the parties must have meant, or would have said if they had spoken, shade into each other by imperceptible degrees. Mr. Langdell has called attention to a very important principle, and one which, no doubt, throws light on many decisions. This is that, where you have a bilateral contract, while the consideration of each promise is the counter-promise, yet prima facie the payment for performance of one is performance of the other. The performance of the other party is what each means to have in return for his own. If A promises a barrel of flour to B, and B promises him $10 for it, A means to have the $10 for his flour, and B means to have the flour for his $10. If no time is set for either act, neither can call on the other to perform without being ready at the same time himself. But this principle of equivalency is not the only principle to be drawn even from the form of contracts, without considering their subject matter, and of course it is not offered as such in Mr. Langdell's work. Another very clear one is found in contracts for the sale or lease of a thing, and the like. Here the qualities or characteristics which the owner promises that the thing furnished shall possess go to describe the thing which the buyer promises to accept. If any of the promised traits are wanting in the thing tendered, the buyer may refuse to accept, not merely on the ground that he has not been offered the equivalent for keeping his promise, but also on the ground that he never promised to accept what is offered him. When it has been seen that, where the contract contains a statement touching the condition of the thing at an earlier time than the moment for its acceptance, the past condition may not always be held to enter into the description of the thing to be accepted, but no such escape is possible here. Nevertheless, there are limits to the right of refusal even in the present class of cases. If the thing promised is specific, the preponderance of that part of the description which identifies the object by reference to the senses is sometimes strikingly illustrated. One case has gone so far as to hold that performance of an executory contract to purchase a specific thing cannot be refused because it fails to come up to the warranted quality. Another principle of dependency, to be drawn from the form of the contract itself, is that performance of the promise on one side may be manifestly intended to furnish the means for performing the promise on the other. If a tenant should promise to make repairs, and the landlord should promise to furnish him wood for the purpose, it is believed that at the present day, whatever may have been the old decisions, the tenant's duty to repair would be dependent upon the landlord's furnishing the material when required. Another case of a somewhat exceptional kind is where a party to a bilateral contract agrees to do certain things and to give security for his performance. Here it is manifest good sense to hold giving the security a condition of performance on the other side, if it be possible. For the requirement of security shows that the party requiring it was not content to rely on the simple promise of the other side, which he would be compelled to do if he had to perform before the security was given, and thus the very object of requiring it would be defeated. This last case suggests what is very forcibly impressed on anyone who studies the cases that, after all, the most important element of decision is not any technical, or even any general principle of contracts, but a consideration of the nature of the particular transaction as a practical matter. A promises B to do a day's work for $2, and B promises A to pay $2 for a day's work. There the two promises cannot be performed at the same time. The work will take all day, the payment half a minute. How are you to decide which is to be done first? That is to say, which promise is dependent upon performance on the other side? It is only by reference to the habits of the community and to convenience. It is not enough to say that on the principle of equivalency, a man is not presumed to intend to pay for a thing until he has it. The work is payment for the money, as much as the money for the work, and one must be paid in advance. The question is, why, if one man is not presumed to intend to pay money until he has money's worth, the other is presumed to intend to give money's worth before he has money? An answer cannot be obtained from any general theory. The fact that employers, as a class, can be trusted for wages more safely than the employed for their labor, that the employers have had the power and have been the lawmakers, or other considerations, it matters not what, have determined that the work is to be done first. But the grounds of decision are purely practical and can never be elicited from grammar or from logic. A reference to practical considerations will be found to run all through the subject. Take another instance. The plaintiff declared on a mutual agreement between himself and the defendant that he would sell, and the defendant would buy, certain Donskoy wool to be shipped by the plaintiff at Odessa and delivered in England. Among the stipulations of the contract was one, that the names of the vessels should be declared as soon as the wools were shipped. The defense was that the wool was bought, with the knowledge of both parties, for the purpose of reselling it in the course of the defendant's business, that it was an article of fluctuating value, and not saleable until the names of the vessels in which it was shipped should have been declared according to the contract, but that the plaintiff did not declare the names of the vessels as agreed. The decision of the court was given by one of the greatest technical lawyers that ever lived, Baron Park. Yet, he did not dream of giving any technical or merely logical reason for the decision. But after stating in the above words the facts which were deemed material to the question, whether declaring the names of the vessels was a condition to the duty to accept, stated the ground of decision thus. Looking at the nature of the contract, and the great importance of it to the object with which the contract was entered into with the knowledge of both parties, we think it was a condition precedent. Lecture X Successions After Death. In the lecture on possession, I tried to show that the notion of possessing a right as such was intrinsically absurd. All rights are consequences attached to filling some situation of fact. A right which may be acquired by possession differs from others simply in being attached to a situation of such a nature that it may be filled successively by different persons, or by anyone without regard to the lawfulness of his doing so, as is the case where the situation consists in having a tangible object within one's power. When a right of this sort is recognized by the law, there is no difficulty in transferring it, or, more accurately, there is no difficulty in different persons successively enjoying similar rights in respect of the subject matter. If A, being the possessor of a horse or a field, gives up the possession to B, the rights which B acquires stand on the same ground as A's did before. The facts from which A's rights sprang have ceased to be true of A, and are now true of B. The consequences attached by the law to those facts now exist for B, as they did for A before. The situation of fact from which the rights spring is continuing one, and anyone who occupies it, no matter how, has the rights attached to it. But there is no possession possible of a contract. The fact that a consideration was given yesterday by A to B, and a promise received in return, cannot be laid hold of by X and transferred from A to himself. The only thing can be transferred is the benefit or burden of the promise, and how can they be separated from the facts which gave rise to them? How, in short, can a man sue or be sued on a promise in which he had no part? Hitherto it has been assumed, in dealing with any special right or obligation, that the facts from which it sprung were true of the individual entitled or bound. But it often happens, especially in modern law, that a person acquires and is allowed to enforce a special right, although that facts which give rise to it are not true of him, or are true of him only in part. One of the chief problems of the law is to explain the machinery by which this result has been brought to pass. It will be observed that the problem is not coextensive with the whole field of rights. Some rights cannot be transferred by any device or contrivance. For instance, a man's right to bodily safety or reputation. Others, again, are incident to possession, and within the limits of that conception, no other is necessary. As Savigny said, succession does not apply to possession by itself. But the notion of possession will carry us but a very little way in our understanding of the modern theory of transfer. That theory depends very largely upon the notion of succession, to use the word just quoted from Savigny, and accordingly successions will be the subject of this and the following lecture. I shall begin by explaining the theory of succession to persons deceased, and after that is done, shall pass to the theory of transfer between living people, and shall consider whether any relation can be established between the two. The former is easily shown to be founded upon a fictitious identification between the deceased and his successor. And as a first step to the further discussion, as well as for its own sake, I shall briefly state the evidence touching the executor, the heir, and the devisee. In order to understand the theory of our law with regard to the first of these, at least, scholars are agreed that it is necessary to consider the structure and position of the Roman family as it was in the infancy of Roman society. Continental jurists have long been collecting the evidence that, in the earlier periods of Roman and German law alike, the unit of society was the family. The 12 Tables of Rome still recognize the interest of the inferior members of the family in the family property. Heirs are called suis heredibus, that is, heirs of themselves or of their own property, as is explained by Gaius. /1/Paulus says that they are regarded as owners in a certain sense, even in the lifetime of their father, and that after his death they do not so much receive an inheritance as obtain the full power of dealing with their property. Starting from this point, it is easy to understand the succession of heirs to a deceased paterfamilias in the Roman system. If the family was the owner of the property administered by a paterfamilias, its rights remained unaffected by the death of its temporary head. The family continued, although the head died. And when, probably by a gradual change, the paterfamilias came to be regarded as owner, instead of a simple manager of the family rights, the nature and continuity of those rights did not change with the title to them. The familia continued to the heirs as it was left by the ancestor. The heir succeeded not to the ownership of this or that thing separately, but to the total heredibus or headship of the family, with certain rights of property as incident to, and of course he took this headship, or right of representing the family interests, subject to the modifications effected by the last manager. The aggregate of the ancestor's rights and duties, or, to use the technical phrase, the total persona sustained by him, was easily separated from his natural personality. For this persona was but the aggregate of what had formerly been family rights and duties, and was originally sustained by any individual only as the family head. Hence it was said to be continued by the inheritance, /3/, and when the heir assumed it, he had his action in respect of injuries previously committed. 4. Thus the Roman heir came to be treated as identified with his ancestor for the purposes of the law. And thus it is clear how the impossible transfers which I seek to explain were accomplished in that instance. Rights to which B as B could show no title, he could readily maintain under the fiction that he was the same person as a whose title was not denied. It is not necessary at this point to study family rights in the German tribes, for it is not disputed that the modern executor derives his characteristics from the Roman heir. Wills also were borrowed from Rome and were unknown to the Germans of Tacitus. Administrators were a later imitation of executors, introduced by statute for cases where there was no will, or where, for any other reason, executors were wanting. The executor has the legal title to the whole of the testator's personal estate, and, generally speaking, the power of alienation. Formerly, he was entitled to the undistributed residue, not, it may fairly be conjectured, as legatee of those specific chattels, but because he represented the person of the testator, and therefore had all the rights which the testator would have had after distribution if alive. The residue is nowadays generally bequeathed by the will, but it is not even now regarded as a specific gift of the chattels remaining undisposed of, and I cannot help thinking that this doctrine echoes that under which the executor took in former times. No such rule has governed residuary devises of real estate, which have always been held to be specific in England down to the present day. So that, if a devise of land should fail, that land would not be disposed of by the residuary clause, but would descend to the heir as if there had been no will. Again, the appointment of an executor relates back to the date of the testator's death. The continuity of person is preserved by this fiction, as in Rome it was by personifying the inheritance ad interim. Enough has been said to show the likeness between our executor and the Roman heir. And bearing in mind what was said about the heirs, it will easily be seen how it came to be said, as it often was in the old books, that the executor represents the person of his testator. 1. The meaning of this feigned identity has been found in history, but the aid which it furnished in overcoming a technical difficulty must also be appreciated. If the executor represents the person of the testator, there is no longer any trouble in allowing him to sue or be sued on his testator's contracts. In the time of Edward Roman III, when an action of covenant was brought against executors, per se objected. I never heard that one should have a writ of covenant against executors, nor against other person but the very one who made the covenant, for a man cannot oblige another person to a covenant by his deed, except him who was party to the covenant. But it is useless to object that the promise sued upon was made by a, the testator, not by b, the executor. When the law says that for this purpose b is a, here then is one class of cases in which a transfer is accomplished by the help of a fiction, which shadows, as fictions so often do, the facts of an early stage of society, and which could hardly have been invented had these facts been otherwise. Executors and administrators afford the chief, if not the only, example of universal succession in the English law. But although they succeed per universitatem, as has been explained, they do not succeed to all kinds of property. The personal estate goes to them, but land takes another course. All real estate not disposed of by will goes to the heir, and the rules of inheritance are quite distinct from those which govern the distribution of chattels. Accordingly, the question arises whether the English heir, or successor, to real estate presents the same analogies to the Roman heirs as the executor. The English heir is not a universal successor. Each and every parcel of land descends as a separate and specific thing. Nevertheless, in his narrower sphere, he unquestionably represents the person of his ancestor. Different opinions have been held as to whether the same thing was true in early German law. Dr. Laband says that it was. One Sohm takes the opposite view. It is commonly supposed that family ownership, at least of land, came before that of individuals in the German tribes, and it has been shown how naturally representation followed from a similar state of things in Rome. But it is needless to consider whether our law on this subject is of German or Roman origin, as the principle of identification has clearly prevailed from the time of Glanville to the present day. If it was not known to the Germans, it is plainly accounted for by the influence of the Roman law. If there was anything of the sort in the Salic law, it was no doubt due to natural causes similar to those which gave rise to the principle at Rome. But in either event, I cannot doubt that the modern doctrine has taken a good deal of its form, and perhaps some of its substance, from the mature system of the civilians, in whose language it was so long expressed. For the same reasons that have just been mentioned, it is also needless to weigh the evidence of the Anglo-Saxon sources, although it seems tolerably clear from several passages in the laws that there was some identification. As late as Bracton, 2 centuries after the Norman conquest, the heir was not the successor to lands alone, but represented his ancestor in a much more general sense, as will be seen directly. The office of executor, in the sense of heir, was unknown to the Anglo-Saxons. And even in Bracton's time does not seem to have been what it has since become. There is, therefore, no need to go back further than to the early Norman period, after the appointment of executors had become common, and the heir was more nearly what he is now. When Glanville wrote, a little more than a century after the conquest, the heir was bound to warrant the reasonable gifts of his ancestor to the grantees and their heirs. And if the effects of the ancestor were insufficient to pay his debts, the heir was bound to make up the deficiency from his own property. Neither Glanville nor his Scotch imitator, the Regium Majestatem, 5 limits the liability to the amount of property inherited from the same source. This makes the identification of heir and ancestor as complete as that of the Roman law before such a limitation was introduced by Justinian. On the other hand, a century later, it distinctly appears from Bracton, that the heir was only bound so far as property had descended to him, and in the early sources of the continent, Norman as well as other, the same limitation appears. The liabilities of the heir were probably shrinking. Britton and Fleta, the imitators of Bracton, and perhaps Bracton himself, say that an heir is not bound to pay his ancestor's debt, unless he be thereto especially bound by the deed of his ancestor. The later law required that the heir should be mentioned if he was to be held. But at all events, the identification of heir and ancestor still approached the nature of a universal succession in the time of Bracton, as is shown by another statement of his. He asks if the testator can bequeath his rights of action, and answers, no, so far as concerns debts not proved and recovered in the testator's life. But actions of that sort belong to the heirs, and must be sued in the secular court. For before they are so recovered in the proper court, the executor cannot proceed for them in the ecclesiastical tribunal. This shows that the identification worked both ways. The heir was liable for the debts due from his ancestor, and he could recover those which were due to him until the executor took his place in the king's courts, as well as in those of the church. Within the limits just explained, the heir was also bound to warrant property sold by his ancestor to the purchaser and his heirs. It is not necessary, after this evidence, that the modern heir began by representing his ancestor generally, to seek for expressions in later books, since his position has been limited. But just as we have seen that the executor is still said to represent the person of his testator, the heir was said to represent the person of his ancestor in the time of Edward I/2/so. At a much later date, it was said that the heir is in representation in point of taking by inheritance idem persona cum antecessor. 3. The same persona as his ancestor. A great judge, who died but a few years ago, repeats language which would have been equally familiar to the lawyers of Edward or of James. Baron Park, after laying down that in general a party is not required to make proffered of an instrument to the possession of which he is not entitled, says that there is an exception, in the cases of heir and executor, who may plead a release to the ancestor or testator whom they respectively represent, so also with respect to several tortfeasors, for in all these cases there is a privity between the parties which constitutes an identity of person. 4. But this is not all. The identity of person was carried farther still. If a man died leaving male children and owning land and fee, it went to the oldest son alone, but if he left only daughters, it descended to them all equally. In this case, several individuals together continued the persona of their ancestor, but it was always laid down that they were but one heir. One, for the purpose of working out this result, not only was one person identified with another, but several persons were reduced to one, that they might sustain a single persona. What was the persona? It was not the sum of all the rights and duties of the ancestor. It has been seen that for many centuries his general status, the sum of all his rights and duties except those connected with real property, has been taken up by the executor or administrator. The persona continued by the heir was from an early day confined to real estate in its technical sense, that is, to property subject to feudal principles, as distinguished from chattels, which, as Blackstone tells us, /2/ include whatever was not a feud. But the heir's persona was not even the sum of all the ancestors' rights and duties in connection with real estate. It has been said already that every fee descends specifically, and not as incident to a larger universitas. This appears not so much from the fact that the rules of descent governing different parcels might be different, so that the same person would not be heir to both, as from the very nature of feudal property. Under the feudal system in its vigor, the holding of land was only one incident of a complex personal relation. The land was forfeited for a failure to render the services for which it was granted. The service could be renounced for a breach of correlative duties on the part of the lord. It rather seems that, in the beginning of the feudal period under Charlemagne, a man could only hold land of one lord. 2. Even when it had become common to hold of more than one, the strict personal relation was only modified so far as to save the tenant from having to perform inconsistent services. Glanville and Bracton tell us that a tenant holding of several lords was to do homage for each fee, but to reserve his allegiance for the lord of whom he held his chief estate. But that, if the different lords should make war upon each other, and the chief lord should command the tenant to obey him in person, the tenant ought to obey, saving the service due to the other lord for the fee held of him. We see, then, that the tenant had a distinct persona or status in respect of each of the fees which he held. The rights and duties incident to one of them had no relation to the rights and duties incident to another. A succession to one had no connection with the succession to another. Each succession was the assumption of a distinct personal relation, in which the successor was to be determined by the terms of the relation in question. The persona which we are seeking to define is the estate. Every fee is a distinct persona, a distinct heredibus, or inheritance, as it has been called since the time of Bracton. We have already seen that it may be sustained by more than one where there are several heirs, as well as by one, just as a corporation may have more or less members. But not only may it be divided lengthwise, so to speak, among persons interested in the same way at the same time, it may also be cut across into successive interests, to be enjoyed one after another. In technical language, it may be divided into a particular estate and remainders, but they are all parts of the same fee, and the same fiction still governs them. We read in an old case that he and reversion and particular tenant are but one tenant. This is only a statement of counsel, to be sure, but it is made to account for a doctrine which seems to need the explanation, to the effect that, after the death of the tenant for life, he in reversion might have error or attaint on an erroneous judgment or false verdict given against the tenant for life. To sum up the results so far, The heir of modern English law gets his characteristic features from the law as it stood soon after the conquest. At that time, he was a universal successor in a very broad sense. Many of his functions as such were soon transferred to the executor. The heir's rights became confined to real estate and his liabilities to those connected with real estate and to obligations of his ancestor expressly binding him. The succession to each fee or feudal inheritance is distinct, not part of the sum of all the ancestors' rights regarded as one whole. But to this day, the executor in his sphere and the heir in his represent the person of the deceased and are treated as if they were one with him for the purpose of settling their rights and obligations. The bearing which this has upon the contracts of the deceased has been pointed out, but its influence is not confined to contract, it runs through everything. The most striking instance, however, is the acquisition of prescriptive rights. Take the case of a right-of-way. A right-of-way over a neighbor's land can only be acquired by grant or by using it adversely for 20 years. A man uses a way for 10 years and dies. Then his heir uses it 10 years. Has any right been acquired? If common sense alone is consulted, the answer must be no. The ancestor did not get any right because he did not use the way long enough, and just as little did the heir. How can it better the heir's title that another man had trespassed before him? Clearly, if 4 strangers to each other used the way for 5 years each, no right would be acquired by the last. But here comes in the fiction which has been so carefully explained. From the point of view of the law, it is not 2 persons who have used the way for 10 years each, but one who has used it for 20. The heir has the advantage of sustaining his ancestors, and the right is acquired. Lecture X Successions inter vivos. I now reach the most difficult and obscure part of the subject. It remains to be discovered whether the fiction of identity was extended to others besides the heir and executor. And if we find, as we do, that it went but little farther in express terms, the question will still arise whether the mode of thought and the conceptions made possible by the doctrine of inheritance have not silently modified the law as to dealings between the living. It seems to me demonstrable that their influence has been profound, and that, without understanding the theory of inheritance, it is impossible to understand the theory of transfer inter vivos. The difficulty in dealing with the subject is to convince the skeptic that there is anything to explain. Nowadays, the notion that a right is valuable is almost identical with the notion that it may be turned into money by selling it. But it was not always so. Before you can sell a right, you must be able to make a sale thinkable in legal terms. I put the case of the transfer of a contract at the beginning of the lecture. I have just mentioned the case of gaining a right by prescription, when neither party has complied with the requirement of 20 years adverse use. In the latter instance, there is not even a right at the time of the transfer, but a mere fact of 10 years past trespassing. A way, until it becomes a right-of-way, is just as little susceptible of being held by a possessory title as a contract. If then a contract can be sold, if a buyer can add the time of his seller's adverse user to his own, what is the machinery by which the law works out the result? The most superficial acquaintance with any system of law in its earlier stages will show with what difficulty and by what slow degrees such machinery has been provided, and how the want of it has restricted the sphere of alienation. It is a great mistake to assume that it is a mere matter of common sense that the buyer steps into the shoes of the seller, according to our significant metaphor. Suppose that sales and other civil transfers had kept the form of warlike capture, which it seems that they had in the infancy of Roman law, one in which was at least partially retained in one instance, the acquisition of wives, after the transaction had, in fact, taken the more civilized shape of purchase. The notion that the buyer came in adversely to the seller would probably have accompanied the fiction of adverse taking, and he would have stood on his own position as founding a new title. Without the aid of conceptions derived from some other source, it would have been hard to work out a legal transfer of objects which did not admit of possession. A possible source of such other conceptions was to be found in family law. The principles of inheritance furnished a fiction, and a mode of thought which at least might have been extended into other spheres. In order to prove that they were in fact so extended, it will be necessary to examine once more the law of Rome, as well as the remains of German and Anglo-Saxon customs. I will take up first the German and Anglo-Saxon laws, which are the ancestors of our own on one side of the house. For although what we get from those sources is not in the direct line of the argument, it lays a foundation for it by showing the course of development in different fields. The obvious analogy between purchaser and heir seems to have been used in the FOAK laws, but mainly for another purpose than those which will have to be considered in the English law. This was to enlarge the sphere of alienability. It will be remembered that there are many traces of family ownership in early German, as well as in early Roman law, and it would seem that the transfer of property, which originally could not be given outside the family, was worked out through the form of making the grantee an heir. The history of language points to this conclusion. Heirs, as Besseler I and others have remarked, from meaning a successor to the property of a person deceased, was extended to the doni mortis causa, and even more broadly to grantees in general. Hereditaire was used in like manner for the transfer of land. Heaven is quoted by Laferriere as calling attention to the fact that the ancient usage was to say hereditor for purchase, heredier for purchaser, and deseritor for sell. The texts of the Salic law give us incontrovertible evidence. A man might transfer the whole or any part of his property by delivering possession of it to a trustee who, within 12 months, handed it over to the beneficiaries. For to those, the text reads, whom the donor has named hereds, quos hereds appellevit. Here then was a voluntary transfer of more or less property at pleasure to persons freely chosen, who were not necessarily universal successors, if they ever were, and who nevertheless took under the name hereds. The word, which must have meant at first persons taking by descent, was extended to persons taking by purchase. If the word became enlarged in meaning, it is probably because the thought which it conveyed was turned to new uses. The transaction seems to have fallen halfway between the institution of an heir and a sale. The later law of the Ripuarian Franks treats it more distinctly from the former point of view. It permits a man who has no sons to give all his property to whomsoever he chooses, whether relatives or strangers, as inheritance, either by way of adfathomire, as the Salic form was called, or by writing or delivery. The Lombards had a similar transfer, in which the donee was not only called heirs, but was made liable like an heir for the debts of the donor on receiving the property after the donor's death. /2/2, by the Salic law, a man who could not pay the wergeld was allowed to transfer formally his house lot, and with it the liability. But the transfer was to the next of kin. The house lot or family curtilage at first devolved strictly within the limits of the family. Here again, at least in England, freedom of alienation seems to have grown up by gradually increased latitude in the choice of successors. If we may trust the order of development to be noticed in the early charters, which it is hard to believe accidental, although the charters are few, royal grants at first permitted an election of heirs among the kindred, and then extended it beyond them. In a deed of the year 679, the language is, as it is granted, so do you hold it and your posterity. One a century later reads, which let him always possess, and after his death leave to which of his heirs he will. Another, and after him with free power of choice, leave to the man of his kin to whom he wishes to leave it. A somewhat earlier charter of 736 goes a step further, so that as long as he lives he shall have the power of holding and possessing, and of leaving it to whomsoever he choose, either in his lifetime or certainly after his death. At the beginning of the 9th century, the donee has power to leave the property to whomsoever he will, or, in still broader terms, to exchange or grant in his lifetime, and after his death to leave it to whom he chooses or to sell, exchange, and leave to whatsoever heir he chooses. This choice of heirs recalls the quos hereds appellevit of the Salic law just mentioned, and may be compared with the language of a Norman charter of about the year 1190. To W and his heirs, to wit those whom he may constitute his heirs. A perfect example of a singular succession worked out by the fiction of kinship is to be found in the story of Burnt Engjal, an Icelandic saga, which gives us a living picture of a society hardly more advanced than the Salian Franks, as we see them in the Lex Salica. A lawsuit was to be transferred by the proper plaintiff to another more versed in the laws, and better able to carry it on in fact to an attorney. But a lawsuit was at that time the alternative of a feud, and both were the peculiar affair of the family concerned. Accordingly, when a suit for killing a member of the family was to be handed over to a stranger, The innovation had to be reconciled with the theory that such suit belonged only to the next of kin. Mord is to take upon himself Thorger's suit against Flosi for killing Helgi, and the form of transfer is described as follows. Then Mord took Thorger by the hand and named 2 witnesses to bear witness, that Thorger Thofir's son hands me over a suit for manslaughter against Flosi Thord's son, to plead it for the slaying of Helgi Enjal's son, with all those proofs which have to follow the suit. Thou handest over to me this suit to plead and to settle, and to enjoy all rights in it, as though I were the rightful next of kin. Thou handest it over to me by law, and I take it from thee by law. Afterwards, these witnesses come before the court and bear witness to the transfer in like words. He handed over to him then this suit, with all the proofs and proceedings which belonged to the suit. He handed it over to him to plead and to settle, and to make use of all rights, as though he were the rightful next of kin. Thorger handed it over lawfully, and Mord took it lawfully. The suit went on, notwithstanding the change of hands, as if the next of kin were plaintiff. This is shown by a further step in the proceedings. The defendant challenges 2 of the court, on the ground of their connection with Mord, the transferee, by blood and by baptism. But Mord replies that this is no good challenge, for he challenged them not for their kinship to the true plaintiff, the next of kin, but for their kinship to him who pleaded the suit. And the other side had to admit that Mord was right in his law. I now turn from the German to the Roman sources. These have the closest connection with the argument, because much of the doctrine to be found there has been transplanted unchanged into modern law. The early Roman law only recognized as relatives those who would have been members of the same patriarchal family, and under the same patriarchal authority, had the common ancestor survived. As wives passed into the families of their husbands and lost all connection with that in which they were born, relationship through females was altogether excluded. The heir was one who traced his relationship to the deceased through males alone. With the advance of civilization, this rule was changed. The praetor gave the benefits of the inheritance to the blood relations, although they were not heirs and could not be admitted to the succession according to the ancient law. But the change was not brought about by repealing the old law, which still subsisted under the name of the jus civil. The new principle was accommodated to the old forms by a fiction. The blood relation could sue on the fiction that he was an heir, although he was not one in fact. One of the early forms of instituting an heir was a sale of the familia or headship of the family to the intended heir, with all its rights and duties. 3. This sale of the universitas was afterwards extended beyond the case of inheritance to that of bankruptcy, when it was desired to put the bankrupt's property into the hands of a trustee for distribution. This trustee also could make use of the fiction, and sue as if he had been the bankrupt's heir. 4. We are told by one of the great jurisconsults that in general universal successors stand in the place of heirs. The Roman heir, with 1 or 2 exceptions, was always a universal successor, and the fiction of heirship, as such, could hardly be used with propriety except to enlarge the sphere of universal successions. So far as it extended, however, all the consequences attached to the original fiction of identity between heir and ancestor followed as of course. To recur to the case of rights acquired by prescription, every universal successor could add the time of his predecessor's adverse use to his own in order to make out the right. There was no addition, legally speaking, but one continuous possession. The express fiction of inheritance perhaps stopped here. But when a similar joinder of times was allowed between a legatee or divisi, legatarius, and his testator, the same explanation was offered. It was said that when a specific thing was left to a person by will, so far as concerned having the benefit of the time during which the testator had been in possession for the purpose of acquiring a title, the legatee was in a certain sense quasi an heir. One yet, a legatarius, was not a universal successor, and for most purposes stood in marked contrast with such successors. Thus, the strict law of inheritance had made the notion familiar that one man might have the advantage of a position filled by another, although it was not filled, or was only partially filled, by himself. And the second fiction, by which the privileges of a legal heir in this respect, as well as others, had been extended to other persons, broke down the walls which might otherwise have confined those privileges to a single case. A new conception was introduced into the law, and there was nothing to hinder its further application. As has been shown, It was applied in terms to a sale of the universitas for business purposes, and to at least one case where the succession was confined to a single specific thing. Why, then, might not every gift or sale be regarded as a succession, so far as to ensure the same advantages? The joinder of times to make out a title was soon allowed between buyer and seller, and I have no doubt, from the language always used by the Roman lawyers, that it was arrived at in the way I have suggested. A passage from Scaevola, BC 30, will furnish sufficient proof. Joinder of possessions, he says, that is, the right to add the time of one's predecessors holding to one's own, clearly belongs to those who succeed to the place of others, whether by contract or by will. For heirs and those who are treated as holding the place of successors are allowed to add their testator's possession to their own. Accordingly, if you sell me a slave, I shall have the benefit of your holding. The joinder of times is given to those who succeed to the place of another. Ulpian cites a like phrase from a jurisconsult of the time of the Antonines, to whose place I have succeeded by inheritance, or purchase, or any other right. Tu succedier in locum alirum, like sustenere personam, is an expression of the Roman lawyers for those continuations of one man's legal position by another of which the type was the succession of heir to ancestor. Succedere alone is used in the sense of inherit, /3/ and successio in that of inheritance. For the succession par excellence was the inheritance, and it is believed that scarcely any instance will be found in the Roman sources where succession does not convey that analogy and indicate the partial assumption, at least, of a persona formerly sustained by another. It clearly does so in the passage before us. But the succession which admits a joinder of times is not hereditary succession alone. In the passage which has been cited, Scaevola says that it may be by contract or purchase, as well as by inheritance or will. It may be singular, as well as universal. The jurists often mention antithetically universal successions and those confined to a single specific thing. Ulpian says that a man succeeds to another's place, whether his succession be universal or to the single object. If further evidence were wanting for the present argument, it would be found in another expression of Ulpian's. He speaks of the benefit of joinder as derived from the persona of the grantor. He to whom a thing is granted shall have the benefit of joinder from the persona of his grantor. A benefit cannot be derived from a persona except by sustaining it. It farther appears pretty plainly from Justinian's Institutes and the Digest that the benefit was not extended to purchasers in all cases until a pretty late period. Savigny very nearly expressed the truth when he said, somewhat broadly, that every accessio, for whatever purpose, presupposes nothing else than a relation of juridical succession between the previous and present possessor. For succession does not apply to possession by itself. One and I may add, by way of further explanation, that every relation of juridical succession presupposes either an inheritance or a relation to which, so far as it extends, the analogies of the inheritance may be applied. The way of thinking which led to the accessio or joinder of times is equally visible in other cases. The time during which a former owner did not use encasement was imputed to the person who had succeeded to his place. 2. The defense that the plaintiff had sold and delivered the thing in controversy was available not only to the purchaser, but to his heirs or to a second purchaser, even before delivery to him, against the successors of the seller, whether universal or only to the thing in question. If one used away wrongfully as against the predecessor in title, it was wrongful as against the successor, whether by inheritance, purchase, or any other right. For the formal oath of a party to an action was conclusive in favor of his successors, universal or singular. 5 successors by purchase or gift had the benefit of agreements made with the vendor. 1. A multitude of general expressions show that for most purposes, whether of action or defense, the buyer stood in the shoes of the seller, to use the metaphor of our own law. 2. And what is more important than the result, which often might have been reached by other ways, the language and analogies are drawn throughout from the succession to the inheritance. Thus understood, there could not have been a succession between a person dispossessed of a thing against his will and the wrongful possessor. Without the element of consent, there is no room for the analogy just explained. Accordingly, it is laid down that there is no joinder of times when the possession is wrongful, /3/, and the only enumerated means of succeeding in rem are by will, sale, gift, or some other right. The argument now returns to the English law, fortified with some general conclusions. It has been shown that in both the systems from whose union our law arose the rules governing conveyance, or the transfer of specific objects between living persons, were deeply affected by notions drawn from inheritance. It had been shown previously that in England the principles of inheritance applied directly to the singular succession of the heir to a specific fee, as well as to the universal succession of the executor. It would be remarkable, considering their history, if the same principles had not affected other singular successions also. It will soon appear that they have. And not to be too careful about the order of proof, I will first take up the joinder of times in prescription, as that has just been so fully discussed. The English law of the subject is found on examination to be the same as the Roman in extent, reason, and expression. It is indeed largely copied from that source. For servitudes, such as rights of way, light, and the like, form the chief class of prescriptive rights, and our law of servitudes is mainly Roman. Prescriptions, it is said, are properly personal, and therefore are always alleged in the person of him who prescribes, viz., that he and all those whose estate he hath, and see, therefore a bishop or a parson may prescribe. For there is a perpetual estate, and a perpetual succession, and the successor hath the very same estate which his predecessor had, for that continues, though the person alters, like the case of the ancestor and the heir. So in a modern case, where by statute 20 years' dispossession extinguished the owner's title, the Court of Queen's Bench said that probably the right would be transferred to the possessor, if the same person or several persons, claiming one from the other by descent, will or conveyance, had been in possession for the 20 years. But such 20 years' possession must be either by the same person or several persons claiming one from the other, which is not the case here. In a word, it is equally clear that the continuous possession of privies in title, or, in Roman phrase, successors, has all the effect of the continuous possession of one, and that such an effect is not attributed to the continuous possession of different persons who are not in the same chain of title. One who dispossesses another of land cannot add the time during which his decisee has used away to the period of his own use, while one who purchased can. The authorities which have been quoted make it plain that the English law proceeds on the same theory as the Roman. One who buys land of another gets the very same estate which his seller had. He is in of the same fee, or heredibus, which means, as I have shown, that he sustains the same persona. On the other hand, one who wrongfully dispossesses another a deceasor gets a different estate, is in of a new fee, although the land is the same, and much technical reasoning is based upon this doctrine. In the matter of prescription, therefore, buyer and seller were identified, like heir and ancestor. But the question remains whether this identification bore fruit in other parts of the law also, or whether it was confined to one particular branch, where the Roman law was grafted upon the English stock. There can be no doubt which answer is most probable, but it cannot be proved without difficulty. As has been said, the heir ceased to be the general representative of his ancestor at an early date, and the extent to which even he was identified came to be a matter of discussion. Common sense kept control over fiction here as elsewhere in the common law. But there can be no doubt that in matters directly concerning the estate, the identification of heir and ancestor has continued to the present day. And as an estate in fee simple has been shown to be a distinct persona, we should expect to find a similar identification of buyer and seller in this part of the law, if anywhere. Where the land was devised by will, the analogy applied with peculiar ease. For although there is no difference in principle between a devise of a piece of land by will and a conveyance of it by deed, the dramatic resemblance of a devisee to an heir is stronger than that of a grantee. It will be remembered that one of the Roman jurists said that a legatarius, legatee, or devisee was in a certain sense quasi heirs. The English courts have occasionally used similar expressions. In a case where a testator owned a rent and divided it by will among his sons, and then one of the sons brought debt for his part, two of the judges, while admitting that the testator could not have divided the tenant's liability by a grant or deed in his lifetime, thought that it was otherwise with regard to a division by will. Their reasoning was that the devise is quasi an act of law, which shall inure without atonement, and shall make a sufficient privity, and so it may well be apportioned by this means. One so it was said by Lord Ellenborough. in a case where a lessor and his heirs were entitled to terminate a lease on notice, that a devisee of the land as heres factus would be understood to have the same right. But wills of land were only exceptionally allowed by custom until the reign of Henry Roman VIII, and as the main doctrines of conveyancing had been settled long before that time, we must look further back and to other sources for their explanation. We shall find it in the history of warranty. This, and the modern law of covenants running with the land, will be treated in the next lecture. lxxiv Successions, Roman II, inter vivos. The principal contracts known to the common law and suable in the king's courts, a century after the conquest, were suretyship and debt. The heir, as the general representative of his ancestors' rights and obligations, was liable for his debts, and was the proper person to sue for those which were due the estate. By the time of Edward Roman III, this had changed. Debts had ceased to concern the heir except secondarily. The executor took his place both for collection and payment. It is said that even when the heir was bound, he could not be sued, except in case the executor had no assets. But there was another ancient obligation which had a different history. I refer to the warranty which arose upon the transfer of property. We should call it a contract, but it probably presented itself to the mind of Glanvill's predecessors simply as a duty or obligation attached by law to a transaction which was directed to a different point. Just as the liability of a bailee, which is now treated as arising from his undertaking, was originally raised by the law out of the position in which he stood toward third persons. After the conquest, we do not hear much of warranty, except in connection with land, and this fact will at once account for its having had a different history from debt. The obligation of warranty was to defend the title, and, if the defense failed, to give to the evicted owner other land of equal value. If an ancestor had conveyed lands with warranty, this obligation could not be fulfilled by his executor, but only by his heir, to whom his other lands had descended. Conversely, as to the benefit of warranties made to a deceased grantee, his heir was the only person interested to enforce such warranties, because the land descended to him. Thus the heir continued to represent his ancestor in the latter's rights and obligations by way of warranty, after the executor had relieved him of the debts, just as before that time he had represented his ancestor in all respects. If a man was sued for property which he had bought from another, the regular course of litigation was for the defendant to summon in his seller to take charge of the defense, and for him, in turn, to summon in his, if he had one, and so on until a party was reached in the chain of title who finally took the burden of the case upon himself. A contrast which was early stated between the Lombard and the Roman law existed equally between the Anglo-Saxon and the Roman. It was said that the Lombard presents his grantor. The Roman stands in his grantor's shoes, langibardis dat auctorum, Romanus stat loco auctoris. Suppose now that A gave land to B and B conveyed over to C if C was sued by D, claiming a better title. C practically got the benefit of A's warranty, because, when he summoned B, B would summon A, and thus A would defend the case in the end. But it might happen that between the time when B conveyed to C and the time when the action was begun, B had died. If he left an heir, C might still be protected. But supposing B left no heir, C got no help from A, who in the other event would have defended his suit. This no doubt was the law in the Anglo-Saxon period, but it was manifestly unsatisfactory. We may conjecture, with a good deal of confidence, that a remedy would be found as soon as there was machinery to make it possible. This was furnished by the Roman law. According to that system, the buyer stood in the place of his seller, and a fusion of the Roman with the Anglo-Saxon rule was all that was needed. Bracton, who modeled his book upon the writings of the medieval civilians, shows how this thought was used. He first puts the case of a conveyance with the usual clause binding the grantor and his heirs to warrant and defend the grantee and his heirs. He then goes on. Again, one may make his gift greater and make other persons quasi-heirs, although, in fact, they are not heirs, as when he says in the gift, to have and to hold to such a one and his heirs, or to whomsoever he shall choose to give or assign the said land, and I and my heirs will warrant to the said so, and his heirs, or to whomsoever he shall choose to give or assign the said land, and their heirs against all persons. In which case, if the grantee shall have given or assigned the land, and then have died without heirs, The grantor and his heirs begin to hold the place of the first grantee and his heirs, and are in place of the first grantee's heir, pro hered, so far as concerns warranting to his assigns and their heirs according to the clause contained in the first grantor's charter, which would not be but for the mention of assigns in the first gift. But so long as the first grantee survives, or his heirs, they are held to warranty and not the first grantor. Here we see that, in order to entitle the assign to the benefit of the first grantor's warranty, assigns must be mentioned in the original grant and covenant. The scope of the ancient obligation was not extended without the warrantor's assent. But when it was extended, it was not by a contrivance like a modern letter of credit. Such a conception would have been impossible in that stage of the law. By mentioning assigns, the first grantor did not offer a covenant to any person who would thereafter purchase the land. If that had been the notion, there would have been a contract directly binding the first grantor to the assign as soon as the land was sold, and thus there would have been two warranties arising from the same clause, one to the first grantee, a second to the assign. But in fact the assign recovered on the original warranty to the first grantee. 2. He could only come on the first grantor after a failure of his immediate grantor's heirs. The first grantor, by mentioning assigns, simply enlarged the limits of his grantee's succession. The assign could vouch the first grantor only on the principles of succession. That is to say, he could only do so when, by the failure of the first grantee's blood, the first grantee's feudal relation to the first grantor, his persona, came to be sustained by the assign. This was not only carrying out the fiction with technical consistency, but was using it with good sense, as fictions generally have been used in the English law. Practically, it made little difference whether the assign got the benefit of the first grantor's warranty immediately or immediately, if he got it. The trouble arose where he could not summon the mean grantor, and the new right was given him for that case alone. Later, the assign did not have to wait for the failure of his immediate grantor's blood, but could take advantage of the first grantor's warranty from the beginning. If it should be suggested that what has been said goes to show that the first grantor's duty to warrant arose from the assign's becoming his man and owing homage, the answer is that he was not bound unless he had mentioned assigns in his grant, homage, or no homage. In this, Bracton is confirmed by all the later authorities. Another rule on which there are vast stores of forgotten learning will show how exactly the fiction fell in with the earlier law. Only those who were privy in estate with the person to whom the warranty was originally given could vouch the original warrantor. Looking back to the early procedure, it will be seen that, of course, only those in the same chain of title could even immediately get the benefit of a former owner's warranty. The ground on which a man was bound to warrant was that he had conveyed the property to the person who summoned him. Hence a man could summon no one but his grantor, and the successive vouchers came to an end when the last vouchee could not call on another from whom he had bought. Now when the process was abridged, no persons were made liable to summons who would not have been liable before. The present owner was allowed to vouch directly those who otherwise would have been indirectly bound to defend his title, but no others. Hence, he could only summon those from whom his grantor derived his title, but this was equally well expressed in terms of the fiction employed. In order to vouch, the present owner must have the estate of the person to whom the warranty was made. As every lawyer knows, the estate does not mean the land. It means the status or persona in regard to that land formerly sustained by another. The same word was used in alleging a right by prescription, that he and those whose estate he hath have for time, whereof memory runneth not to the contrary, and c. And it will be remembered that the word corresponds to the same requirement of succession there. To return to Bracton, it must be understood that the description of assigns as quasi-hereds is not accidental. He describes them in that way whenever he has occasion to speak of them. He even pushes the reasoning drawn from the analogy of inheritance to extremes and refers to it in countless passages. For instance, it should be noted that of heirs some are true heirs and some quasi-heirs in place of heirs and c, true heirs by way of succession quasi-heirs and c by the form of the gift, such as assigns and c1. If it should be suggested that Bracton's language is only a piece of medieval scholasticism, there are several answers. In the first place, it is nearly contemporaneous with the first appearance of the right in question. This is shown by his citing authority for it as for something which might be disputed. He says, and that warranty must be made to assigns according to the form of the gift is proved in the circuit of W. der Reylig, about the end of the roll, and c. It is not justifiable to assume that a contemporary explanation of a new rule had nothing to do with its appearance. Again, the fact is clear that the assign got the benefit of the warranty to the first grantee, not of a new one to himself, as has been shown, and Bracton's explanation of how this was worked out falls in with what has been seen of the course of the German and Anglo-Saxon law, and with the pervading thought of the Roman law. Finally, and most important, the requirement that the assign should be in of the first grantee's estate has remained a requirement from that day to this. The fact that the same thing is required in the same words as in prescription goes far to show that the same technical thought has governed both. I have said Glanvill's predecessors probably regarded warranty as an obligation incident to a conveyance, rather than as a contract. But when it became usual to insert the undertaking to warrant in a deed or charter of fiefment, it lost something of its former isolation as a duty standing by itself, and admitted of being generalized. It was a promise by deed, and a promise by deed was a covenant. This was a covenant having peculiar consequences attached to it, no doubt. It differed also in the scope of its obligation from some other covenants, as will be shown hereafter. But still, it was a covenant, and could sometimes be sued on as such. It was spoken of in the yearbooks of Edward Roman III as a covenant which falls in the blood, too as distinguished from those where the acquittance fell on the land and not on the person. The importance of this circumstance lies in the working of the law of warranty upon other covenants which took its place. When the old actions for land gave way to more modern and speedier forms, warrantors were no longer vouched in to defend, and if a grantee was evicted, damages took the place of a grant of other land. The ancient warranty disappeared, and was replaced by the covenants which we still find in our deeds, including the covenants for season, for right to convey, against encumbrances, for quiet enjoyment, of warranty, and for further assurance. But the principles on which an assign could have the benefit of these covenants were derived from those which governed warranty, as anyone may see by looking at the earlier decisions. For instance, the question, what was a sufficient assignment to give an assign the benefit of a covenant for quiet enjoyment, was argued and decided on the authority of the old cases of warranty. /4/. The assign, as in warranty, came in under the old covenant with the first covenantee, not by any new right of his own. Thus, in an action by an assign on a covenant for further assurance, the defendant set up a release by the original covenantee after the commencement of the suit. The court held that the assignee should have the benefit of the covenant. They held that although the breach was in the time of the assignee, yet if the release had been by the covenantee, who is a party to the deed, and from whom the plaintiff derives, before any breach or before the suit commenced, it had been a good bar to the assignee from bringing this writ of covenant. But the breach of the covenant being in the time of the assignee, and the action brought by him, and so attached in his person, the covenantee cannot release this action wherein the assignee is interested. The covenantee, even after assignment, remains the legal party to the contract. The assign comes in under him, and does not put an end to his control over it, until by breach and action, a new right attaches in the assign's person, distinct from the rights derived from the persona of his grantor. Later, the assign got a more independent standing, as the original foundation of his rights sunk gradually out of sight, and a release after assignment became ineffectual, at least in the case of a covenant to pay rent. Only privies in estate with the original covenantee can have the benefit of covenants for title. It has been shown that a similar limitation of the benefits of the ancient warranty was required by its earlier history before the assign was allowed to sue, and that the fiction by which he got that right could not extend it beyond that limit. This analogy also was followed. For instance, a tenant in tail mail made a lease for years with covenants of right to let and for quiet enjoyment, and then died without issue mail. The lessee assigned the lease to the plaintiff. The latter was soon turned out, and thereupon brought an action upon the covenant against the executor of the lessor. It was held that he could not recover, because he was not privy in estate with the original covenantee. For the lease, which was the original covenantee's estate, was ended by the death of the lessor and termination of the estate tail out of which the lease was granted, before the form of assignment to the plaintiff. The only point remaining to make the analogy between covenants for title and warranty complete was to require assigns to be mentioned in order to enable them to sue. In modern times, of course, such a requirement, if it should exist, would be purely formal, and would be of no importance except as an earmark by which to trace the history of a doctrine. It would aid our studies if we could say that wherever assigns are to get the benefit of a covenant as privies in a state with the covenantee, they must be mentioned in the covenant. Whether such a requirement does exist or not would be hard to tell from the decisions alone. It is commonly supposed not to. But the popular opinion on this trifling point springs from a failure to understand one of the great antinomies of the law, which must now be explained. So far as we have gone, we have found that, wherever one party steps into the rights or obligations of another, without in turn filling the situation of fact of which those rights or obligations are the legal consequences, the substitution is explained by a fictitious identification of the two individuals, which is derived from the analogy of the inheritance. This identification has been seen as it has been consciously worked out in the creation of the executor, whose entire status is governed by it. It has been seen still consciously applied in the narrower sphere of the heir. It has been found hidden at the root of the relation between buyer and seller in two cases at least, prescription and warranty, when the history of that relation is opened to a sufficient depth. But although it would be more symmetrical if this analysis exhausted the subject, there is another class of cases in which the transfer of rights takes place upon a wholly different plan. In explaining the succession which is worked out between buyer and seller for the purpose of creating a prescriptive right, such as a right-of-way over neighboring land to the land bought and sold, it was shown that one who, instead of purchasing the land, had wrongfully possessed himself of it by force, would not be treated as a successor, and would get no benefit from the previous use of the way by his decisee. But when the former possessor has already gained a right-of-way before he is turned out, a new principle comes into operation. If the owner of the land over which the way ran stopped it up, and was sued by the wrongful possessor, a defense on the ground that the decisor had not succeeded to the former owner's rights would not prevail. The decisor would be protected in his possession of the land against all but the rightful owner, and he would equally be protected in his use of the way. This rule of law does not stand on a succession between the wrongful possessor and the owner, which is out of the question. Neither can it be defended on the same ground as the protection to the occupation of the land itself. That ground is that the law defends possession against everything except a better title. But, as has been said before, the common law does not recognize possession of a way. A man who has used a way 10 years without title cannot sue even a stranger for stopping it. He was a trespasser at the beginning, he is nothing but a trespasser still. There must exist a right against the servient owner before there is a right against anybody else. At the same time, it is clear that a way is no more capable of possession because somebody else has a right to it than if no one had. How comes it, then, that one who has neither title nor possession is so far favored? The answer is to be found, not in reasoning, but in a failure to reason. In the first lecture of this course, the thought with which we have to deal was shown in its theological stage, to borrow Kant's well-known phraseology, as where an axe was made the object of criminal process, and also in the metaphysical stage, where the language of personification alone survived, but survived to cause confusion of reasoning. The case put seems to be an illustration of the latter. The language of the law of easements was built up out of similes drawn from persons at a time when the noxo deditio was still familiar. And then, as often happens, language reacted upon thought, so that conclusions were drawn as to the rights themselves from the terms in which they happened to be expressed. When one estate was said to be enslaved to another, or a right-of-way was said to be a quality or incident of a neighboring piece of land, men's minds were not alert to see that these phrases were only so many personifying metaphors, which explained nothing unless the figure of speech was true. Ragran deduced the negative nature of servitudes from the rule that the land owes the services, not the person, protium non persona servit. For said Ragran, the land alone being bound, it can only be bound passively. Austin called this an absurd remark. One but the jurists from whom we have inherited our law of easements were contented with no better reasoning. Papinian himself wrote that servitudes cannot be partially extinguished because they are due from lands, not persons. Celsus thus decides the case which I took for my illustration. Even if possession of a dominant estate is acquired by forcibly ejecting the owner, the way will be retained, since the estate is possessed in such quality and condition as it is when taken. The commentator Godefroy tersely adds that there are two such conditions, slavery and freedom, and his antithesis is as old as Cicero. For so, in another passage, Celsus asks, what else are the rights attaching to land but qualities of that land? So Justinian's institutes speak of servitudes which inhere in buildings. 6. So Paulus speaks of such rights as being accessory to bodies. And thus, adds Godefroy, rights may belong to inanimate things. It easily followed from all this that a sale of the dominant estate carried existing easements, not because the buyer succeeded to the place of the seller, but because land is bound to land. All these figures import that land is capable of having rights, as Austin recognizes. Indeed, he even says that the land is erected into a legal or fictitious person and is styled predium dominans. But if this means anything more than to explain what is implied by the Roman metaphors, it goes too far. The dominant estate was never erected into a legal person, either by conscious fiction or as a result of primitive beliefs. /4/ it could not sue or be sued, like a ship in the Admiralty. It is not supposed that its possessor could maintain an action for an interference with an easement before his time, as an heir could for an injury to property of the heredibus jascens. If land had even been systematically treated as capable of acquiring rights, the time of a decisi might have been added to that of the wrongful occupant, on the ground that the land, and not this or that individual, was gaining the easement, and that long association between the enjoyment of the privilege and the land was sufficient, which has never been the law. All that can be said is that the metaphors and similes employed naturally led to the rule which has prevailed, and that, as this rule was just as good as any other, or at least was unobjectionable, it was drawn from the figures of speech without attracting attention, and before anyone had seen that they were only figures, which proved nothing and justified no conclusion. As easements were said to belong to the dominant estate, it followed that whoever possessed the land had a right of the same degree over what was incidental to it. If the true meaning had been that a way or other easement admits of possession, and is taken possession of with the land to which it runs, and that its enjoyment is protected on the same grounds as possession in other cases, the thought could have been understood. But that was not the meaning of the Roman law, and, as has been shown, it is not the doctrine of ours. We must take it that easements have become an incident of land by an unconscious and unreasoned assumption that a piece of land can have rights. It need not be said that this is absurd, although the rules of law which are based upon it are not so. Absurd or not, the similes as well as the principles of the Roman law reappear in Bracton. He says, the servitude by which land is subjected to land is made on the likeness of that by which man is made the slave of man. 1. For rights belong to a free tenement, as well as tangible things. They may be called rights or liberties with regard to the tenements to which they are owed, but servitudes with regard to the tenements by which they are owed. One estate is free, the other subjected to slavery. 2. May be called an arrangement by which house is subjected to house, farm to farm, holding to holding. No passage has met my eye in which Bracton expressly decides that an easement goes with the dominant estate upon a disseisin, but what he says leaves little doubt that he followed the Roman law in this, as in other things. The writ against a disseisor was for so much land and its appurtenances, which must mean that he who had the land even wrongfully had the appurtenances. So Bracton says an action is in rem, whether it is for the principal thing or for a right which adheres to the thing, as when one sues for a right of way. Since rights of this sort are all incorporeal things, and are quasi-possessed and reside in bodies, and cannot be got or kept without the bodies in which they inhere, nor in any way had without the bodies to which they belong. 3. And again, since rights do not admit of delivery, but are transferred with the thing in which they are, that is, the bodily thing, he to whom they are transferred forthwith has a quasi-possession of those rights as soon as he has the body in which they are. 4. There is no doubt about the later law, as has been said at the outset. We have thus traced two competing and mutually inconsistent principles into our law. On the one hand is the conception of succession or privity, on the other, that of rights inhering in a thing. Bracton seems to have vacillated a little from a feeling of the possibility of conflict between the two. The benefit of a warranty was confined to those who, by the act and consent of the grantee, succeeded to his place. It did not pass to assigns unless assigns were mentioned. Bracton supposes grants of easements with or without mention of assigns, which looks as if he thought the difference might be material with regard to easements also. He further says that if an easement be granted to his heirs and assigns, all such by the form of the grant are allowed the use in succession, and all others are wholly excluded. But he is not speaking of what the rights of a desacer would be as against one not having a better title. And he immediately adds that they are rights over a corporeal object belonging to a corporeal object. Although it may be doubted whether the mention of assigns was ever necessary to attach an easement to land, and although it is very certain that it did not remain so long, the difficulty referred to grew greater as time went on. It would have been easily disposed of if the only rights which could be annexed to land were easements, such as a right-of-way. It then might have been said that these were certain limited interests in land, less than ownership in extent, but like it in kind, and therefore properly transferred by the same means that ownership was. A right-of-way, it might have been argued, is not to be approached from the point of view of contract. It does not presuppose any promise on the part of the servient owner. His obligation, although more troublesome to him than to others, is the same as that of everyone else. It is the purely negative duty, not to obstruct or interfere with a right of property. But although the test of rights going with the land may have been something of that nature, this will not help us to understand the cases without a good deal of explanation. For such rights might exist to active services which had to be performed by the person who held the servient estate. It strikes our ear strangely to hear a right to services from an individual called a right of property as distinguished from contract. Still, this will be found to have been the way in which such rights were regarded. Bracton argues that it is no wrong to the lord for the tenant to alienate land held by free and perfect gift, on the ground that the land is bound and charged with the services into whose hands soever it may come. The lord is said to have a fee in the homage and services, and therefore no entry upon the land which does not disturb them injures him. It is the tenement which imposes the obligation of homage. And the same thing is true of villein and other feudal services. The law remained unchanged when feudal services took the form of rent. For even in our modern terms for year's rent is still treated as something issuing out of the leased premises, so that to this day, although, if you hire a whole house and it burns down, you have to pay without abatement, because you have the land out of which the rent issues, yet if you only hire a suite of rooms and they are burned, you pay rent no longer, because you no longer have the tenement out of which it comes. It is obvious that the foregoing reasoning leads to the conclusion that a desacer of the tenant would be bound as much as the tenant himself, and this conclusion was adopted by the early law. The lord could require the services, or collect the rent of anyone who had the land, because, as was said in language very like Bracton's, the charge of the rent goes with the land. Then as to the right to the rent. Rent was treated in early law as a real right, of which a disseisin was possible, and for which a possessory action could be brought. If, as was very frequently the case, the leased land lay within a manor, the rent was parcel of the manor, for so that there was some ground for saying that one who was seized of the manor, that is, who possessed the lands occupied by the lord of the manor, and was recognized by the tenants as lord, had the rents as incident thereto. Thus Bryan, Chief Justice of England under Henry Roman VII, says, "If I am disseised of a manor, and the tenants pay their rent to the dissacer, and then I re-enter, I shall not have the back rent of my tenants which they have paid to my dissacer, but the dissacer shall pay for all in trespass or assize." This opinion was evidently founded on the notion that the rent was attached to the chief land like an easement. Sic fit ut debintur re a re. Different principles might have applied when the rent was not parcel of a manor, and was only part of the reversion. That is, part of the landlord's fee or estate out of which the lease was carved. If the lease and rent were merely internal divisions of that estate, the rent could not be claimed except by one who was privy to that estate. A dissacer would get a new and different fee, and would not have the estate of which the rent was part. And therefore it would seem that in such a case the tenant could refuse to pay him rent, and that payment to him would be no defense against the true owner. 1. Nevertheless, if the tenant recognized him, the desacer would be protected as against persons who could not show a better title. /2/ Furthermore, the rent was so far annexed to the land that whoever came by the reversion lawfully could collect it, including the superior lord in case of escheat. Yet escheat meant the extinction of the fee of which the lease and rent were parts, and although Bracton regarded the lord as coming in under the tenant's title pro hered, in privity, it was soon correctly settled that he did not, but came in paramount. This instance, therefore, comes very near that of a desacer. Services and rent, then, were, and to some extent are still, dealt with by the law from the point of view of property. They were things which could be owned and transferred like other property. They could be possessed even by wrong, and possessory remedies were given for them. No such notion was applied to warranties, or to any right which was regarded wholly from the point of view of contract. And when we turn to the history of those remedies for rent which sounded in contract, we find that they were so regarded. The actions of debt and covenant could not be maintained without privity, in the 9th year of Henry Roman VI. It was doubted whether an heir having the reversion by descent could have debt, and it was held that a grantee of the reversion, although he had the rent, could not have that remedy for it. A few years later, it was decided that the heir could maintain debt, too, and in Henry Roman VII. Reign the remedy was extended to the devisee, 3 who, as has been remarked above, seemed more akin to the heir than a grantee, and was more easily likened to him. It was then logically necessary to give assigns the same action, and this followed. For the privity of contract followed the estate, so that the assignee of the reversion could sue the person then holding the term. 5 On like grounds he was afterwards allowed to maintain covenant. /6/ But these actions have never lain for or against persons not privy in estate with the lessor and lessee respectively, because privity to the contract could never be worked out without succession to the title. However, all these niceties had no application to the old freehold rents of the feudal period, because the contractual remedies did not apply to them until the time of Queen Anne. /8/ The freehold rent was just as much real estate as an acre of land, and it was sued for by the similar remedy of an assize, asking to be put back into possession. The allowance of contractual remedies shows that rent and feudal services of that nature, although dealt with as things capable of possession, and looked at generally from the point of view of property rather than of contract, yet approach much nearer to the nature of the latter than a mere duty not to interfere with away. Other cases come nearer still. The sphere of prescription and custom in imposing active duties is large in early law. Sometimes the duty is incident to the ownership of certain land. Sometimes the right is, and sometimes both are, as in the case of an easement. When the service was for the benefit of other land, the fact that the burden, in popular language, fell upon one parcel was of itself a reason for the benefit attaching to the other. Instances of different kinds are these. A parson might be bound by custom to keep a bull and a boar for the use of his parish. /1/ A right could be attached to a manor by prescription to have a convent sing in the manor chapel. A right might be gained by like means to have certain land fenced by the owner of the neighboring lot. Now, it may readily be conceded that even rights like the last two, when attached to land, were looked at as property and were spoken of as the subject of grant. For it may be conceded that, in many cases where the statement sounds strange to modern ears, the obligation was regarded as failing on the land alone, and not on the person of the tenant. And it may be conjectured that this view arose naturally and reasonably from there, having been originally no remedy to compel performance of such services, except a distress executed on the servient land. One but any conjectured distinction between obligations for which the primitive remedy was distress alone, and others, if it ever existed, must soon have faded from view, and the line between those rights which can be deemed rights of property and those which are mere contracts is hard to see after the last examples. A covenant to repair is commonly supposed to be a pure matter of contract. What is the difference between a duty to repair and a duty to fence? The difficulty remains almost as great as ever of finding the dividing line between the competing principles of transfer succession on the one side and possession of dominant land on the other. If a right in the nature of an easement could be attached to land by prescription, it could equally be attached by grant. If it went with the land in one case, even into the hands of a desacer, it must have gone with it in the other. No satisfactory distinction could be based on the mode of acquisition, nor was any attempted. As the right was not confined to assigns, there was no need of mentioning assigns. 3. In modern times, at least, if not in early law, such rights can be created by covenant as well as by grant. 1. And, on the other hand, it is ancient law that an action of covenant may be maintained upon an instrument of grant. The result of all this was that not only a right created by covenant, but the action of covenant itself might in such cases go to assigns, although not mentioned, at a time when such mention was essential to give them the benefit of a warranty. Logically, these premises led one step farther, and not only assigns not named, but decisors, should have been allowed to maintain their action on the contract, as they had the right arising out of it. Indeed, if the plaintiff had a right which when obtained by grant would have entitled him to covenant, it was open to argument that he should be allowed the same action when he had the right by prescription, although, as has been seen in the case of rent, it did not follow in practice from a man's having a right that he had the contractual remedies for it. 3/covenant required a specialty, but prescription was said to be a sufficiently good specialty. 4. Where, then, was the line to be drawn between covenants that devolved only to successors and those that went with the land? The difficulty becomes more striking upon further examination of the early law. For side by side with the personal warranty which has been discussed hitherto, there was another warranty which has not yet been mentioned by which particular land alone was bound. The personal warranty bound only the warrantor and his heirs. As was said in a case of the time of Edward I, no one can bind assigns to warranty, since warranty always extends to heirs who claim by succession and not by assignment. But when particular land was bound, the warranty went with it, even into the hands of the king, because, as Bracton says, the thing goes with its burden to everyone. Fleda writes that every possessor will be held, for there cannot be a doubt that a decisor would have been bound equally with one whose possession was lawful. We are now ready for a case 5 decided under Edward Roman III, which has been discussed from the time of Fitzherbert and coked down to Lord St. Leonard's and Mr. Rawle, which is still law, and is said to remain still unexplained. 6. It shows the judges hesitating between the two conceptions to which this lecture has been devoted. If they are understood, I think the explanation will be clear. Pakenham brought covenant as heir of the covenantee against a prior, for breach of a covenant made by the defendant's predecessor with the plaintiff's great-grandfather, that the prior and convent should sing every week in a chapel in his manor, for him and his servants. The defendant first pleaded that the plaintiff and his servants were not dwelling within the manor, but not daring to rest his case on that, he pleaded that the plaintiff was not heir, but that his elder brother was. The plaintiff replied that he was tenant of the manor, and that his great-grandfather enfiefed a stranger, who enfiefed the plaintiff and his wife, and that thus the plaintiff was tenant of the manor by purchase and privy to the ancestor, and also that the services had been rendered for a time whereof the memory was not. It is evident from these pleadings that assigns were not mentioned in the covenant, and so it has always been taken. /1/ It also appears that the plaintiff was trying to stand on two grounds. First, privity, as descendant and assign of the covenantee. Second, that the service was attached to the manor by covenant or by prescription, and that he could maintain covenant as tenant of the manor, from whichever source the duty arose. Finchton, J. puts the case of parsoners making partition, and one covenanting with the other to acquit of suit. A purchaser has the advantage of the covenant. Belknap, for the defendants, agrees but distinguishes. In that case, the acquittance falls on the land and not on the person. That is to say, such obligations follow the analogy of easements, and, as the burden falls on the quasi-servient estate, the benefit goes with the dominant land to assigns, whether mentioned or not, and they are not considered from the point of view of contract at all. Warranty, on the other hand, is a contract pure and simple, and lies in the blood falls on the person, not on the land. Finchton, a fortiori in this case, for there the action was maintained because the plaintiff was tenant of the land from which the suit was due, and here he is tenant of the manor where the chapel is. Witchingham, J. If the king grants warren to another who is tenant of the manor, he shall have warren and C, but the warren will not pass by the grant, because the warren is not appendant to the manor. No more does it seem the services are here appendant to the manor. Thorpe CJ to Belknap. There are some covenants on which no one shall have an action, but the party to the covenant, or his heir, and some covenants have inheritance in the land, so that whoever has the land by alienation, or in other manner, shall have action of covenant. Or, as it is stated in Fitzherbert's abridgment, one the inhabitants of the land as well as everyone who has the land shall have the covenant. And when you say he is not heir, he is privy of blood, and may be heir. 2. And also he is tenant of the land, and it is a thing which is annexed to the chapel, which is in the manor, and so annexed to the manor. And so he has said that the services have been rendered for all time whereof there is memory, whence it is right this action should be maintained. Belknap denied that the plaintiff counted on such a prescription, but Thorpe said he did, and we bear record of it, and the case was adjourned. It will be seen that the discussion followed the lines marked out by the pleading. One judge thought that the plaintiff was entitled to recover as tenant of the manor. The other puisne doubted, but agreed that the case must be discussed on the analogy of easements. The Chief Justice, after suggesting the possibility of sufficient privity on the ground that the plaintiff was privy in blood and might be heir, turns to the other argument as more promising, and evidently founds his opinion upon it. One, it would almost seem that he considered a prescriptive right enough to support the action, and it is pretty clear that he thought that a deceasor would have had the same rights as the plaintiff. In the reign of Henry Roman IV, another case too arose upon a covenant very like the last, but this time the facts were reversed. The plaintiff counted as heir, but did not allege that he was tenant of the manor. The defendant, not denying the plaintiff's descent, pleaded in substance that he was not tenant of the manor in his own right. The question raised by the pleadings, therefore, was whether the heir of the covenantee could sue without being tenant of the manor. If the covenant was to be approached from the side of contract, the heir was party to it as representing the covenantee. If, on the other hand, it was treated as amounting to the grant of a service like an easement, it would naturally go with the manor if made to the lord of the manor. It seems to have been thought that such a covenant might go either way, according as it was made to the tenant of the manor or to a stranger. Markham, one of the judges, says, "In a writ of covenant one must be privy to the covenant if he would have a writ of covenant or aid by the covenant. But peradventure, if the covenant had been made with the lord of the manor, who had inheritance in the manor, isn't come determination poit ester fate, it would be otherwise," which was admitted. When it was assumed that the covenant was not so made as to attach to the manor, and the court, observing that the service was rather spiritual than temporal, were inclined to think that the heir could sue. 2. The defendant accordingly over and set up a release. It will be seen how fully this agrees with the former case. The distinction taken by Markham is stated very clearly in a reported by Lord Coke. In the argument of Chudley's case, the line is drawn thus. Always, the warranty as to voucher requires privity of estate to which it was annexed, i.e. succession to the original covenantee, and the same law of a use. But of things annexed to land, it is otherwise, as of commons, advocens, and the like appendants or appurtenances. So a deceasor, a baiter, intruder, or the lord by escheat, and c, shall have them as things annexed to the land. So note a diversity between a use or warranty, and the like things annexed to the estate of the land in privity, and commons, advowsons, and other hereditaments annexed to the possession of the land. 3. And this, it seems to me, is the nearest approach which has ever been made to the truth. Coke, in his commentary on Littleton 385a, takes a distinction between a warranty, which binds the party to yield lands and recompense, and a covenant annexed to the land, which is to yield but damages. If Lord Coke had meant to distinguish between warranties and all covenants which in our loose modern sense are said to run with the land, this statement would be less satisfactory than the preceding. A warranty was a covenant which sometimes yielded but damages, and a covenant in the old law sometimes yielded land. In looking at the early cases, we are reminded of the still earlier German procedure, in which it did not matter whether the plaintiff's claim was founded on a right of property in a thing, or simply on a contract for it. One covenant was brought for a freehold under Edward I, II, and under Edward Roman III. It seems that a mill could be abated by the same action, when maintained contrary to an easement created by covenant. But Lord Coke did not mean to lay down any sweeping doctrine, for his conclusion is that a covenant is in many cases extended further than the warranty. Furthermore, this statement, as Lord Coke meant it, is perfectly consistent with the other and more important distinction between warranties and rights in the nature of easements or covenants creating such rights. For Lord Coke's examples are confined to covenants of the latter sort, being in fact only the cases just stated from the yearbooks. Later writers, however, have wholly forgotten the distinction in question, and accordingly it has failed to settle the disputed line between conflicting principles. Covenants which started from the analogy of warranties, and others to which was applied the language and reasoning of easements, have been confounded together under the title of covenants running with the land. The phrase, running with the land, is only appropriate to covenants which pass like easements. But we can easily see how it came to be used more loosely. It has already been shown that covenants for title, like warranties, went only to successors of the original covenantee. The technical expression for the rule was that they were annexed to the estate in privity. Nothing was easier than to overlook the technical use of the word estate, and to say that such covenants went with the land. This was done, and forthwith all distinctions became doubtful. It probably had been necessary to mention assigns in covenants for title, as it certainly had been to give them the benefit of the ancient warranty. For this seems to have been the formal mark of those covenants which passed only to privies. But it was not necessary to mention assigns in order to attach easements and the like to land. Why should it be necessary for one covenant running with the land more than another? And if necessary for one, why not for all? The necessity of such mention in modern times has been supposed to be governed by a fanciful rule of Lord Coke's. 3. On the other hand, the question is raised whether covenants which should pass irrespective of privity are not governed by the same rule which governs warranties. These questions have not lost their importance. Covenants for title are in every deed, and other covenants are only less common, which, it remains to show, belong to the other class. Chief among these is the covenant to repair. It has already been observed that an easement of fencing may be annexed to land, and it was then asked what was the difference in kind between a right to have another person build such structures and a right to have him repair structures already built. Evidence is not wanting to show that the likeness was perceived. Only, as such covenants are rarely, if ever, made, except in leases, there is always privity to the original parties. For the lease could not, and the reversion would not be likely to, go by disseisin. The Dean of Windsor's case decides that such a covenant binds an assignee of the term, although not named. It is reported in 2 books of the highest authority, one of the reporters being Lord Coke, the other Croke, who was also a judge. Croke gives the reason thus: for a covenant which runs and rests with the land lies for or against the assignee at the common law, quia transit terra cum onera, although the assignees be not named in the covenant. This is the reason which governed easements, and the very phrase which was used to account for all possessors being bound by a covenant binding a parcel of land to warranty. Coke says, for such covenant which extends to the support of the thing demised is quodmodo appurtenant to it, and goes with it. Again the language of easements. And to make this plainer, if need be, it is added, if a man grants to one Estovers to repair his house, it is appurtenant to his house. Estovers for repair went with the land, like other rights of common, /1/which, as Lord Coke has told us, passed even to dissessors. In the next reign the converse proposition was decided, that an assignee of the reversion was entitled in like manner to the benefit of the covenant, because it is a covenant which runs with the land. 2. The same law was applied, with still clearer reason, to a covenant to leave 15 acres unplowed for pasture, which was held to bind an assignee not named, /3/, and it would seem, to a covenant to keep land properly manured. 4. If the analogy which led to this class of decisions were followed out, a dissessor could sue or be sued upon such covenants, if the other facts were of such a kind as to raise the question. There is nothing but the novelty of the proposition which need prevent its being accepted. It has been mentioned above that words of covenant may annex an easement to land, and that words of grant may import a covenant. It would be rather narrow to give a dissessor one remedy, and deny him another where the right was one, and the same words made both the grant and the covenant. The language commonly used, however, throws doubt and darkness over this and every other question connected with the subject. It is a consequence, already referred to, of confounding covenants for title, and the class last discussed, under the name of covenants running with the land. According to the general opinion, there must be a privity of estate between the covenanter and covenantee in the latter class of cases in order to bind the assigns of the covenanter. Some have supposed this privity to be tenure, some an interest of the covenantee in the land of the covenantor, and so on. The first notion is false, the second misleading, and the proposition to which they are applied is unfounded. Privity of estate, as used in connection with covenants at common law, does not mean tenure or easement, it means succession to a title. 2. It is never necessary between covenantor and covenantee or any other persons, except between the present owner and the original covenantee. And on principle, it is only necessary between them in those cases such as warranties and probably covenants for title where, the covenants being regarded wholly from the side of contract, the benefit goes by way of succession and not with the land. If now it should be again asked, at the end of this long discussion, where the line is to be drawn between these two classes of covenants, the answer is necessarily vague in view of the authorities. The following propositions may be of some service. A. With regard to covenants which go with the land. 1. Where either by tradition or good sense the burden of the obligation would be said, elliptically, to fall on the land of the covenanter, the creation of such a burden is in theory a grant or transfer of a partial interest in that land to the covenantee. As the right of property so created can be asserted against every possessor of the land, it would not be extravagant or absurd to allow it to be asserted by the action of covenant. 2. Where such a right is granted to the owner of a neighboring piece of land for the benefit of that land, the right will be attached to the land and go with it into all hands. The action of covenant would be allowed to assigns not named, and it would not be absurd to give it to desassors. 3. There is one case of a service, the burden of which does not fall upon land even in theory, but the benefit of which might go at common law with land which it benefited. This is the case of singing and the like by a convent. It will be observed that the service, although not falling on land, is to be performed by a corporation permanently seated in the neighborhood. Similar cases are not likely to arise now. B. With regard to covenants, which go only with the estate in the land. In general, the benefit of covenants which cannot be likened to grants, and the burden of which does not fall on land, is confined to the covenantee and those who sustain his persona, namely, his executor or heir. In certain cases, of which the original and type was the ancient warranty, and of which the modern covenants for title are present examples, the sphere of succession was enlarged by the mention of assigns, and assigns are still allowed to represent the original covenantee for the purposes of that contract. But it is only by way of succession that any other person than the party to the contract can sue upon it. Hence the plaintiff must always be privy in estate with the covenantee. See, it is impossible, however, to tell by general reasoning what rights will be held in English law to belong to the former class, or where the line will be drawn between the two. The authorities must be consulted as an arbitrary fact. Although it might sometimes seem that the test of the first was whether the service was of a nature capable of grant, so that if it rested purely in covenant it would not follow the land, yet if this test were accepted, it has already been shown that, apart from tradition, some services which do follow the land could only be matter of covenant. The grant of light and air, a well-established easement, is called a covenant not to build on the servient land to the injury of the light, by Baron Park. 2. And although this might be doubted, 3. It has been seen that at least one well-established easement, that of fencing, cannot be considered as a right granted out of the servient land with any more propriety than 100 other services, which would be only matter of contract, if the law allowed them to be annexed to land in like manner. The duty to repair exists only by way of covenant, yet the reasoning of the leading cases is drawn from the law of easement. On the other hand, a covenant by a lessee to build a wall upon the leased premises was held, in Spencer's case, not to bind assigns unless mentioned. But Lord Coke says that it would have bound them if it had purported to. The analogy of warranty makes its appearance and throws a doubt on the fundamental principle of the case. We can only say that the application of the law is limited by custom, and by the rule that new and unusual burdens cannot be imposed on land. The general object of this lecture is to discover the theory on which a man is allowed to enjoy a special right when the facts out of which the right arises are not true of him. The transfer of easements presented itself as one case to be explained, and that has now been analyzed, and its influence on the law has been traced. But the principle of such transfers is clearly anomalous and does not affect the general doctrine of the law. The general doctrine is that which has been seen exemplified in prescription, warranty, and such covenants as followed the analogy mentioned. Another illustration, which has not yet been, is to be found in the law of uses. In old times, a use was a chose and action that was considered very nearly from the point of view of contract, and it had a similar history to that which has been traced in other cases. At first it was doubted whether proof of such a secret trust ought to be allowed, even as against the heir. When it was allowed, however, in the end, to and then the principle of succession was extended to the assign, but it never went further. Only those who were privies in a state with the original fiefy to uses were bound by the use. A decisor was no more bound by the confidence reposed in his decisee than he was entitled to vouch his decisee's warrantor. In the time of Henry Roman VIII, it was said that, where use shall be, it is requisite that there be two things, sc. confidence and privity. As I say, if there be not privity or confidence, then there can be no use. And hence if the feoffees make a fiefment to one who has notice of the use, now the law will adjudge him sais to the first use, since there is sufficient privity between the first fiefer and him, for if he had warranted he should vouch as a sign, which proves privity, and he is in the per by the feoffees. But where one comes into the land and the post, as the lord by a sheet or the decisor, then the use is altered and changed, because privity is wanting. To this day it is said that a trust is annexed in privity to the person and to the estate, which means to the persona. It is not regarded as issuing out of the land like a rent, so that while a rent binds everyone who has the land, no matter how, a decisor is not bound by the trust. The case of the lord taking by a sheet has been doubted, and it will be remembered that there is a difference between Bracton and later authors as to whether he comes in as quasi-heirs or as a stranger. Then as to the benefit of the use. We are told that the right to sue the subpoena descended indeed to the heir, on the ground of heirs idem persona cum antecessor, but that it was not assets. The sestui quae use was given power to sell by an early statute. 6. But with regard to trusts, Lord Coke tells us that in the reign of Queen Elizabeth all the judges in England held that a trust could not be assigned, because it was a matter in privity between them, and was in the nature of a chose in action. One uses and trusts were both divisible, however. From an early day, and now trusts are as alienable as any form of property. The history of early law everywhere shows that the difficulty of transferring a mere right was greatly felt when the situation of fact from which it sprung could not also be transferred. Analysis shows that the difficulty is real. The fiction which made such a transfer conceivable has now been explained, and its history has been followed until it has been seen to become a general mode of thought. It is now a matter of course that the buyer stands in the shoes of the seller, or, in the language of an old law book, that the assign is in a manner quasi-successor to his assignor. Whatever peculiarities of our law rest on that assumption may now be understood. Footnotes 3.1 E.G. and E. C. 74, Alfred C. 42, Ethelred Roman 4. 4, Section 1. 3.2 Bracht, Fall, 144-145, Fleta IC 40-41, Colit, 126b Hawkins PC BK, 2 CH, 23 Section 15. 3.3 Lib IC2 Adfin, 3.4 Bracht, Fall, 144a Assulto Premeditado, 4.1 Fall, 155 CF, 103b, 4.2 YB6 ed, Roman 4, 7 PL 18, 4.3 Ibid, and 21H Roman 7, 27 PL 5, 4.4 D47, 9.9, 7.1 Roman 21, 28, 7.2 Roman 9, Jowetts TR, BK Roman 9, P 437, Bones TR, PP 378, 379, 7.3 Roman 15, Jowett 449, Bone 397, 8.1 Roman 14, Jowett 509, Bone 495, 8.2 Roman 12, Jowett 443, 444, Bone 388, 83, 244, 245. 84L28, 11. 85 Solon. 86 C quadrupes papirium fessus dister actio ex lege duodecim tabularum descendit, qui lex voluit, aut duri quad nocuit, id ist, id animal, quad noxium commissit, aut estimationem noxii offera. D911 PR, just, inst, 49, Roman 12 tab, Roman 8. 6. 87 Gai inst, Roman 4, section 75-76, D942, section 1, C servus verdum faxit noxium v noxit, Roman 12 tab, Roman 12 2, cf, just, inst, 4.8, section 7. 91 D39, 27, sections 1 2, Gai inst, Roman 4, section 75. 92 Noxa caput sequitur, D911, section 12, inst, 4.8, section 5. 93 Quia desinit dominus esse ubi fera evacit, D911, section 10, inst, 49 PR, compare me v Burdit, 9 QB 101, 113. 101 D19, 514, section 3, Plin, Nat, Hist Roman 18, 3. 102 In lege antiqua si servis scient domino ferdum fecit, vel alium noxium commissit, servi nomen actio est noxalis, nec dominus suo nomen tenetur. D942. 103 Gaius inst, Roman 4. Section 77 says that a noxal action may change to a direct, and conversely, a direct action to a noxal. If a paterfamilias commits a tort, and then is adopted or becomes a slave, a noxal action now lies against his master in place of the direct one against himself as the wrongdoer. Just. Inst. 4.8, section 5. 11.1 LL. Alfred, C13, 1 Tyler, Primitive Culture, A.M., ed., p. 285 et sec. Bain, Mental and Moral Science, B.K., Roman 3, ch. 8, p. 261. 11.2 Florus, Epitome, Roman 2, 18, cf. Livy, Roman 9.1, 8 Roman 8, 39 Zanaras, Roman 7, 26 ed., Niebuhr, volume 43, pp. 98-99. 12.1 Gai inst, Roman 4, section 81. I give the reading of Hushk. Lycer enim etiam, si fato is furit mortus, mortuum dare, nam quamquam diximus, non etiam permissum rise esse, et mortuos homines dedir, tamen et si quis eam dederit, qui fato suo vita accessorit, ec liberator. Ulpian's statement, in D911 section 13, that the action is gone if the animal dies ante litem contestatam, is directed only to the point that liability is founded on possession of the thing. 12.2 Bello contra foedis suscepto. 12.3 Livy, Roman 8, 39, ver, hod dubi proximarum inducerum ruptor, de eo cocti refera praetors decretum fecerunt ut brucilis papius Romanis dederetur, fecels ramem ut censurant missi, et corpus brucili exanem, ips mort voluntaria ignominii si ac supplicio subtraxit, placuit cum corpor bona quoque ejus dedi. Cf. Zanaras, Roman 7. 26 ed. Niebuhr, volume 43, p. 97. See further Livy, v. 36, postulatum ut pro jure gentium violato fabii dederenter, and ib. I 32. 13.1 Livy, Roman 9. 5, 8, 9, 10. Nam quad dedition nostra negant exsolvi religini populum, id istos magis ni dedenter, quam quia ida si res habat, dicer, quis idio juris fecialium expers est, qui ignorit. The formula of surrender was as follows. Quando his homines injussu populi Romani quiridium foedis ictum iri spopenderunt, ac ob eam rem noxem nocurant, ob eam rem, quo populus Romanus celer impio sit salutis, hos homines vobis dido. Cf. Zanaras, Roman 7. 26 ed. Niebuhr, volume 43, pp. 98-99. 13.2 De Orator. I-40 and elsewhere. It is to be noticed that Florus in his account says dedition Mancini expiavit. Epitome, Roman 2, 18. It has already been observed that the cases mentioned by Livy seem to suggest that the object of the surrender was expiation, as much as they do that it was satisfaction of a contract. Zanaras says posthumous and Calvinist Greek characters. Romans 7, 26 ed. Niebuhr, volume 43, pp. 98-99. Cf. ib. p. 97. Compare serve. Adverg. Eclog Roman 4, 43, in legibus numicatum est, ut si quis imprudens occidus et hominum pro capite oxysi et natis igius in contine offerit ariatum. Igior, Roman 3, 387 and Festus subaci subiger. But cf. Wordsworth's Fragments and Specimens of Early Latin, note to Roman 12 tab, Roman 12. 2, p. 538. 14.1 D942. 14.22 Tissot, Droit Penal 615, 1 Ihering Geist d Roem. R. Section 14, 4 id Section 63. 14.3 All, Gel, Nox Attici 21 Quintal, Inst. Oret 3684 Turtle Apal, C4. 14.4 Cf. Varro, de Lingua Latina Roman 6. Liber, qui suas operas in servitut pro pecunia, quam debit, dum solverit nexus vocatur. 15.1 D911, Section 9 but cf. 1 Hale, PC 420. 15.2 D942, Section 1. 15.3 D911, Sections 4-5. 16.1 D491, Section 1, Ib. 7, Section 4. 16.2 Gaius in D44. 7.5 Section 6 Just, Inst. 4.5 Section 3. 16.3 D497, PR. 17.1 C Austin Jurisp. 3D ed. 513 Doctor and Student Dial 2 ch. 42. 17.2 Cf. L. Burgund, Roman 18, L. Rip, Roman 46, Al 48. 17.3 See the word liege Merkel Lex Salica P 103. Cf. Wilde Strafrecht der Germanen 660 N1. See further Lex Salica XL, Pactus pro tenor passus child. Et cloth, C5 Decretio Clotharic C5 Edictus Hilperici CC 5-7, and the observations of Soame in his treatise on the procedure of the Salic law, sections 20, 22, 27 French tr. The Venin, pp. 83n 93 94 101 3 130. 17.4 Wilde, Strafrecht 590. 18.1 cf. Wilde Strafrecht 660 N1, Merkel Lex Salica Gloss Liege P 103, Lex Saxon. Zi section 3, C Servus Perpetrato Facinor Fugerit, ida ut adimino ulterius inveniri non possit nihil solvat. Cf. Id Roman 2, section 5. Cap. Rip. C5. Nemini licet servum suum, propter damnum ob illo cubit in laudum, Dimiter. Sed justa qualitatem damni dominus pro illo respondit vel eum in composition aut ad ponam petitori offeret. C autem servus perpetrato celer fugerit, ida ut a domino penitus inveniri non possit, sacramento si dominus ejus excuser studit, quod nec sui voluntatis nec conscientia fuiset, quod servus ejus tail facinus commissit. 18.2 L. Saxon, Zi section 1. 18.3 Lex Angle, et were, Roman 16, omni damnum quod servus fecerit dominus amendit. 19.1 C3, 1 Thorpe Anc Laws pp. 27-29. 19.2 C74, 1 Thorpe p 149, cf. p 118 NACLL, Hen, I LXX, section 5. 19.3 C24, 1 Thorpe p 79, cf. INI C42, 1 Thorpe p 129. 19.4 C13, 1 Thorpe p 71. 19.5 1 Tyler, Primitive Culture, AM, ed. p 286. 21 cf. Record in Mali, Book 2 ch. 3 Section 16 24 ed. Roman 3. Visum fuit curiae, quod unusquisque magister navis tenetur responder de quacunc transgression per servient suos in navi sua facta. The laws of Olron were relied on in this case, cf. Stat. Of the staple ed. Roman 3, Stat. 2, c19. Later, the influence of the Roman law is clear. 22 Quan. Attach, c48 pl, 10 et sec. Cf. The form and manner of barren courts, c62 et sec. 21 1 Form and manner of barren courts, c63. 21 2 c64. This substantially follows the quonium attachmenta c. 48 pl 13 but is a little clearer. Contra Fitz, Aber, Caron pl. 389 8 ed. Roman 2. 22 1 Fitz, Aber, Bar pl. 290. 22-2 Mitchell v. Alestri, 1 Vent, 295, SC2 Lev, 172, SC3 Keb, 650, cf. May be Burdett, 9 QB 101, 113. 22-3 May v. Burdett, 9 QB 101. 22-4 Mason v. Keeling, 12 Mod 332, 335, SC1 LD. Rame, 606, 608. 23-1 Williams, J. in Cox v. Burbage, 13 CB. NS 430, 438. cf. Wills, J. in Reed v. Edwards, 17 CB. NS 245, 261. 23-2 Mason v. Keeling, 1 LD. Rame, 606, 608. 23-3 in the Laws of Ine, C. 42, 1 Thorpe Anc. Laws, 129. Personal liability seems to be imposed where there is a failure to fence. But if an animal breaks hedges, the only remedy mentioned is to kill it, the owner to have the skin and flesh, and forfeit the rest. The defendant was held because it was found that this was for default of guarding them. For default of good guard, in 27 As PL 56 Fall, 141 AD 1353 or 1354, it is much later that the reason is stated in the absolute form, because I am bound by law to keep my beasts without doing wrong to anyone. Mitch, 12 Henry Roman 7, Caleway 3b PL 7. See, further, the distinctions as to a horse killing a man in Regium Majestatem, Roman 4, c. 24. 24-1 Fall, 128. 24-2 cf. 1 Britain Nish. 6a b 16 top paging 1539, Bracht, Fall, 136b, ll. Alfred c. 13 1 Thorpe Anc Laws p. 71, Lex Saxon, tit, Roman 13, Lega Laman, tit ci, 24. 25-1 Fleta I-26 Section 10, Fitz, Aber, Coron PL 416, C. Generally Stondford PC IC2 Fall, 20 et sec. 1 Hale P. C. 410 et sec. 25-2 Doctor and Student Dial, 2 C. 51. 25-3 Plowed, 260. 25-4 Jacob Law Dict, Deodend. 25-5 YB 30 and 31 ed. I. pp. 524-525, cf. Bracht, Fall, 136b. 26-1 Fitz, Aber, Coron PL 403. 26-2 Bracht, 122 1 Britain Nish. Top P16, Fleta Ike. 25 Section 9 Fall, 37. 26-3 1 Hale, PC 423. 26-4 1 Rot, Parl. 372 2 Rot, Parl. 345 372 A B 3 Rot, Parl. 94A 120A 121 4 Rot, Parl. 12A B 492B 493. But C1 Hale PC 423. 26-5 1 Black Book of the Admiralty 242. 27-1 cf. Ticonderoga, Swaby 215 217. 27-2 China 7 Wall 53. 28-1 Doctor and Student Dial 2 C51. 28-2 1 Roll, Aber 530 C1. 29-1 3 Black Book of Adam 103. 29-2 Malik at Hell 2 How 210 234. 30-1 3 Kent 218. Customs of the Sea Cap. 27-141 182 in 3 Black Book of the Admiralty 103 243 245. 31-1 3 Kent's Com 188. 31-2 Clay v. Snellgrave 1 LD. Rame 576 577 SC1 Salk 33 cf. Mall P 355 Book 2 ch. 3 Section 8. 31-3 Ens perdrant lures lowers quant la nef est perdu. 2 Black Book 213. This is from the Judgments of the Sea, which according to the editor Roman 2 pp. Roman 44 Roman 47 is the most ancient extant source of modern maritime law except the decisions of Trani. So Mall Book 2 ch. 3 Section 7 p 354 If the ship perishes at sea, they lose their wages. So 1 Ciderfin 236 PL 2. 3213 Black Book pp. Lix, lxxiv. 3223 Black Book 263. It should be added, however, that it is laid down in the same book that, if the vessel is detained in port by the local authorities, the master is not bound to give the mariners wages, for he has earned no freight. 32.3 Lipson v. Harrison, 2 Weekly Rep 10. Cf. Louisa Jane, 2 Lowell, 295. 32.4.3 Kent's Com. 12th ed., 218, Ib. 138 N1. 32.5.3 Kent, 218. 32.6 Justin v. Ballum, 1 Salk, 34, SC 2 LD. Rame, 805. 33.1 D20. For 5 and 6, cf. Livy XXX, 38. 33.2 Pardesis, Droit, Com, N 961. 33.3.3 Keb, 112, 114, citing 1 roll, Aber, 530. 34.1 Godbolt, 260. 34.2.3 Colquhoun, Roman Civil Law, Section 2196. 35.1 Lex Salica Merkel, lxxiv, ed. Hilperich, Section 5. 36.1 C Lecture Roman 3, ad fin. 39.1 cf. 2 Hawk, PC 303 et sec. 27 As 25. 41.2 Palgrave Commonwealth CXXX, CXXXI. 41.1 Butler Sermons Roman 8, Bentham, Theory of Legislation, Principles of Penal Code, Part 2 ch. 16, Hildreth's tr. p. 309. 41.2 General View of the Criminal Law of England, p. 99. 43.1 Wharton Crim, Law 8th ed., Section 8 N1. 43.2 Ibid, Section 7. 43.3 Even the law recognizes that this is a sacrifice, Commonwealth v. Sowen, 2 Pick. Mass. 547, 549. 47.1 cf. 1 East, PC 294, United States v. Holmes, 1 Wall, Jr. 1 Bishop Crim, Law, Sections 347, 349, 845, 6th ed., 4 BL, Com 31. 51.1 Art, 223. 51.2 General View of the Criminal Law of England, p. 116. 53.1 Harris, Criminal Law, p. 13. 53.2 Steff, Dig, Crim, Law Art, 223, Illustrations 6 and N1. 56.1 4 BL, Com, 192. 57.1 cf, 4 BL, Com, 197. 58.1 Reg. V. Hibbert, LR1 CC 184. 59.1 Reg. V. Prince, LR2 CC 154. 59.2 Commonwealth v. Hallett, 103 Mass, 452. 61 Stephen Dig, CR, Law Art, 223 Illuster. 5, Foster 294-295. 62 cf. Gray's case, cited 2 Strange, 774. 63 Steff, Dig Art, 223 Illuster, 1. 64 Steff, Dig Art, 223 Illuster, 8. 65 Rex v. Maston, 6C and P, 396. Cf. Reg. V. Swindoll 2C and K, 230. 66 4 BL, Com, 192. 62 1 Steff, Dig, CR, Law Art, 225. 62 2 Rex v. Shaw, 6C and P, 372. 62 3 Rex v. 1B, 2 Strange, 766, 773. 62 4 Rex v. Hayward, 6C and P, 157. 63 1 Commonwealth v. Walden, 3 Cush, Mass, 558, cf. Steff, Gen. View of the Crim, Law 84. 64 1 2 Bishop Crim, Law, Section 14, 6th ed. 64 2 Glanv, Lib Roman 14, C4. 64 3 Bracht, Fall, 146b. 64 4 Ibid. 64 5 2 East, PC, C21, Section 7 8 pp. 1027, 1031. 6611 Bishop Crim. Law, Section 735, 6th ed. 66-2 Reg. V. Dilworth, 2 Moo and Rob 531. Reg. V. Jones, 9C and P. 258. The statement that a man is presumed to intend the natural consequences of his acts is a mere fiction disguising the true theory. See Lecture Roman 4. 67-1 Reg. V. Taylor, 1F and F 511. 67-2 Reg. V. Roberts, 25 LJ MC 17. SC Dearsley, C. 539. 68-1 Lewis v. The State, 35 Ala. 380. 69-1 C. Empherson's case, Dearsley and Bell, 197, 201, Bramwell b. 69-2 cf. 1 Bishop Crim. Law, Section 741 745 6th ed. 71-1 2 Bishop Crim. Law, Section 758 6th ed. 73-1 cf. Stephen, General View of Criminal Law of England, 49 et sec. 73-2 cf. Stephen, General View, 4952, 2 East, PC 553. 74-1 Rex v. Cabbage, Russ and Rye, 292. 74-2 cf. 4 BL, Com 224, Steph, Dig, Crim, Law Arts, 316, 319. 74-3 cf. 4 BL, Com 227, 228. 75-1 Starkey, CR, PL, 177. This doctrine goes further than my argument requires. For if burglary were dealt with only on the footing of an attempt, the whole crime would have to be complete at the moment of breaking into the house. Cf. Rex v. Furnival, Russ, and Rye, 445. 81-1 See Lecture Roman 7. 82-1 Austin, Jurisprudence 3d ed. 440 et sec. 474, 484 Lect, Roman 20, Roman 24, Roman 25. 84-1 Lib. IC2 ad fin. 85-1 Hist. English Law I 113 bis, NA, id ed. Fin lesson I 178 and 1. Fitzherbert, NB 85 F says that in the Viscountial writ of trespass, which is not returnable into the King's Court, it shall not be said quaere Roman 6 et armes. Cf. Ib. 86 H. 85-2 Milman v. Dalwell 2 Camp. 378, Knapp v. Salisbury 2 Camp, 500, P. v. Walter 6C and P. 232, Hall v. Fearnley 3 QB 919. 85-3 YB 6 ed. Roman 4. 7 PL, 18 AD 1466, cf. Ames, Cases in Tort, 69 for a translation, which has been followed for the most part. 87-1 YB 21 Hen, Roman 7, 27 PL, 5 AD 1506. 87-2 cf. Bracht, Fall, 136b but cf. Stat, of Gloucester 6 ed. I, C9 YB 2 Hen, Roman 4, 18 PL 8 by Thurning, Essays in Ang, Sachs, Law 276. 87-3 Hobart, 134, AD 1616. 87-4 Sir T. Jones, 205, AD 1682. 87-5 Strange, 596, AD 1723. 87-6 Keys, 169, AD 1865. 88-1 Anonymous Crow, Eliz, 10, AD 1582. 88-2 Sir T. Rame, 467, AD 1682. 88-3 Scott v. Shepherd, 2 WM, B1, 892, AD 1773. 88-4 East, 593. See further Coleridge's note to 3BL. Com 123, Saunders Negligence CH. 1 Section 1, Argument in Fletcher v. Rylands 3H and C. 774, 783, Lord Cranworth in SC, LR3HL, 330, 341. 91 XGR. Metropolitan Railway Co. v. Jackson, 3 App, Cass 193. C. M. Manus v. Cricket, 1 East, 106, 108. 9111 LD, Rame, 38 SC Salk, 637 4 Mod 404, AD 1695. 9212 WM, BL, 892, CF, Clark v. Chambers 3 QBD, 327 330 338. 9227 VT, 62. 93-1 Smith v. London and Southwestern Railway Co., LR6 CP 14, 21. CF. SC 5 ID 98, 103, 106. 93-2 Sharp v. Powell, LR7 CP 253. CF. Clark v. Chambers 3Q BD, 327 336 338. Many American cases could be cited which carry the doctrine further, but it is desired to lay down no proposition which admits of controversy, and it is enough for the present purposes that see home fate unloyal act, que apre divinta loyal, CEO est damnum sine injuria. Latch 13. I purposely omit any discussion of the true rule of damages where it is once settled that a wrong has been done. The text regards only the tests by which it is decided whether a wrong has been done. 94-1 Mitchell v. Alestri, 1 Ventris, 295, SC 3 Keb, 650 2 Lev, 172. Compare Hammack v. White, 11 CB. NS 588, Infra P 158. 95-1 Harvey v. Dunlop, Hill and Denio, Laller, 193. 95-2 C. Lecture Roman 2, pp. 54-55. 97-1 CF, Hobart v. Haggett, 3 Fairf, me, 67. 98-1 C. Bonomi v. Backhouse, L. BL, and L. 622 Coleridge, J. at P. 640. 99-1 3 Leverts, 87, AD 1681. 99-2 Compare the rule as to cattle in YB 22 Edwa, Roman 4, 8 PL, 24, stated below, P. 118. 101 Disc, 123 PR, 124 Sections 2, 3. As to the historical origin of the latter rule, compare Lecture V. 101 1 Lecture IPP, 3, 4. 101 2 Lib, IC2 Ad Fin. 101 3 Fall, 155. 101 4 Bro, Trespass PL, 119, Finch 198, 3 BL, Com, 118, 119. 101 5 C. Brunner, Schwergericht, P. 171. 101 6 An example of the year 1195 will be found in Mr. Bigelow's very interesting and valuable Placida Anglo-Normannica, P. 285, citing Rot. Kerr, Regis 38 SC, Aber, Plaque Fall 2 Eber Rot, 5. The suit was by way of appeal, the cause of action a felonious trespass. Cf. Bracht, Fall, 144a. 102-1 An example may be seen in the yearbook, 30 and 31 Edward I. Horwood, P. 106. 103-16 ed., Roman 4, 7 PL, 18. 103-2 Popham, 151. Latch, 13, 119, AD 1605. 104-1 Hobart, 134, AD 1616. 104-2 3 East, 593. 105-1 Bing, 213, AD 1823. 105-2 6 Cush, 292. 106-1 Morris v. Platt, 32 Con, 75-84 at Sec, AD 1864. 106-2 Nitroglycerine case, Parrott v. Wells, 15 Wall, 524, 538. 106-3 Hill and Denio, Laller, 193. Lucy v. Buchanan, 51 NY 476, 489. 107-1 Vincent v. Steinor, 7 VT. 62. See further Clayton, 22 PL. 38. Holt, CJ in Cole v. Turner, 6 Mod 149, Lord Hardwicke in Williams v. Jones, Cass, Temp, Hardwa, 298, Hall v. Fearnley, 8 QB 919, Martin B. in Coward v. Baddeley, 4 H and N. 478, Holmes v. Mather, LR 10X 261, Bizel v. Booker, 16 Arc, 308, Brown v. Collins, 53 NH 442. 107-2, Blyth v. Birmingham Waterworks Co., 11 XXXI. 781, 784, Smith v. London and Southwestern Rye Co., LR5 CP 98, 102, compare Campbell negligence, section 1 2d ed. For Austin's point of view. 109 1 cf. Bro. Caron PL 6, Neal v. Gillett 23 Con, 437 442 D, 925 section 2 D 48, 812. 113 1 I Thorpe P 85, cf. LL, Hen, I C 88 section 3. 113 2 Spofford v. Harlow, 3 Allen, 176. 114 1 C 27 Ass PL, 56 Fall, 141, YB 43 Edwa, Roman 3, 33, PL 38. The plea in the latter case was that the defendant performed the cure as well as he knew how, without this that the horse died for default of his care. The inducement, at least, of this plea seems to deal with negligence as meaning the actual state of the party's mind. 115 1 Hobart, 134. 115 2 C. Knight v. German, Crow, Eliz, 134. Chambers v. Taylor, Crow, Eliz, 900. 115 3 32 Con, 75 89 90. 116 1 YB 12 Hen, Roman 8, 2B PL 2. 116 2 Caleway, 46B. 116 3 LR 3 HL 330, 339. LR 1X 265, 279 to 82, 4H and C. 263, 3 ID 774. 117, 1 C Card V Case, 5 CB 622, 633, 634. 117, 2 C Lecture, IP 23 and N3. 117, 3 Mitten v. Fandry, Popham, 161. SC, 1 Sir W. Jones, 136 SC. Nom. Malen v. Howery, Latch 13, ID 119. In the latter report, at p. 120, after reciting the opinion of the court in accordance with the text, it is said that judgment was given non-obstant for the plaintiff, contrary to the earlier statement in the same book and to Popham and Jones, but the principle was at all events admitted. For the limit, see Reed v. Edwards, 17 C.B. N.S. 245. 118 1 YB 22 Edwa, Roman 4, 8 PL, 24. 118 2 Popham at P 162, SC Latch at P 120 CF, Mason v. Keeling 1 LD, Rame 606 608, but CF, YB 20 Edwa, Roman 4, 10 11 PL, 10. 118 3 Latch at P 120. This is a further illustration of the very practical grounds on which the law of trespass was settled. 118 412 Mod 332, 335, SC 1 LD. Rame 606 608. 118 512 Mod 335, Dyer 25B PL, 162 and Cass. In Marg, 4 Co. Rep. 18B, Buxenden v. Sharp 2 Salk, 662 SC 3 Salk, 169 SC, Nom, Bainteen v. Sharp 1 Lutwa, 90, Smith v. Pella 2 Strange 264, May v. Burdett 9 QB 101, Card v. Case 5 CB 622. 119, 112 Mod 335. C. Andrew Baker's Case, 1 Hale, PC 430. 119 2 Basazi v. Harris, 1 F and F, 92. 119 3 C. Fletcher v. Rylands, LR. IX 265, 281, 282, Cox v. Burbridge 13 CB. NS 430, 441, Reed v. Edwards 17 CB. NS 245, 260, Lee v. Riley 18 CB. NS 722, Ellis v. Loftus Iron Co., LR 10 CP 10, 27 Ass PL 56 Fall, 141 YB 20 Ed, Roman 4, 11 PL 10, 13 Hen, Roman 7, 15 PL 10 Caleway 3B PL 7 CF 4 Kent 12th ed. 110 N1 Ad Fin 121 2 LD Rame 909 13 AM LR 609 122 C Grill v General Iron Screw Collier Co. LR 1 CP 600 612 614 123 Railroad Co. v Lockwood 17 Wall 357 383 121 1 LR 1 CP 300 121 2 C Gorham v Gross 125 Mass 232 239 Bottom 121 3 Minor v Sharon 112 Mass 477 487 122 1 C Winsmore v Greenbank Wills 577 583 Rex v 1B 2 Strange 766 773 Lampley v Brathwaite Hobart 105 107 Wigram Disc PL 249 Evans on Pleading 49 138 139 143 et sec. Id Miller's ed. pp. 147 149 123 1 C Detroit and Milwaukee R. Covey Van Steinberg 17 Mitch 99 120 123 2 in the smallpox case Minor v Sharon 112 Mass 477 while the court ruled with regard to the defendant's conduct as has been mentioned, it held that whether the plaintiff was guilty of contributory negligence in not having vaccinated his children was a question of fact and was properly left to the jury. P. 488. 124 1 Metropolitan Railway Co. v. Jackson, 3 App. Cass. 193 197. 125 1 C. Carney v. London, Brighton and S. Coast Rye. Co. LR 5Q B. 411 414 417. SC 6 id 759. 125 2 Bayan v. Bodle, 2H and C 722. 125 3 C Skinnier v. Loudon, Brighton and S. Coast Rye. Co. 5X 787, but CF. Hammack v. White, 11 CB. NS 588 594. 127 17 American Law Review, 654 et sec. July, 1873. 128 1 Callahan v. Bean, 9 Allen 401. 128 2 Carter v. Town, 98 Mass. 567. 128 3 Lovett v. Salem and South Danvers R. Co., 9 Allen, 557. 128 4 Back v. Stacy, 2 C and P, 465. 128 5 CF. Beadle v. Perry, LR 3 Ec, 465, City of London Brewery Co. v. Termant, LR 9 CH, 212 220, Hackett v. Bayes, LR 20 Ec, 494, Theed v. Debenham, 2 CH, D 165. 135 1 Williamson v. Allison, 2 East, 446. 136 1 Leather v. Simpson, LR 11 Ec, 398 406. On the other hand, the extreme moral view is stated in Weir v. Bell, 3 XD, 238 243. 138 1 As to actual knowledge and intent, see Lecture Roman 2. p. 57. 141 1 CF. Knight v. German Crow, Eliz, 70, SC Ib, 134. 141 2 Mitchell v. Jenkins, 5B and Ad. 588 594. Turner v. Ambler 10 QB 252, 257, 261. 142 1 Redfield, CJ and Barron v. Mason, 31 VT. 189 197. 142 2 Mitchell v. Jenkins, 5B and Ad. 588 595. 143 1 C. Burton v. Fulton, 49 Penn, St. 151. 144 1 Rolfe, B. and Footas v. Willefby, 8 Meeson and Welsby, 540. 145 1 supra, pp. 115 et sec. 147 1 c, e.g., Cooley torts, 164. 147 2 Rex v. Dixon, 3 Mall and Selwyn, 11 15, Reg. v. Hicklin L.R., 3 QB 360, 5 C and P. 266 N. 148 1 Align, 35, Style 72, AD 1648. 149 1 1 Kent, 12th ed., 467 N1, 6 AM. Law Reverend 723 725, 7 ID 652. 149 22 WM. BL. 892 AD 1773, Supra P92, Addison on Torts, 4th ed., 264, citing YB 37 Hen, Roman 6. 37 PL, 26, which hardly sustains the broad language of the text. 151 1 Compare Crouch v. London and N.W. Arco, 14 CB 255, 283 Calais case, 8 Co. Rep 32, Colit, 89 A N7 1 CH, PL, LSD ed., 219 6th ed., 216 217, 7 AM. Law Reverend 656 et sec. 151 2 but cf. The Powishik 2 Lowell, 142. 151 3 Gibson v. Stevens, 8 Howe, 384 398 399 Barnett v. Brandow 6 Man, and Gr. 630 665 Hawkins v. Carty 1 LD, Rame 360. 151 4 Pickering v. Barkley, Style 132, Wedgerstoff v. Keene 1 Strange 214 216 223. Smith v. Kendall, 6 TR 123, 124. 155 1 Card v. Case, 5 CB 622, 634. Cf. Austin 3D ed., 513. 156 1 Rylands v. Fletcher, LR3 HL 330. Supra, P 116. 156 2 C. Marshall v. Wellwood, 38 NJ. 9 Vroom, 339, 2 Thompson, Negligence, 1234 N3. 157 1 Gorham v. Gross, 125 Mass 232. Supra, P 117. 158 1 Mitchell v. Alestri, 1 Vent, 295, SC 3 Keb, 650 2 Lev, 172. Supra, P 94. 158 2 Hammock v. White, 11 CB, NS 588. 166 1 Laband, Vermo Gensrichlichen Klagen, Section 16 pp. 108 et sec. Husler Jewer 487 492. These authors correct the earlier opinion of Bruns R.D. Besitzes, Section 37 pp. 313 et sec, adopted by Sohm and his proc. De Lex Salica, Section 9. Cf. The discussion of sua in writs of trespass, and C in the English law at the end of Lecture Roman 6. Those who wish short accounts in English may consult North Amer. Reverend CX, 210 and C. Id CXVI, 416, Essays in Anglo-Saxon Law pp. 212 et sec. Our knowledge as to the primitive form of action is somewhat meager and dependent on inference. Some of the earliest texts are ed Leoper, 131, Lex Beu, Roman 15, 4, L. Frisian, ad X, L. Vissig, v5, I. Elberg, Roman 49. I2. The Edict of Liutprand, dealing with housebreaking followed by theft of property left in charge of the householder, lays down that the owner shall look to the bailey alone, and the bailey shall hold the thief both for the housebreaking and for the stolen goods. Because, as it says, we cannot raise two claims out of one causa. Somewhat as our law was unable to divide the severing a thing from the realty, and the conversion of it into two different wrongs. Compare, further Jones, Baum. 112, Exodus Roman 22, 1012, LL, Alfred 28, I Thorpe Anc, L. P. 51, Gai Inst, Roman 3, Sections 200-2207. 167 1 Roman 31, 16. 168 1, Peterit enim rem suum Peter ut adoretum per testimonium proborum hominum, et sic consequi rem suum quam via furitam. Et non refert utrum res quaeta subtracta fuit extiterit alias appellantes propria vel alterius, dum tamen de custodia sua. Bracht, Fall, 150b 151, Britain Nish, ed. I 5960 de Larsens, cf. Ib. 67, Fleta Fall. 5 ILI, C38 Section 1. 169 1 YB 21 and 22 ed. I 466 468 noticed in North Amer. Reverend CXVI, 421 N. So Britain C. Il Puce of Virir la Pert. This is not Trover. The declaration in Detenu per inventionem was called Un Newfound Halliday in YB 33 Hen. Roman 6, 26 27 cf. 7 Hen. Roman 6, 22 PL, 3. Isaac V. Clark I. Roll R. 126 128. 169 2 YB 2 ed. Roman 4, 4 5 PL 9 21 Hen. Roman 7, 39 PL, 49, Bro Trespass PL, 216 295. 169 32 WMS. Sond, 47 N1, see above P 167. 171 Notes to Saunders, Wilbraham v. Snow, Note H. 172 YB 11 Hen. Roman 4, 23 24. See further YB 8 ed. Roman 4, 6 PL, 5 9 ed. Roman 4, 34 PL 9 3 Hen. Roman 7, 4 PL 16 20 Hen. Roman 7 1 PL 1 21 Hen. Roman 7, 14 B PL, 23 13 Co Rep 69 1 Roll. Aber 4 I PL. I FNB 86, N a Supra, P 167. 173 Fitz. Aber. Bar PL, 130 YB 9 ed. Roman 4, 34 PL 9, 12 AM, Law Reverend 694. 171 1 2 Steph. Com. 6th ed. 83 Cited Dicey Parties 353 2 BL. Com 453 2 Kent 585. As the bailee recovered the whole value of the goods, the old reason that he was answerable over has in some cases become a new rule, seemingly based on a misunderstanding, that the bailee is a trustee for the bailor as to the excess over his own damage. Cf. Lyle v. Barker, 5 Bin. 457 460, 7 Cohen, 68 LN, White v. Webb, 15 Con, 302 305, in the order cited. Thence the new rule has been extended to insurance recovered by a bailee. 1 Hall NY 84 91 3 Kent's Com. 12th ed. 371 376 N1. In this form it ceases to be a reason for allowing the action. 171 2 YB 48 ed. Roman 3, 20 PL 8 Bro Trespass PL 67 CF 1 Britain Nish ed. 67 YB 6 Hen. Vi 1, 12 PL 9 12 ed. Roman 4, 13 PL 9 12 AM. Law Reverend 694. 172 1 YB 22 ed. Roman 4, 5 PL 16. 172 22 Roll Aber. 569 Trespass 5 CF. YB 20 Hen. Roman 7, 5 PL 15 21 Hen. Roman 7, 39 PL 49 Clayton 135 PL 243 2 WMS Sond 47E 3D ed. 172 3 Bro Trespass PL 67 in Marg. CF ed. Leupper 131 Cited Supra P 166 N. 172 4 in one instance, where, against the opinion of Bryan, the bailor was allowed to sue for damage to the chattel by a stranger, the action seems to have been case. YB 12 ed. Roman 4, 13 PL, 9 CF, the margin of the report. 173 1 Gordon v. Harper, 7 TR9, Lord v. Price, L. Il 9 X54, Mugridge v. Eveleth 9 Met, 233. CF. Clayton 135 PL 243. 173 2 Nichols v. Bastard 2 CM and R 659 660 Manders v. Williams 4X 339 343 344 Morgan v. Ide 8 Cush 420 Strong v. Adams 30 VT 221 223, little v foseft 34 me, 545. 173 32 camp, 464, cf. Mears v London and Southwestern Railway Co., 11 cb. NS 849, 854. 173 4 Addison, Torts 4th ed., 364. 174 1 WMS, Pers, Prop 26 5th ed., 27 7th ed. 174 2 Booth v Wilson, IB and Ald. 59 YB 48 ed., Roman 3. 20 PL 8, 11 hen Roman 4. 17 PL 39, 11 hen Roman 4. 23 24 PL 46 tree. U de prompter, 21 hen Roman 7. 14 B PL 23 Godbolt 173 PL 239 Sutton v Buck 2 taunt. 302 309 Burton v Hughes 2 Bing. 173 Nichols v Bastard 2 CM and R 659 660 Manders v Williams 4 Ext. 339 343 344 2 WMS. Sond. Note to Wilbraham v Snow 2 Kent 585 568 574 Morin v Portland SP Co. 35 me. 55 See further lecture Roman 6 Adfin. 175 1 CF. Lord V. Price, LR 9X 54 56 Supra, P 172. 175 2 Supra, P 167. 175 3 Lib XC 13 CF, I C 8. 175 4 Is qui rem commodatum excepit, ad ipsum restituendum tenetur, vel adjus presium, si forte incendio, ruins naufragio ant latronum, vel hostium incursu, consumpta furit vel deperdita, substrax vel oblata. Fall. 99a b This has been thought a corrupt text, Guterbach Bracton by Cox P 175, 2 twists Bract. Int. Roman 28. But agrees with Glanville, Supra, and with Fleta L. Roman 2. C 56, section 5. 175 5 Bract, Fall. 62b C 28 section 2 Fleta L Roman 2 E 59 section 4 Fall 128 cf just inst 324 section 5 ib 15 section 2 176 1 YB 8 ed Roman 2 275 Fitz Detenu PL 59 176 22 LD Rame 909 176 3 YB 13 ed. Roman 4. 9 PL 5 C lecture Roman 6. 176 429 As 163 PL 28. 176 5 CF. Ratcliffe v. Davis, Yelv, 178, Crow, Jack, 244, Noy 137 1 Bolster. 29. 176 6 YB 33 Hen. Roman 6. 1 PL. 3 This case is cited and largely relied on in Woodlife's case, Infra. Southcote v. Bennett, Infra Pickering v. Barclay, Style 132, 24 Car. I. Covenant on a Charter Party, and Morse v. Slew, Infra, in short, in all the leading cases on bailment. 177 1 CF. Abbreviatio Pleitorum, P 343, Call 2, Rot, 87 17 ed. 2. 178 1 YB 9 ed. Roman 4. 34 PL 9 2 ed. Roman 4. 15 PL 7. It is proper to add that in the latter case Littleton does not seem to distinguish between servants and bailees. 178 2 YB 9 ed. Roman 4 40 PL 22, so Brian in 20 ed. Roman 4. 11 PL 10 adfin. 178 3 YB 10 hen, Roman 7, 25 26 PL 3. 178 4 CF. L Bayou, Roman 15, 5 YB 33 hen, Roman 6, 1 PL 3. 178 5 YB 6 hen, Roman 7, 12 PL 9, Bro, Detenu PL 37, 10 hen Roman 6, 21 PL 69. 178 6 YB 3 hen, Roman 7, 4 PL 16, cf. 10 hen, Roman 6, 21 PL 69. 178 7 YB 11 hen, Roman 4, 23 24 6 hen, Roman 7, 12 PL 9. 178 8 Crow. Eliz, 815, 4 Co Rep 83b, Co Lit 89, 2 by Com 452. 181 Savile, 133 134. Cf. Bro, Akian sur la case PL, 103 Dyer 161 a B. 182 Nugent v. Smith, 1 CPD 19, Brett, J. at P 28. 183 Nugent v. Smith, 1 CPD 423, Cockburn, CJ, at P 428. 181 One more, 462, Owen, 57. 181 2 Dial, 2 CH, 38 AD 1530. 182 1 Caleway 160 PL, 2 2 Hen, Roman 8, CF, Ib, 77b, 21 Hen Roman 7. 182 2 YB 33 Hen, Roman 6, 1 PL 3. 182 34 Co Rep 83b, Crow, Eliz, 815. 183 1 Caleway 160 PL, 2. 183 2 YB 19 Hen, Roman 6, 49 Adfin, CF, Mulgrave v. Ogden Crow Eliz, 219, SC Owen 141 1 Leon, 224 with Isaac v. Clark 2 Bolster, 306 at P 312 Coke J. 183 3 C Lecture Roman 7. 184 1 Paston J in YB 19 Hen, Roman 6, 49. See also Rogers v. Head Crow Jack 262, Rich v. Nealand Crow Jack 330, which will be mentioned again. An innkeeper must be a common innkeeper YB 11 Hen Roman 4, 45. See further 3BL, Com 165, where the transition from status to contract will be found to have taken place. 184 2 FNB 94D, Infra P 203. 184 3 YB 7 Hen, Roman 4, 14 12 ed, Roman 4, 13 PL 9 10 Dyer 22b. 184 4 The process may be traced by reading, in the following order: YB 2 Hen, Roman 7, 11 Caleway 77b Adfin, 21 Hen Roman 7. Ib 160 PL 2 2 Hen Roman 8. Drake v. Royman Savile 133 134 36 Eliz. Mosley v. Fawcett Moore 543 40 Eliz. 1 Roll, Aber. 4 FPL 5 Rich v. Nealand Crow, Jack. 330 11 Jack I. 185 1 Crow, Jack. 262 8 Jack I. Compare Maynard's argument in Williams v. Hyde Palmer 548, Simmons v. Darknall Ib. 523 and other cases below. 1 Roll, Aber. 4 FPL 3 Mosley v. Fawcett Moore 543 40 Eliz. An obscurely reported case seems to have been a sumpsit against an aegester for a horse stolen while in his charge, and asserts Obiter that, without such special assumpsit, the action does not lie. This must have reference to the form of the action, as the judges who decided Southcote's case took part in the decision. See, further, Evans v. Yeoman, Clayton, 33. 186 1 C. Simmons v. Darknall, and the second count in Morse v. Slew Infra. The latter case shows the averment of negligence to have been mere form. Cf. I. Salk, 18, top. 187 1 Supra, p. 179. 187 2 Boson v. Sanford, Shower, 101. Coggs v. Bernard, Infra. 187 3 Simmons v. Darknall, Infra. 188 1 Reg. Brev 92b, 95a, 98a, 100b, 104a, cf. YB 19 ed. Roman 2, 624 30 ed. Roman 3, 25 26 2 Hen, Roman 4, 18 PL 6, 22 Hen, Roman 6, 21 PL 38 32 and 33 ed. I. Int. Roman 33. Brunner, Schwergericht 177, id Franzisisch in Haberpapier 9 N1. 188 212, Co Rep 64. 188 3c, besides the following cases, the declaration in Chamberlain v. Cook, 2 Ventris, 75 1W and M, and note especially the variations of statement in Morse v. Slew, set forth below in the text. 189 1 Hobart 17, Crow, Jack, 330 see also George v. Wyburn 1 Roll, Aber, 6 PL 4 AD, 1638. 191. The use which has been made of this case in later times shows the extreme difficulty in distinguishing between principles of substantive law and rules relating only to procedure in the older books. 192 YB 22 Hen, Roman 6, 21 PL 38, Supra P 188 N1. 190 1 Palmer, 523. 190 2 Palmer, 548. 191 3 Align, 93. 190 4 Sid, 36. 192 1 Sid, 244, cf. Dalston v. Jansen 1 LD, Rame, 58. 192 2 Keb, 866, 3 Id 72 112 135, 2 Lev, 69, I Vent, 190 238 1 Mod 85, Sir T. Rame, 220. 193 2 Keb, 866, C3 Keb, 74 1 Mod 85, Sir T. Rame, 220. 193 2 Keb, 72. 193 3 YB 33 Hen, Roman 6, 1, Supra P 177. 193 3 Keble, 73. This is the main point mentioned by Sir T., Raymond and Levens. 193 5 CF, 1 Mod 85. 194 1 Ventris, 238, citing Southcote's case in the margin. CF, 3 Keble, 135. 194 2 Align, 93. Supra, P 191. 194 3 see also 1 Hale, PC 512, 513. 195 1 King v. Viscount Hertford, 2 Shower 172 PL, 164, cf. Woodlife's case, Supra. 195 2 Boson v. Sanford, 1 Shower 101 2 W and M, see above pp. 180 3185, below p. 197. Modern illustrations of the doctrine will be found in Fleming v. Manchester, Sheffield and Lincolnshire Railway Co., 4 QBD. 81 and cases cited. In Borman v. Brown, 3 QB 511, 526, the reader the primitive assumpsit, which was the inducement to a declaration in tort, interpreted as meaning contract in the modern sense. It will be seen directly that Lord Holt took a different view. Note the mode of dealing with the Marshall's case, 33 Hen, Roman 6. 1 in a line, 27. 196 1 C. Lovett v. Hobbs, 2 Shower 127 32 Car. Roman 2. Chamberlain v. Cook 2 Ventris 75 1 W and M. Boson v. Sanford 1 Shower 101 citing Southcote's case 2 W and M. Upshare v. 80 1 Cummins 25 8 W Roman 3. Middleton v. Fowler I. Salk 288 10 W Roman 3. 196 2 12 Mod 472. 196 32 LD. Rame 909. 197 1 Pautuary v. Walton 1 Roll, Aber, 10 PL 539 Eliz, cf. Caleway 160. 197 2 LD. Rame 919 C. Lecture Roman 7. How little Lord Holt meant to adopt the modern view, that delivery, being a detriment to the owner, was a consideration, may be further seen by examining the cases put and agreed to by him from the yearbooks. 199 1 2 Kent, 598, 1 CPD 429. 199 2 Palmer, 523. C2 Caleway, 77B and 160 PL. 2. Where the encroachment of case on detinue and the corresponding confusion in principle may be pretty clearly seen taking place. But CP 175, Supra. 201 2 Kent, 597, Forward v. Pittard, 1 tr 27. 202 cf. YB 7 hen, Roman 4. 14 2 hen, Roman 7. 11 Caleway 77b 160 pl. 2 and other cases already cited. 203 YB 41 ed. Roman 3. 3 pl 8. 204 YB 33 hen. Ye 1 pl 3. 205 Reg. Brev 107 a 108a 110 a b. Entries cited 1 tr 29. 206 c above pp. 167 175 et sec. 12 am. Law Reverend 692 693 YB. 42 ed. Roman 3. 11 pl. 13 42 as pl. 17. 201 11 Wilson 282 cf. 2 Kent 12th ed. 596 and 1b. 201 2 YB 33 hen. Roman 6. 1 pl 3. 202 1 Mouse's case. 12 co rep 63. 202 2 Bird v. Estcock 2 Bolster. 280 cf. Dyer 33 a pl. 10 Keithley's case. 10 co rep 139b 140. 202 3 YB 40 ed. Roman 3. 5 6 pl 11. See also Willems v. Hyde Palmer 548 Shep. Touched 173. 203 1 C Safe Delcaset Company of Pittsburgh v. Pollock 85 Penn. 391. 203 2 Paston J in YB 21 hen. Roman 6. 55. Caleway 50 a pl 4 Harders 163. 203 3 Lane v. Cotton 1 ld. Rame 646 654 1 Salk 18 12 Mod 484. 204 1 Forward v. Pittard 1 tr 27 83. 205 1 Printing and Numerical Registering Co v. Sampson LR 19 ec. 462 465. 207 1 Possession Section 6 Eng tr pp. 27 28. 207 2 rd Besitzes 487. 208 1 rd Besitzes 490 491. 208 2 Bruns rd Besitzes 415 Windshade Pand. Section 148 n. 6. Further Hegelian discourse may be found in Dr. J. Hutchison Sterling's lectures on the philosophy of law. 208 3 Institutionen, sections 224 226, Windshade Pand. Section 148 n6. 208 4 Windshade Pand. Section 148 n6. 208 5 Besitzgleichen, 276 279. 209 1 Bruns, rd Besitzes 499. 209 2 Bruns, rd Besitzes, section 2 pp. 5 et sec. Puchta Besitz in Weisk Rechtslex, Windshade Pand. Section 154 pp. 461 et sec. 4th ed. 209 3d 4123, section 20, 1368 and 9. Cf. D 4119, section 5. 210 1 but C. Ihering, Geist D. Ram R, section 62 French tr, Roman 4. p. 51. 210 2 Husler thinks this merely a result of the English formalism and narrowness in their interpretation of the word suo in the writ Decesivit de tuamento suo. Jewer, 429 432. But there was no such narrowness in dealing with catala sua and trespass. See below, p. 242. 210 3c, further Bracton Fall, 413, YB 6 hen, Roman 7, 9, pl 4. 211 1 infra, p. 243. 211 2 rd Besitzes, 494. 212 1 Rogers v. Spence, 13 m and w 579, 581. 212 2 Webb v. Fox, 7 tr 391, 397. 212 3 Fennings v. Lord Grenville, 1 taunt. 241 Littledale v. Skaith, Ib. 243 N.A., cf. Hogarth v. Jackson, M. and M. 58, Skinner v. Chapman, Ib. 59 N. 212, 4 Swift v. Gifford, 2 Lowell, 110. 212, 5 1 Taunt, 248. 213, 1 cf. Wake, Evolution of Morality, Part 1, ch. 4 pp. 296 et sec. 215, 1 Asher v. Whitlock, LR 1 QB1. 215, 2 People v. Shearer, 30 Cal. 645. 217, 1 2 Kent's Com. 349, citing Pearson v. Post, 3 Keynes, N.Y. 175, Buster v. Newkirk, 20 Johnson, N.Y. 75. 217, 2 Young v. Hitchens, 6 QB 606. 217, 3 2 Kent's Com. 349, N.D. 218, 1 Inst. 2 1, Section 13. 218, 2 Swift v. Gifford, 2 Lowell, 110. 218, 3 Savigny, R. D. Besitzes, Section 21. 218, 4 Roman 2. 9, Section 4, Roman 3. 29, Section 2. Animus domini will be used here as shortly indicating the general nature of the intent required even by those who deny the fitness of the expression, and especially because Savigny's opinion is that which has been adopted by English writers. 219, 1 cf. Bruns, R. D. Besitzes, 413, and Ib. 469, 474, 493, 494, 505, Windshade, Pand. Section 149, N5, p. 447, 4th ed. Puchta, Inst. Section 226. 219, 2 Supra, p. 207, 2 Puchta, Inst. Section 226, 5th ed. pp. 545, 546. 221, 115 Jur. 1079, 21 LJ QB 75, 7 Eng, L and Ek, 424. 222, 111 Allen, 548. 223, 1 Kincaid v. Eaton, 98 Mass 139. 223, 2 Barker v. Bates, 13 Pick. 255, 257, 261. Proctor v. Adams, 113 Mass 376, 377, 1 BL. Com. 297 Sharswa, ed. N14. Cf. Blades v. Hicks, 13 CB. NS 844, 847, 848, 850, 851, 11 HLC. 621, Smith v. Smith, Strange, 955. 223 3 Reg. V. Bell, CC 93. 224 1C, as to treasure hidden in another's land, D41, 244 PR. D10, 415. Note the different opinions in D40 123, Section 3. 224 23 Inst. 107, 1 Hale, PC 504 505, 2 Bishop, Crim. Law Sections 834, 860, 6th ed. 224 3 Reg. V. Middleton, LR2 CC 3855. Cf. Halliday v. Hallgate, LR3 X 299, 302. 224 4 CF. YB 8 ed. Roman 2, 275, Fitz, Aber. Detenu PH 59, YB 13 ed. Roman 4. 9 PL 5 Caleway 160 PL 2 Mary v. Green 7 M and W 623 630. It may not be necessary to go quite so far, however, and these cases are not relied on as establishing the theory. For wrong explanations, see 2 East, PC 696. 225 1 Durfee v. Jones 11 RI 588. 225 2 Reg. V. Bell, CC 93, stated above. 225 3 8 Vess, 405, 7 M and W 623, Stephen, Crim, Law, Art, 281 ill. 4, P 197, he says, because cannot be presumed to intend to act as the owner of it when he discovers it, a reason drawn from Savigny, but not fitted to the English law, as has been shown. 226 1 YB 13 ed. Roman 4, 9 10 PL 5, 21 hen, Roman 7, 14 PL 21, CF 3 hen, Roman 7, 12 PL 9, Steph. Crim, Law, Art, 297 and App Note 17. 226 2 Steph. CR Tree, Law, Art, 297 and App Note Roman 17. P 882, it may be doubted whether the old law would have sanctioned the rule in this form. FNB 91E, YB 2 ed., Roman 4, 15, PL 7. 226 3 YB 21 hen, Roman 7, 14, PL 21, 13 Co Rep 69. 227 1 they have been said to be a part of the family pro Hackvice. Southcote v. Stanley, 1H and N 247, 250. Cf. YB 2 hen, Roman 4, 18, PL 6. 227 2 more, 248 PL. 392, SC Owen 52, FNB 91E, 2B1 Com. 396 1 HBL. 81 84 1 Chitty PL, 171st ed. Dicey Parties 358 9 Mass. 104 7 Cohen 294 3S and R20, 13 Iredell 18, 6 Barb. 362 and cases cited. Some of the American cases have been denied on the ground that the custodian was not a servant. Cf. Holiday v. Hicks Crow, Eliz, 638, 661, 746, Drope v. Thayar, Popham, 178, 179. 228 1 Bracton Fall. 6 a Section 312 a 17 a Cap. V. Ad Fin 25 a B, etc. Puckbra Inst. Section 228. 228 2 see also 7 a.m. Law Reverend 62 et sec. 10 a.m. Law Reverend 431, 2 Kent Com. 12th ed. 260 N1. 228 3 1 Com. 427. Cf. Preface to Paleon Agency. Factors are always called servants in the old books, see e.g. Woodlife's case Owen 57 Holiday v. Hicks Crow, Eliz, 638, Southcote's case 4 Co Rep 83b 84 a Southern v. Howe Crow, Jack, 468, St. 21 Jack. I. C16, Section 3, Morse v. Slew, 3 Keble 72. As to bailiffs, see Bract. 26b, Restituat Domino vel servienti, etc. YB 7 hen, Roman 4, 14, PL 18. 229 1 Paley, Agency, C4, Section 1, citing Godbolt 360. See further FNB 120G, Fitz, Aber, Det PL 3, YB 8 ed, Roman 4. 11, PL 9. These rules seem to be somewhat modern even as to servants. The liability of a master for debts contracted by his servant is very narrowly limited in the earlier yearbooks. 231 I am inclined to think that this extension has been largely due to the influence of the Roman law. See lecture IP 20 N1 and observe the part which the precedents as to fire e.g. YB 2 hen, Roman 4, 18 PL 6 have played in shaping the modern doctrine of master and servant. Tuberville v. Stamp, ILD. Rame. 264, where Lord Holt's examples are from the Roman law, Brucker v. Framont, 6 TR 659, M. Manus v. Cricket 1 East 106, Patton v. Rhea 2 CB, NS 606. In Southern v. Howe, Popham 143, doctor and student is referred to for the general principles of liability. Doctor and student states Roman law. See further Bosson v. Sanford, 1 Shower 101 102. 232 back. R. Master and Servant K. Smith Master and Servant 3D ed. 260 NT. 233 Clapp v. Kemp 122 Mass 481. Murray v. Curry LR 6 CP. 2428. Hill v. Maury 26 VT. 178. 234 C, e.g., Patton v. Rhea 2 CB. NS 606. Bolingbroke v. Swindon Local Board, LR 9 CP 575. 235 Freeman v. Rosher, 13 QB 780, 785, Gauntlet v. King, 3 CB. NS 59, Haisler v. Lemon, 28 LJCP 103, Collett v. Foster, 2H and N 356, Barwick v. English Joint Stock Bank, LR. 2X 259, 265, 266, Lucas v. Mason, LR 10X 251, 253. Last paragraph, Mackay v. Commercial Bank of New Brunswick, LR 5PC, 394, 411, 412, so as to partners 3 Kent's Com. 12th ed. 46, notes D and 1. 230, 1 Bush v. Steinman, 1B and P 404, 409. 230, 126M and W 358. Cf. Udell v. Atherton, 7H and N 172, 184, for a comment like that in the text. Other grounds for the decision are immaterial here. 230, 13 Mackay v. Commercial Bank of New Brunswick, LR 5PC, 394, Barwick v. English Joint Stock Bank, LR 2X 259, Western Bank of Scotland v. Addy, LR 1HLSC, 145, 2 Kent, 12th ed. 616, N1, Swift v. Jewsbury, LR 9 QB 301, overruling SC. Subnom. Swift v. Winterbotham, LR 8 QB 244, Weir v. Bell, 3XD 238, 244. The objections which Baron Bramwell mentions, LR 9 QB 815, to holding one man liable for the frauds of another, are objections to the peculiar consequences attaching to the relation of master and servant in general, and have been urged in that more general form by the same learned judge. 12 A.M. Law Reverend 197, 200, 2H and N 856, 361. C 7 A.M., Law Reverend 61, 62. 230, 137 A.M., Law Reverend 63, Oct. 1872. 232, 1D 44. 24, Note 17, Elsevier ed. 232, 2 Hunter's Roman Law, 431. 232, 3 Ancient Hist. Of Inst. 235. 232, 4 cf. Gillett v. Ball, 9 Pen. St. 13, Craig v. Gilbreth, 47 Me, 416, Nicholson v. Knowles, 5 Maddock, 47, Williams v. Port, L.R. 12 Eck, 149, Adams v. Jones, 12 Ad, and L. 455, Bracton, Fall, 28B, 42B, 43. And compare with the passage cited above from Blackstone, Possitor, Cujus Reamine Possitor, Procurator Alieni Possessioni Praestet Ministerium. D. 41, 218, PR. 233, 1 Ward v. Macaulay, 4 TR 489, 490. Cf. As to factors supra, P. 228. 233, 2 Bernson v. Strang, LR 3CH. 588, 590. 233, 3 Blackburn, Sale, 33, Marvin v. Wallis, 6L and BL. 726. 233, 4D 41. 218, PR. Quod meo nomen possideo, possum alieno nomen possidir, nec enim muto mihi cossum possessionis, sed dizino possidir et alium possessorum ministerio meo facio. Nec idem est possidir et alieno nomen possidir, nam possidit, cujus nomen possitor, procurator alieni possessioni praestet ministerium. Thus showing that the vendor changed possession by holding in the name of the purchaser as his agent to possess. Cf. Bracton Fall, 28b. 233, 4 Windshade, Pand. Section 155, N8 a 2 Kent, 12th ed. 492, N1a. It should be kept in mind also that the Roman law denied possession to bailees. 234, 1c, e.g., Farina v. Home, 16M and W 119, 123. 235, 1 McGahey v. Moore, 3 Ired, NC 35. 235, 2 Reader v. Moody, 3 Jones, NC 372. Cf. Bassett v. Maynard, Crow, Eliz, 819, 820. 235, 3 Brown v. Dawson, 12A and E 624. Cf. D 43. 1617, Ib. 3 Section 9 D 41, 218 Section 3, Clayton 147 PL, 268. 236 1 cf. Bruns, R.D. Besitzes 503. 237 1 Clark v. Maloney, 3 Harrington Dell, 68. Bruns, R.D. Besitzes 503, 507 comes to the same conclusion on practical grounds of convenience, although he utterly repudiates it on theory. I must refer to what I said above touching these conflicts between theory and convenience. 238 1 Bruns, R.D. Besitzes, Section 57, p. 486. A learned writer of more ancient date asks why a doctor has not a possessory action if you cease to employ him, and answers, Sentio actionem non tenor, sed sentio tantum, nec si vel mort minoris possum dicerquare. Tu lector si sapis rations decidendi suger. Hamel, Raps. 489, cited Bruns 407. 239 1 Gardiner v. Thibodeau, 14 Law, and 732. 239 2 Bruns, 483. 241 2 Kent, 12th ed., 205 N1, cf. YB 21 Hen, Roman 6, 8 9 PL, 19, American Note to Scott v. Shepard in 1 SM, LC AM ed. 242 Britton Nish, ed. I 277 cf. Bracht, Fall, 164b, Fleta Fall, 214, Glanv, Lib, Roman 13, C37, Littleton, sections 237-240, 588, 589, 3BL, Com, 170, 3 Cruz, Dig, Tit, Roman 28, Rents, ch. 2, section 34. 240, 1 C XXXI. 240 2 cf. Stockport Water Works v. Potter, 3H and C 300, 318, the language in the 7th English edition of 1 SM, LC 300, is rather too broad. If the law should protect a possessor of land in the enjoyment of water coming to it, it would do so because the use of the water was regarded as a part of the enjoyment of that land, and would by no means imply that it would do the same in the case just put of away over land of another. 242 1 Jeffreys v. Great Western Railway Co., 5L and B1. 802 cf. Armory v. Delamory, 1 Strange, 505 1 SM, LC. 242 2 Colit, 145b. 242 32 WMS. Sond, 47b Note 1 to Wilbraham v. Snow. 242 4 Bracht, Fall, 150b 151, Supra, p 168, YB 22 ed. I 466-468. 242 5 YB 48 ed. Roman 3, 20, 11 Hen, Roman 4, 17, 11 Hen, Roman 4, 23 24 21 Hen, Roman 7, 14. The meaning of sua is discussed in YB 10 ed. Roman 4 1b by Catesby. Compare Laband Vermogensrichlichen Klagen 111, Husler Jewer 492 et sec, correcting Bruns R.D., Besitzes 300 et sec. Sohm, Proc. D.L. Sal, Section 6. 243 1 YB 11 Hen, Roman 4, 17 PL 39. 243 2 YB 21 Hen, Roman 7, 14b PL 23. 243 3 Godbolt 173 PL 239 cf 11 Hen, Roman 4, 17 PL 39. 243 4 Bro, Aber, Trespass PL 433 Sit, YB 13 Hen, Roman 7, 10. 243 5 Kelling 89. See further Buller NP 33. 243 6 Lecture V, YB 20 Hen, Roman 7, 1 PL 11. 243 7 YB 21 Leon, Roman 7, 14b PL 23. 243 8 1 Roll, Aber, 4 5 I PL 1 CF, Arnold v. Jefferson 1 LD, Rame 275. 244 129 Ass Fall, 163 PL 28. 244 2 Southcote's Case, 4 Co. Rep. 83b. 244 3 Mores v. Canam, Owen, 123, cf. Ratcliffe v. Davis, I. Bolster, 29. 244 4 Doe v. Dyball, Mood, and M. 346 and Note, 2 WMS. Sond, 111 and later notes, I. Add and L. 119, Asher v. Whitlock, LR 1Q, B. 1. 244 5 Graham v. Pete, 1 East, 244. 245 1 As to this period see Husler, Gewer, cf. Laveli Propriet, 166. 248 1 2 Hist, Du Droit Frank, pp. 146 et sec. 152. 248 2 Anciens Poets de la France, Gessard, p. 71. 248 3 page 283, cf. 284 cxvi et sec. 44 Elzix. 249 1 Somme, Proc, Delex. Sal, sections 15 23-25 tr. The Venin, pp. 80 105 122. 249 2 Essays in A.S. Law, p. 292. 249 3 Cap, Roman 8, Merkel, p. 48. 249 4 Cap, lxxiv. Section 3, Essays in A.S. Law, p. 291. 249 5 Chapter Roman 4, Section 16. 251 Fitz, Aber, Main Prize PL, 12 H33 ed., Roman 3, Stondford, PC 65. 252 Aber, Plaque, P 343 Call 2 Rot, 37 17 ed., Roman 2. 253 Jacob, LD Bale, cf. I. Bolster, 45 Hawkins, PC Roman 2 ch. 15 Section 83 Aber, Plaque, P 343 Call 2 Rot, 37 17 ed. 2. 254 Highmore Bale, P 199 Jacob, LD Bale, cf. 2 Laferriere Hist, Du Droit Frank, P 148. 255 Highmore, P 195. 256 Ibid, p. 200. 252 1 Vermo Gensrichlichen Klagen. 253 1 Roman 2, c. 60, section 25, Glanville's Justa Debendi Causa, Lib X, c. 4 seems remote from consideration. 254 1 YB3 Hen, Roman 6, 36. 254 2 YB 37 Hen, Roman 6, 13, PL 3. 254 3 YB 37 Hen, Roman 6, 8, PL 33. 254 4 Glanv, Lib XC12, Bract Fall, 400B, Section 10, 22 Ass, PL 70 Fall, 101. 255 1 Essays in A.S. Law, 187. 256 1 I-45, Roman 3, 10. 256 2 Lib XE17. Suit, secta, was the term applied to the persons whose oath the party tendered. 257 1 Lib XC12, Beams P 262, C8 and C5 Beams PP 256 251, cf. Roman 4, C6 where witnesses are tendered divisuet auditu. Cf. Bract 315b, Section 6 Fleta Roman 2, C63 Section 10p, 137. It was no doubt true, as Glanville says Lib XC17, that the usual mode of proof was by a writing or by duel, and that the King's Court did not generally give protection to private agreements made anywhere except in the court of the king, Lib X, C. 8. But it can hardly be that debts were never established by witness in his time, in view of the continuous evidence from Bracton onwards. 257 2, but cf. Brunner, Schwergericht, 399. I do not go so far as to say that they were still a living institution. However that may be, tradition must at least have modeled itself on what had been the function of the former official body. 257 3 Bract, Fall, 315b, Section 6, Brit, Nish, IP 162 Magna Charta C38, YB 21 ed., I 456 7 ed., Roman 2, 242 18 ed., Roman 2, 582 3BL, com. 295 344, cf. 17 ed. Roman 3, 48b. 257 4 cf. Glanv, Lib Roman 4, c6. 258 1 Lib X c18. It is possible that this means no more than Glanville's often repeated statement that the King's Court did not, generally speaking, take cognizance of private agreements. The substantive law was, perhaps, still limited by traditions from the infancy of contract. CPP. 248, 251, 259, 260. The proposition in its broadest form may have been based on the inability to try such agreements in any way but those which have been specified. Cf. The requirement of alium durationationum and aliis probationibus in Lib XC12, but cf. Ibid, with essays in A.S. Law pp. 189, 190. 259 1 Sherrington v. Straught, Plowden, 298 at p. 302, m. 7 and 8 Eliz. 259 2 Pillins v. Van Meerop, 3 Borough, 1663, 1669. 261 1 Thorpe Anc Laws 181 Oaths 7 8. 262 Glanv, Lib XC5, Beams p. 251, YB 7 ed. Roman 2, 242 Nova Nar. Detvers Plege Rassel's Law Tracts p. 253 d. 2 Finnel, Reeves 376. 261 1 Glanv, Lib XC22 Beams p. 263, Bract, Fall, 398 by Section 1. The favorite proof by duel was also allowed, but this disappeared. When the inquest became general, the execution of the deed was tried, like any other fact, by that means. 261 2 Bract, Fall, 315b, Section 6, 400b, Coke 2d inst, 4445. 262 1 Glanv, Lib XC12 Beams p. 263, Bract, Fall, 100b Section 9. 262 2 Glanv, Lib XC17 Beams p. 272. 262 3 Bract, Fall, 400b Section 9. 262 4 cf. YB 20 ed. I 304 and 34 ed. Roman 2, 150 152, Ib 330 332, 35 ed. I 546. 263 1 Bract, Fall, 400b Section 8. 263 2 cf. YB 20 ed. I 304. 263 3 Cap, 28, 32 and 33 ed. I 516, 18 ed. Roman 2, 582, Fleta Roman 2. C 63 Section 9 Coke 2d inst, 44 3BL, com. 344. 263 4 YB 18 ed. Roman 2, 582, 17 ed. Roman 3, 48b PL 14. 264 1 YB 29 ed. Roman 3, 25 26 cf. 48 ed. Roman 3, 6 PL 11 Fleta Roman 2. C60 Section 25 Glanville Lib XC12. 264 2 cf. Bro, Ac, Sur la Case PL 5, SC 27 Hen, Roman 8, 24 25 PL 3. 264 3 YB 18 ed. Roman 3, 13 PL 7. 264 4 YB 44 ed. Roman 3, 21 PL 23. 264 5 FNB 122, I in margin. CF. FNB 122 K YB 43 ed. Roman 3. 11 PL 1 SC Bro, Pledges PL 3 9 Hen, V14 PL 23. 265 1 YB 17 ed. Roman 3, 48b PL 14. CF. Fortescue Amos 67 N, 3 BL, com. 295. 265 2 for limit C constit. Of Clarendon C15, Glanv, Lib X, C8 12 YB 22 As PL 70 Fall, 101 45 ed. Roman 3, 24 PL 30 19 R Roman 2, Fitz, aber, det pl. 166 37 hen, Roman 6. 8 pl. 1814 ed. Roman 4. 6 pl. 315 ed. Roman 4. 32 pl. 14, 19 ed. Roman 4. 10 pl. 18, 20 ed. Roman 4. 3 pl. 17. 266 1c for an illustration 2 Kent's com. 12th ed. 451 n. 1b. 266 2 repromitator, but cf. Pro servidio chuo vel pro homagio fleta, Roman 2. C60, section 25. 267 1 yb 29 ed. Roman 3, 25 26, but cf. 48 ed. Roman 3, 3 pl 6. 267 2 19 r Roman 2. Fitz, aber, det pl. 166. 267 3 yb 12 hen, Roman 4. 17 pl 13 ad fin. 267 4 yb 9 hen, v14 pl 23. 267 5 cf. 13 ed. Roman 2. 403 17 ed. Il 48 pl 14 29 ed. Roman 3. 25 26. 41 ed. Roman 3. 7 pl 15 46 ed. Roman 3. 6 pl 16. Fitz, aber det pl. 166. 267 6 yb 3 hen Roman 6. 36 pl 33. 268 1 yb 37 hen, Roman 6. 8 pl 18. 268 2 e.g. Rolf and yb 3 hen, Roman 6. 36 pl 23. 269 1 yb 37 hen, Roman 6. 8 pl 18. cf. Bro, Fiefmans al uses pl 54, Plowden 301. 269 2 yb 15 ed. Roman 4. 32 pl 14, sc 14 ed. Roman 4. 6 pl 3, 17 ed. 4 pl 4. 269 3 cf. yb 37 hen, Roman 6. 8 pl 18, 17 ed. Roman 4. 4 5 Plowden 305 306. 269 4 yb 3 hen, Roman 6. 36 pl 33. 269 5 yb 37 hen, Roman 6. 13. 269 6 as to requirement of certain sum, cf. yb 12 ed. Roman 2. 375 fleta Roman 2. C60, section 24. 271 yb 29 ed. Roman 3. 25 26 40 ed. Roman 3. 24 pl. 27 43 ed. I1. 2 pl 5. 272 yb 43 ed. Roman 3. 2 pl 5 46 ed. Roman 3. 25 pl 10 50 ed. Roman 3. 5 pl 11. 273 cf. Glanv, Lib X C8 fleta Roman 2. C60, section 25. 274 yb 35 ed. I 454, 12 ed. Roman 2. 375. 272 1 Ducange, Sigillium, Ingulf, 901. 272 2 Big, pl. Ang, Norm, 177. 272 3 Big, pl. Ant, Norm, 177 Bract, Fall, 100b section 9 Scriptura. But cf. yb 30 ed. I 158 fleta Roman 2, C60, section 25. 272 4 yb 33 ed. I 354 356 35 ed. I 455 top 41 ed. Roman 3. 7 pl. 15 44 ed. Roman 3. 21 pl. 23. cf. 39 hen. Roman 6. 34 pl. 46. 272 5 yb 7 ed. I 242. cf. 35 ed. I 452. 272 6 cf. Bract, Fall, 100b section 9. 272 7 cf. Glanv, Lib X C12 Dugdale Antic, Warwick, 673 cited Dukenge, Sigillum, Bract, Fall, 396b, Section 3, Ibrit, Nish, 163, Section 17, Abreve, Plaque 8 Joe, Burke, Rot, 4 pp 55-56, Ib, 19 ed., I. Norf and Surf, Rot, 7 p 284, Ib, Index Sigillum. 272 8 YB 30 ed., I. 158, Fleta, Roman 2, C. 60, Section 25, p. 130. 273 145 ed., Roman 3, 24 pl 30. 273 2 Bract, Fall, 100b, Section 9. 275 1 cf. 5 Co. Rep 13b, 14 with 1 roll. Rep 126 128, YB 43 ed., Roman 330 pl. 15. 275 2 YB 46 ed., Roman 3, 19 pl 19 SC Bro, Ac. Sur Lacase pl. 22. 275 3 YB 22 As pl. 4 I Fall, 94. 276 1 YB 43 ed., Roman 3, 33 pl. 38. 277 1 YB 11 hen, Roman 4, 33 pl. 60. 277 2 YB 3 hen, Roman 6, 36 pl. 33. 277 3 YB 2 hen, Roman 4, 3 pl. 9, 11 hen, Roman 4, 33 pl. 60, cf. 3 hen, Roman 6, 36 83. 279 1 cf. 19 hen, Roman 6, 49 pl. 5 ad fin, Newton, cj. 281 cf. YB 48 ed., Roman 3, 6 pl. 11. 282 cases supra, YB 2 hen, Roman 4, 3 pl. 9, 11 hen, Roman 4, 33, cf. 3 hen, Roman 6, 36 pl. 33 20 hen, Roman 6, 34 pl. 4 2 hen, Roman 7, 11 pl. 9. 281 1 YB 48 ed., Roman 3, 6 pl. 11, cf. Fitz, Aber, Ac. Sur Lacase pl. 37 11 R Roman 2, 14 hen, Roman 6, 18, but cf. 43 ed., Roman 3, 33 pl. 38. 282 1 cf. Candish's reasons for allowing wager of law with YB, 32 and 33 ed. I. Preface, p. Roman 36, citing the old rules of pleading printed at the end of the tract entitled Modus tenendi unum hundredum sire curiam de recordo in Rassel's Law Tracts, p. 410, EFG. 282 2 YB 3 hen, Roman 6, 36 pl. 33. 282 3 YB 2 hen, Roman 4, 3 pl. 9, 11 hen, Roman 4, 33 pl. 60, 3 hen Roman 6, 36 pl. 33. 282 4 3 hen, Roman 6, 36 pl. 33. 283 1 YB 14 hen, Roman 6, 18 pl. 58. 283 2 Ibid. Cf. 48 ed., Roman 3 6 pl. 11. 283 3 YB 19 hen, Roman 6, 49 pl. 5 c. Further YB 20 hen, Roman 6, 25 pl. 11. 284 1 cf. YB 3 hen, Roman 6, 36 pl. 33. 284 2 YB 2 hen, Roman 7, 11 pl. 9 cf. 20 hen, Roman 6, 34 pl. 4. 284 3 cf. YB 14 hen, Roman 6, 18 pl. 58, 21 hen, Roman 7, 41 pl. 66 Phinox cj. 284 4 Caleway 160 pl. 2 2 hen, Roman 8, Pouturi v. Walton 1 roll, Aber, 10 pl. 539 Eliz, Cogs v. Bernard 2 ld, Rame 909 2 Ann, AD 1703. Supra, p. 195. 285 1 Sands v. Trevelyan, Crow, Car, 193 194 Mitch, 4 Car, IAD, 1629. 285 Tubro. Ac. Sur la case PL 5, SC YB 27 Hen, Roman 8. 24-25 PL 3, Sidenham v. Worlington 2 Leon. 224 AD 1585. 285 3 YB 21 Hen, Roman 7. 30 PL 5, Ib 41 PL 66. 285 4 YB 3 Hen, Roman 6. 36 PL 33. 286 1 Sherrington v. Stratton, Plowden, 298 Mitch, 7 and 8 Eliz. Ib 309 Note on the Civil Law. 286 2 Hunt v. Bate, 3 Dyer, 272 a 10 Eliz. AD 1568. 286 3 C Lecture Roman 8. Mr. Langdell, Contracts, Sections 92, 94, suggests the ingenious explanation for this doctrine, that it was then held that no promise could be implied in fact from the request. There may be evidence which I do not know, but the case cited, Boston v. Thin Yelv. 40, for this statement was not decided until AD 1603, while the implication of Hunt v. Bate, supra, which was the authority followed by the cases to be explained, is all the other way. 286 4 Sidenham v. Worlington, 2 Leon. 224 AD 1585. 287 1 Red v. Baxter, 3 Dyer, 272 B, N 26 and 27 Eliz. Cf. Richards and Bartlett's case, 1 Leon. 1926 Eliz. 287 Tubro. Ac. Sur la case PL 5, SC YB 27 Hen, Roman 8. 24-25 PL 3, 3 Dyer, 272 N. 287 3 Marsh v. Rainsford, 3 Dyer, 272 B, N, SC 2 Leon. 111 and Crow, Eliz. 59 sub nom, Marsh v. Cavenford. 287 4 Smith and Smith's case, 3 Leon. 88 AD 1583, Riches and Briggs Yelv. 4 AD 1601, Picas v. Guile Yelv. 128 AD 1608. 288 1 Supra, p. 195. Lord Coke's caution not to rely on the abridgments is very necessary to the proper study of the history of consideration. The abridgments apply the doctrine to cases which make no mention of it, and which were decided before it was ever heard of. 291 YB 46 ed. Roman 3, 19 PL 19, 19 Hen, Roman 6. 49 PL, 5 Caleway 160 PL 2, Poutieri v. Walton 1 Roll, Aber. 10 PL, 5 Cogs v. Bernard 2 LD. Rame, 909. 292 Riches and Briggs Yelv. 4 AD 1601, Picas v. Guile Yelv. 128. 291 1 Bainbridge v. Firmstone, 8 ad. And L 743, AD 1838. 291 2 Wilkinson v. Oliveira, 1 Bing. NC 490, AD 1835, Hague v. Brooks, 10 ad, and L 309, LB. 323 Hart v. Miles, 4 CB. NS 371, AD 1858. 291 3 Wheatley v. Lowe, Crow, Jack. 668, AD 1623. Cf. Bine and Plains case, 1 Leon. 220, 221, 32, and 33 Eliz. 291 4 Wilkinson v. Oliveira, 1 Bing. NC 490, Hague v. Brooks, 10 ad, and L 309, Hart v. Miles, 4 CB. NS 371, 6 AM. Law Reverend 47, Oct. 1871. 292 1 Supra, pp. 196, 197. See also Lecture Roman 7. 292 2 Biles, J. in Shadwell v. Shadwell, 30 LJCP 145, 149. 292 3 Shadwell v. Shadwell, U by Supra. Burr v. Wilcox, 13 Allen 269, 272, 273. 292 4 Thomas v. Thomas, 2 QB 851. 293 1 Price v. Jenkins, 5 ch. D 619. Cf. Grab v. Moxie, 1 Wr. 226. Thomas v. Thomas, 2 QB 851. Monahan, Method of Law, 141 et sec. 294 1 Ellis v. Clark, 110 Mass. 389. 294 2 Fitch v. Snedaker, 38 NY 248, criticizing Williams v. Carwardine, 4 Barn, and add. 621, where, however, it does not appear that the plaintiff did not know of the offer of a reward, but merely that the jury found that she was in fact actuated by other motives, a finding wholly beside the mark. 296 1 YB 29 ed. Roman 3, 25 26. 296 219 R Roman 2, Fitz, Aber, Det. PL, 166. 296 3 Hunt v. Bate, Dyer, 272, AD 1568. 297 1 C. Barker v. Halifax, Crow, Eliz, 741, SC3 Dyer, 272 AN, 32. 297 2 Sidenham v. Worlington, 2 Leonard, 224, Boston v. Thin Yelv, 40, Lampley v. Brathwaite Hobart 105, Langdell Cass on Conter, 2 D. ed. Ch. 2 Section 11 Summary Sections 90 et sec. See above Lecture Roman 7, p. 286. 297 3 Pollock Conter, LSD ed. p. 6. 298 1 Canham v. Bari, 15 CB 597 619, Jones v. Howe 9 CB 19, Com. Dig. Condition D2 I roll Aber, 420 D. PL 1 YB 22 ed. Roman 4, 26 PL 6. 301 1 G v. Lancashire and Yorkshire Railway Co., 6 H and N 211 218, Bramwell, BCF. Hydraulic Engineering Co. v. McAfee, 4Q, BD. 670 674 676. 301 2 British Columbia Sawmill Co. v. Nettleship, LR3CP 499, 509, Wills J. Horn v. Midland Railway Co., LR7CP, 583, 591, SC, LR8CP 131. 302 1 British Columbia Sawmill Co. v. Nettleship, LR3CP, 499, 509. 304 1 Cheel v. Kenward, 3 Deg, and J27. 304 2 Langdell Conter, Sections 89 28. 305 1 Langdell Conter, Section 57. 305 2 Ibid, Sections 14 15. 306 1 But C. Langdell Conter, Sections 14 15. 309 1 Raffles v. Witchell House, 2 H and C. 906. Cf. Kyle v. Kavanagh, 103 Mass 356, 357. 309 2 Cf. Cocker v. Crompton, 1B and C. 489. 310 1 Smith v. Hughes, LR6 QB 597. 310 2 C. Gardner v. Lane, 12 Allen, 39, SC 9 Allen, 492, 98 Mass. 517. 311 1 Goddard v. Monitor Inns, Co. 108 Mass. 56. 313 1 C. Cundy v. Lindsay, 3 App. Cass. 459 469. Cf. Reg. v. Middleton, LR2 CC 38 55 et sec. 62 et sec. Reg. v. Davies, Dearsley, CC 640, Rex v. Mucklow, 1 Moody, OC 160 Reg. V. Jacobs, 12 Cox 151. 313 2 Presentia corporis tollit erorum nominis. Cf. Biles J. in Way v. Hearn, 32 LJ and SCP 3440, but cf. The conflicting opinions in Reg. v. Middleton, LR2 CC 38 45 57. It would seem that a proper name or other identification of an object or person as specific may have the same effect as an actual identification by the senses, because it refers to such an identification, although in a less direct way. 316 1 Brown v. Foster, 113 Mass 136. 316 2 Leak Dig, Conter. 13 14 637, Hunt v. Livermore 5 Pick, 395 397, Langd, Conter. 2d ed. Section 36. 316 3 Leak Dig, Conter. 638, Braunstein v. Accidental Death Ins, Co., 1b and s 782. 316 4 but cf. Langd, Conter. 2d ed. Section 29. 318 1 Langd, Conter. 2d ed. Section 29. 318 2 Bullen and Leak Prec. Of Plead. 3d ed. 147 Conditions Precedent. 319 1 cf. Court v. Ambergate, Nottingham and Boston and Eastern Junction Railway Co., 17 QB 127. 321 Goodman v. Pocock, 15 QB 576, 1850. 325 1 Fisher v. Mellon, 103 Mass. 503. 325 2 Supra, p. 136. 327 1 Langd, Conter. 2d ed. Section 33. 328 1 See the explanation of Dimich v. Corlett, 12 Mu. PC 199 in Bain v. Burness, 3b and s 751, 760. 329 1 Bain v. Burness, 3b and s 751. 329 2 Langd, Conter. 2d ed. Section 28 p. 1000. 329 3 See Lecture Roman 8. 331 Kennedy v. Panama and C. Mail Co., LR2 QB 580, 588, Lyon v. Bertram 20 Howe, 149 153. Cf. Windshade Pand, Section 76 NN. 6 9. 332 Windshade Pand, Section 76 4. C. Generally Ibid, NN. 6 7 Section 78 pp. 206 207, Section 82 pp. 216 et sec. 331 1 cr. Ihering, Geist d Roem, Rex, Section 48 Roman 3, p. 116, fr. Transl. 331 2 c. However, the language of Crompton, J in SC, IB and S. 877. Cf. Kent, Com. 12th ed. 479 N1 a c. 331 3 Bain v. Burness, 3b and s 751, 755, 756. 334 1 cf. Anglo-Egyptian Navigation Co. v. Rennie, LR 10 CP, 271. 334 2 Ellen v. Top, 6 ext, 424. 335 1 Contracts 2d ed. Section 106 and Passim. 336 1 Chanter v. Hopkins, 4M and W 399, 404. Possibly Bain v. Burness, stated above, might have been dealt with in this way. The ship tendered was not a ship which had been in the port of Amsterdam at the date of the contract. It was therefore not such a ship as the contract called for. 336 2 Hayworth v. Hutchinson, LR2 QB 447, criticized in Benj, Sales 2d ed. pp. 742 et sec. 336 3 C. Thomas v. Cadwallader, Wills 496, Langd, Conter. 2d ed. Sections 116, 140. This is put as a case of equivalence by Mr. Langdell, Conter. Section 116, but the above explanation is believed to be the true one. It will be noticed that this is hardly a true case of condition, but merely a limitation of the scope of the tenant's promise. So a covenant to serve as apprentice in a trade, which the other party covenants to teach, can only be performed if the other will teach, and must therefore be limited to that event. Cf. Ellen v. Top, 6 ext. 424. 337 1 Langdell, Contracts 2d ed. Section 127. Cf. Roberts v. Brett, 11 HLC 337. 339 1 Graves v. Leg, 9 ext. 709. Cf. Lang, Conter. 2d ed. Section 33, p. 1004. Mr. Langdell says that a botnote, though part of a bilateral contract, is to be treated as unilateral, and that it may be presumed that the language of the contract relied on was that of a botnote, and thus a condition in favor of the defendant who made it. I do not quite understand how this can be assumed when the declaration states a bilateral contract, and the question arose on demurrer to a plea, which also states that the plaintiff was by the agreement bound to declare the names. How remote the explanation is from the actual ground of decision will be seen. 341 1 Rect Despicitzes, Section 11, p. 184 N1 7th ed. Eng, tr. 124 nt. 342 1 Inst, Roman 2, Section 157. 342 2. In suis heredibus evidentius apparet continuationem dominii eo rem perdor. Ut nulla videtur hereditas fuis, quasi allum hi domini assent. Qui etiam vivo pater quadmodo domini existimanter, unde etiam filius familias appellator sicut pater familias, sola nota hei adecta, per quam distinguitur genitor ob eo qui genitus sit. Idac post mortem patris non hereditatem perciper videnter, sed magis liberam benorum administrationem consequenter hac ex causa licet non sint hereds instituti, domini sunt, nec obstat, quod licet eus exuridere, quod et occidere lispet. D 28.2. 11. Cf. Plato, Laws, Greek Characters. 343 1 Laveli, Propriety, 24, 202, 205, 211, N1, 232. Norton L.C. Hindu Law of Inheritance, p. 193. 343 2 D50, 16, 208. 343 3 D41, 134. Cf. D41, 340 Bract, Fall, 8A 44A. 343 4 D43, 2413, Section 5. 344 1 Germania, C20. 345 1 Littleton, Section 337, Colit 209 a B, YB 8 ed. Roman 4 5 6 PL. 1 Caleway 44 a 17 hen, Roman 7. Lord North v. Butts, Dyer 139b 140 a top, Overton v. Siddall, Popham 120-121, Boyer v. Rivet 3 Bolster. 317 321, Bain v. Cooper 1 Dowell. PR Cass, NS 1114. 345 2 YB 48 ed. Roman 3, 2 PL 4. 346 1 Vermogensrichlichen Klagen, 88, 89. 346 2 Proc. De la Lex Salica tr. The Venin, p. 72 and N1. 347 1 Ethelred Roman 2. 9 Cena Roman 2. 73 Essays in Ang. Sachs. Law pp. 221 et sec. 347 2 1 Spence, Eck. 189 Note citing Hicks Dissert. Epist. p. 57. 347 3 Glanv, Lib Roman 7. C2 Beams, p. 150. 347 4 Ibid. C8 Beams, p. 168. 347 5 Reg. Maj, Lib Roman 2, c. 39. 348 1 Fall, 61a. 348 2 Sachsensp, Roman 2. 60 Section 2 cited in Essays in Ang. Sachs, Law p. 221, Grand Cust, de Norm, c. 88. 348 3 Brit, Fall, 64b Nish, ed. 163, Fleta Lib Roman 2, c. 62 Section 10. Cf. Bract, Fall, 37b Section 10. 348 4 Bracton, Fall. 61 a b item quero intestator leger possit actions suas, et verum est quod non, de debitus qui in vita testatoris convicta non furunt nec recognita, sed hugis modi actions competent heredibus. Cum antera convicta sint et recognita, tun sunt quaes in bonus testatoris, et competent executoribus in foro ecclesiastico. Si autem competent heredibus, ut predictum est, in foro seculari debent terminari, quia antiquem communicanter, et in foro debito, non pertinet ad executors, ut in foro ecclesiastico convincanter. 349 1 Bracton Fall, 62a. 349 2 YB 20 and 21 ed. I 232, cf. Ib. 312. 349 3 Oates v. Frith Hob 130, cf. YB 5 Hen, Roman 7, 18 PL, 12 Popham J. and Overton v. Siddall Poff, 120 121 E39L, Boyer v. Rivet 3 Bolster. 317 319 322, Brooker's case Go DB 376 380 P3 Car. Eyes. 349 4 Bain v. Cooper 1 Dowell, Pract, Cass NS 1114, cf. YB 14 Hen, Roman 8, PL, 5 et Fall, 10. 351 Bract, Fall, 66B, 76B and Passim, YB 20 ed. I 226 200, Littleton section 241. The same thing was said where there were several executors, they are only in the place of one person. YB 8 ed. Roman 4, 5 PL, 1. 352 Com, 385. 353 cf. Glanv, Lib Roman 7, C3, FNB 21L, Dyer 4B 5A. 351 1 cf. Bract, Fall 80B. 351 2 Charta Divies. Reg, Frank, Art Roman 9 and Roman 8, cf. 3 Laferriere Hist, Du Droit Francais 408 409. 351 3 Glanv, Lib Roman 9, C1 Beams pp. 218 220, Bract, Fall 79b. 352 1 Brooker's case, Godbolt 376 377, PL, 465. 352 2 Dyer 1 BCF, Bain v. Cooper 1 Dowell, PR, CNS 11 12. 354 1 in the American Law Review for October, 1872, Roman 7. 49, 50, I mentioned 1 or 2 indications of this fact. But I have since had the satisfaction of finding it worked out with such detail and learning in Eihering's Geist des Römischen Rechts, sections 10, 48, that I cannot do better than refer to that work, only adding that for my purposes it is not necessary to go so far as Eihering, and that he does not seem to have been led to the conclusions which it is my object to establish. See, further, Clark, Early Roman Law 109, 110, Laferriere Hist. Du Droit Frang, I 114 et sec. D. 154 Section 3 Gai Inst, Roman 4, Section 16, Ib, Roman 2, Section 69. 356 1 Herbertrige, I 15 et sec. 356 2 Hist, Du Droit Frank, Roman 4, 500. 357 3 Quantum der Valerit aut totem fortunam ui valerit der, nec minus nec magis nisi quantum I creditum est. Lex Sal, Merkel, Roman 46. 357 4 Lex Sal. Merkel, Cap, Roman 46, Duid Fathameier, Sohm, Frank, Reichs u Gerichtsverfischung, 69. 357 6 Bestseller, Erbvertrige, I 101, 102, 105. 358 1 Omnum facultatum suum, Sicuti libet de proximus vel extranes, adopter in hereditatem vel in adfatami vel per scripturarum serium su per traditionem. L. Rib Cap, L. Al Roman 48, cf. L. Thuring, Roman 13, so Cap. Rib, section 7, qui filios non haburit et aliern quem libet heredum facere sibi volerit coram rege, traditionem faclet. 357 2 ed. Roth, Cap, 174 157, cf. LB, 369 388, Liutper, Roman 3, 16 Al 2, Roman 6, 155 Al 102, cf. Bestseller Erbvertrige I 108 et sec, Esp, 116 118. Compare the charter of AD 713, Offero, S. P. Ecclesia quam mihi heredum constitui. Mem. Di Luca v. B. Number 4, Troia Roman 3. Number 394, cited Husler Jewer 4546. Cf. Ib. 484. This, no doubt, was due to Roman influence, but it recalls what Sir Henry Maine quotes from Elphinstone's History of India, I 126, as to sale by a member of one of the village communities. The purchaser steps exactly into his place and takes up all his obligations. Ancient Law, ch. 8 pp. 263-264. 357-3 Merkel Cap, LVI de Crenacruda. Soame Frank, RUG Verf, 117. 358-1 AD 679. Sicuti tibi donata est era tene et postri tui. Kemble, Cod, Dip, I-21 no, Roman 16. Udid, AD 767, quam is semper possidet et post si cui volerit heredum relinquat. Ib I, 144, XXXI. Quilibet heredi volerit relinquat is very common in the later charters. Ib, V155 MLXXIL, LB, Roman 6, 1 Mixfiel it, 31 MCCXXX, LB, 38 Mxxiv, and passim, this may be broader than cui volerit hierulum. Offa, AD 779, ut si viverite habe, deet, et post si suo propinquitatis hemini cui ipsvo. Poseidondum libera utens potstate relinquat. Ib, I-164, 165, CXXXV, Ethelbald, AD 736, ita ut quamdiu vixerit potstatum habet tenendi ac poseidendi cuicumque volerit vel eo vivo vel cert post obidum suum relinquendi. Ib, I-96, lxxx, cf. Ib, V53, mziv. Cuthard of Kent, AD 805, cuicumque hominum volerit in aeternam libertatem derelinquat. Ib, I-232, cxc. Ut habet libertatem commutandi vel denandi in vita sua et post, ejus obitern tenit facultatem relinquendi cuicumque voleris. Ib, I-233, 234 CXCI. Cf. Ib, V70, MXXXI. Wiglaf of Mercia, Aug. 28, AD 831, su vendendum ant commutandum I cuicumque I hered, placurit dereliaquendum. Ib, I-294, CCXXV. 359-1, W at heredibus suis, videlis et quos hereds considerit. Memorials of Hexham, Certes Soc. Pub, 1864, Roman 2, 88. 359-2 cf. YB 27 As Fall, 135 PL, 25. Under the Welsh laws, the champion in a cause decided by combat acquired the rights of the next of kin being the proper champion. Lee, Superstition and Force 3D ed. 165. Cf. Ib. 161 N1, Ib. 17. 361 1D38, 81 PR. 361-2 cum is qui ex edicto bonorum possessionum petiet ficto si hered agit. Gai inst, Roman 4, section 34. Cf. Ulp. Fram Roman 28, section 12 D37, 1-2. So the fidei commissarius, who was a praetorian successor, D41, 4-2 section 19, 10-24, in similitudinem heredis consistit. Nov. 1-1 section 1, cf. Just. Inst. 224 PR, and then Gaius Roman 2. Sections 251, 252. 361 3 Gai Inst, Roman 2, sections 102 et sec, cf. Ib. Sections 252-35. 361 4 Gai Inst, Roman 4 section 35, similiter et bonorum emptor ficto si hered agit. Cf. Ib. Sections 144-145. Keller Romish Civil Process, section 85 Roman 3, but cf. Schewel Laib, der Inst, section 218, p. 407, 6th ed. 361 5 Paulus in D50. 17, 128. 362-1, in re legata in accession temporis quo testator possidit, legatarius quadmodo quaes heres est. D41, 314, section 1. 362-2, D41 162, 43-3-1, section 6, Gai Inst, Roman 2, section 97 just. Inst. 210, section 11. 363-1, plain tribunter his qui in locum alirum succedunt sive ex contractu sive voluntate, heredibus enum et his, qui successorum loco habenter, dater accessio testatoris. Id ac si mihi vendidoris servum uter accession tua. D44 314, sections 1, 2. 363-2, ob eo, in cujus locum hereditate vel emption aliove quo eier successi. D43, 19.3, Section 2. 363 D50, 4.1, Section 4, cf. Sic doaf, 319, 76 Gai inst, Roman 4, Section 34. 363 4C2 321, C616. 2, cf. D38, 81 PR. 364 1, in locum successus equipimus sive per universitatem sive in rem sit successum. D43, 31, Section 13. Cf. D2133, Section 1, D12, 2, 7 and 8D. 39 224, Section 1. 364 2 D41 213, Sections 1, 11. Other cases put by Ulpian may stand on a different fiction. After the termination of a precarium, for instance, fingiter fundus nunquam fuis possessus ob ipso detentor. Gothofrid, note 14 Els, ed. But cf. Puchta in Weisk RL Art, Besitz P50 and D41 213, Section 7. 364 3 Inst. 26, Sections 12 13, cf. D44, 39, c. For a fuller statement, 11 a.m. Law Reverend 644, 645. 365 1 Rect des Besitzes, Section 11, 7th ed. P 184 N1 Ang TR 124 NT. 365 2 Paulus D8 618 Section 1. This seems to be written of a rural servitude aqua which was lost by mere disuse without adverse user by the servient owner. 365 3 Hermogeneous D21 33 EXE Ray Judd D44 29 Section 2 Ib 28 Ib 11 Sections 3 9 D10 225 Section 8D 46 816 Section 1 Keller Rowham Civil Proc Section 73 cf. Bracton Fall 24b Section 1 Adfin. 365 4 Rectami via Udi prohypter et interdictum I inudel est quia ami viter Roman 6 vel clam vel precario possidir qui ab octor meo videos possidit. Nam et pedius scribit, see Roman 6 out clam out precario ob cosit usus, in cuius locum hereditate vel emption aliove quo lur susici, idem esse dicendum. Cum enim successerit quis in locum aerum, equum non est nos nosri hoc, quod adversus eam non nocuit, in cuius locum successimus. D43 19. 3, Section 2. The variation actor argued for by Savigny is condemned by Mommsen, in his edition of the Digest, it seems rightly. 365 5 D12, 2 7 and 8. 366 1 Ulpian D39, 224 Section 1, cf. D8 5.7 D39, 2 17 Section 3N, 79 Elsevier ed. Paulus D214, 17 Section 5. 366 2 Cum quis in alii locum successerit non est equum I noser hoc, quod adversus eam non nocuit, in cujus locum successit. Plerumc emptoris idem causa esse debit circa petendum ac defendendum, qui fuit auctoris. Ulp. D50. 17, 156, Sections 2 3, qui in eus dominium ulterius succedit, ear adjus iudi debit. Paulus. D50. 17, 177. Non debio meliorus condionus esse, quam octor mus a quo eus in me transit. Paulus. D50. 17, 175, Section 1. Quod ipsis qui contraserant obstat et successoribus eatern obstabit. Ulp. D50. 17, 143. Nemo plus iuris ad alium transfera potest quam ips haberit. Ulp. D50. 1754 Bract, Fall, 31 BCF, Decret. Greg, Lib, Roman 2 tit. Roman 13, C18 de rest, spoliat, cum spoliatori quaes I succedet invidium. Bruns, R.D. Besitzes, P. 179. Windshade, Pand, Section 162 a N10. 366 3 Ni videosi quidem possessioni ulla potest excedir, sed nec vidiosa I quis vidiosa non est. D41, 213, Section 13. 367 1 Hill v. Ellard, 3 Salk, 279. Cf. Withers v. Iceham Dyer 70 a 70b 71 a Gatewards case 6 Co Rep 59b 60b YB 20 and 21 ed. I 426 205 12 Hen Roman 4 7 368 1 Doe v. Barnard 13 QB 945 952 953 per Kerr Pattison J. Cf. Asher v. Whitlock LR 1 QB 1 367 368 2C, further, Sawyer v. Kendall 10 Cush, 241 2 BL, Com 263 et sec, 3 CH, PL, 1119 6th AM, ed. 3 Kent 444 445, Angel Limitations, ch. 31, section 413. Of course, if a right had already been acquired before the disseisin, different considerations would apply. If the right claimed is one of those which are regarded as incident to land, as explained in the following lecture, the desaisor will have it. Jenk, cent. 12 first cent, case 21. 371 Ard v. Watkin Crow, Eliz, 637 SC Ib 651. Cf. YB 5 Hen, Roman 7, 18 PL, 12 Dyer 4B N 4. 372 Roe v. Haley, 12 East, 464, 470, 1810. 371 1 Boyer v. Rivet, 3 Bolster. 317, 321. 372 1 Essays in A.S. Law, 219. 372 2 Per Medium, Bracton Fall, 37b, section 10 ad fin. 374 1 Bract, Fall, 17b cf. Fleta Roman 3, C14, section 6. 374 2c, further, Middlemore v. Goodale Crow, Car. 503, stated infra, p. 379. 374 3 see also Bract, Fall, 380b 381. Et quod de heredibus dicitur, idem disipotrit de signatis, et quod signatis feri debit warrantia per modum donationis, probiter in itiner W. De relig in com, var. Circa finem Rocheli et hoc maxime, si primus dominus capitalis et primus fifater, separat hemagem et servidium assignati. Cf. Fleta Roman 6, section 6, Moore 93 PL 230 Chef, touched, 199 200. As to the reason which led to the mention of assigns, cf. Bract, Fall, 20b, section 1, 1 Brit. Nish, 223 312. 375 1 I do not stop to inquire whether this was due to the statute of quia emptors, by which the assign was made to hold directly of the first grantor, or whether some other explanation must be found. Cf. Bract, Fall, 37b, C14, section 6, 11, Roman 6, c. 28, section 4, 1 Britain Nish, 256. 375 2 Fleta Roman 3. C14, section 6 Fall, 197 1 Britain Nish, 223 233 244 255 312 Co-lit, 384b YB 20 ed. I 232, Aber Placet, Fall, 308 2 Decall Dunelm Rot, 43 YB 14 Hen, Roman 4. 5 6. 377 1 Fall, 67 a CF, 54a. 377 2 Fall, 381, Supra, p. 874 N3. 378 1 CF. Pinkham v. Rudge Hobart 3 Bro, Warrantia Cart PL, 8 SC YB 2 Hen, Roman 4. 14 PL, 5. 378 2 YB 50 ed. Roman 3. 12b and 13. 378 3 YB 42 ed. Roman 3. 3 PL 14 per Belknap Argendo. 378 4 Noak v. Otter Crow, Eliz. 373 SC Ib 436. Cf. Lewis v. Campbell 8 Taunt. 715 SC 3 J B Moore 35. 379 1 Middlemore v. Goodale Crow, Car. 503 SC Ib 505 Sir William Jones 406. 379 2 Harper v. Bird, T. Jones 102 Pash 30 Car, Roman 2. These cases show an order of development parallel to the history of the assignment of other contracts not negotiable. 381 Andrew v. Pierce, 4 Bowes, and Poole 158, 1805. 383 1 Austin, Jurisprudence Roman 2, p. 842, 3d ed. 383 2 Quoniam non personi, sed predia deberent, nec adquiri libertas nec remiti servitus per partum potrit. D 8334 pr. 383 3 Qui fundum alienum bona fide mit, itiner quod I fundo debetur usus est, retentur id ius itineris. Ac etiam, si precario aut Roman 6 deecto domino possidit, fundus enim qualitur si habens ida, cum in suo habitu possessus est, ius non deperit, nec refert, ius nec ni possidat qui talem iam possidit. D8. 612. 383 4 Elsevier ed. N51 ad loc. Cit. Cicero de L. Ager 329. 383 5 D50. 1686. Cf. Ulpian D41, 120 Section 1 D83, 23 Section 2. 383 6 Inst. 23 Section 1. 384 1 D8 114 PR. Cf. Elsevier ed. N58, et sic jura. Accessions ease possunt corporum. 384 2 Cum fundus fundo servit. D8, 412. Cf. D8, 520 Section 1 D41, 120 Section 1. 384 3 Jurisprudence, Roman 2, p. 847, 3d ed. 384 4 Cf. Windshade Pand, Section 57 N10 4th ed. p. 150. 385 1 Fall, 10b, Section 3. 385 2 Fall, 220b, Section 1. 386 1 Fall, 221. 386 2 Fall, 219a b. 386 3 Fall, 102a b. 386 4 Fall, 226b, Section 13. All these passages assume that a right has been acquired and inheres in the land. 387 1 Fall, 53 a cf. 59b ad fin, 242b. 387 2 Nihil prescribitur nisi quad possiter, cited from Hale de Jure. Maries, p. 32 in Blundell v. Catterall, 5b and ald. 268, 277. 388 1 Bracht, Fall, 46b, cf. 17b, 18, 47b, 48. 388 2 Fall, 81, 81b, 79b, 80b. 388 3 Fall, 24b, 26, 35b, 86, 208b, and c. cf. FNB 123, E. Laveli Propriet 67, 68, 116. 388 4 Aber, Plaque, 110 Rot, 22 Devon, Hen Roman 3. 388 5 Stockwell v. Hunter, 11 Met, Mass, 448. 389 1 Caleway, 130b, PL, 104. 389 2 Caleway, 113 a PL, 45, Dyer 2b. 389 3 Caleway, 113a, PL, 45, cf. YB 3335 ed. I-70, 45 ed. Roman 3. 11, 12. 389 4 Lit. Section 589. 389 5 Caleway 2 a PL, 2 ad fin, 12 hen, Roman 7, but cf. YB 6 hen, Roman 7, 14 PL, 2 ad fin. 389 6 4 Laferriere Hist, Dudroit, Frank, 442, Bracton Fall, 53a. 391 cf. Colit 322b et sec, YB 6 hen, Roman 7, 14 PL, 2 ad fin. 392 Daintree v. Brocklehurst, 3 ext, 207. 393 YB 5 hen, Roman 7, 18 PL, 12. 391 1 YB 9 hen, Roman 6, 16 PL, 7. 391 2 YB 14 hen, Roman 6, 26 PL, 77. 391 3 YB 5 Hen, Roman 7, 18 PL, 12. 391 4 CF, Thelol Dig, IC 21 PL 9. 391 5 Buskin v. Edmonds, Crow, Eliz, 636. 391 6 Harper v. Bird, T. Jones, 102 30 Car, Roman 2. 391 7 Bowles v. Niceham, Dyer, 254b, Porter v. Swetnam, Style 406, SC, Ib, 431. 391 83 BL, Com, 231, 232. 392 1 Yielding v. Fay, Crow, Eliz, 569. 392 2 Pakenham's Case, YB 42 ed. Roman 3. 3 PL 14, Prior of Woburn's Case 22 Hen, Roman 6. 46 PL 36, Williams's Case 5 Co. Rep. 72b 73 a Slipper v. Mason, Nelson's Lutwich 43 45 Top. 392 3 FNB 127, Noel v. Smith, Crow, Eliz, 709, Star v. Rookesby 1 Salk. 335 336, Lawrence v. Jenkins, LR 8 QB 274. 392 4 Dyer, 24 a PL, 149, FNB 180N. 393 1 FNB 128D, E, Colit. 96b It is assumed that, when an obligation is spoken of as falling upon the land, it is understood to be only a figure of speech. Of course, rights and obligations are confined to human beings. 393 2 Caleway, 145b 146 PL. 15. Sir Henry Neville's Case, Ploughed, 377 381, Chudley's Case, 1 Co. Rep 119b 122b. 393 3 FNB 180N, Co-Lit 385, a Spencer's Case, 5 Co. Rep. 16 a 17b, Pakenham's Case, YB 42 ed. Roman 3. 3 PL 14, Caleway 145b 146 PL. 15. Commins's Digest, Covenant B 3. 394 1 Holmes v. Seller, 3 Lev. 305, Robotham v. Wilson, 8 HLC, 348, Bronson v. Coffin, 108 Mass 175 180, cf. Bro, Covenant PL. 2. 394 2 YB 21 ed. Roman 3. 2 PL 5, FNB 180N. 394 3 The action is case in the prior of Woburn's Case, YB 22 Hen. Roman 6. 46 PL 36. In FNB 128E, NA, it is said that a curia claudenda only lay upon a prescriptive right, and that if the duty to fence was by indenture, the plaintiff was put to his writ of covenant. But see below pp. 396 400. 394 4 YB 32 and 33 ed. I 430. 395 1 YB 20 ed. I 360. 395 2 YB 32 and 33 ed. I 516. 395 3 Quia res cum homine transit ad quem cunc. Fall, 382 382b. 395 4 Lib, Roman 6, c. 23, section 17. 395 5 Pakenham's Case, YB 42 ed. Roman 3, 3 PL 14. 395 6 Sugged, V and P 14th ed. 587 Rawle Covenants for Title 4th ed. P 314. Cf. Vivian v. Arthur 1B and C 410, Sharp v. Waterhouse 7L and BL. 816 823. 396 1 Colit, 385a. 396 2 cf. Finchton as to rent in YB 45 ed. Roman 3, 11 12. 396 3 cf. YB 50 ed. Roman 3, 12 13 PL 2. 397 1 Covenant PL 17. 397 2 There is a colon here in both editions of the yearbooks, marking the beginning of a new argument. 397 3 Pakenham's case, YB 42 ed. Roman 3, 3 PL 14. 398 1 Bro. Covenant PL 5 CF. Spencer's case 5 Co Rep 16 A 17B 18A. 398 2 Horn's case YB 2 Hen, Roman 4, 6 PL 25. 399 1 Quad Conceditor. CF. Spencer's case 5 Co Rep 16 A 18A. 399 2 It was quite possible that two liabilities should exist side by side. Bro. Covenant PL 32 Brett v. Cumberland Crow, Jack, 521 523. 399 31 Co-Rep 122B, SC sub nom. Dillon v. Frayne, Popham 70 71. 401 Essays in Ang. Sachs, Law 248. 402 YB 22 ed. I 494, 496. 403 YB 4 ed. Roman 3, 57 PL, 71 SC 7 ed. Roman 3, 65 PL, 67. 401 1 Bracht, Fall, 17B 37B, Fleta Roman 3, C14 Section 6 1 Britain Nish, 223 233 244 255 312, Abreve, Plaque P, 308 Call 2 Dunelm Rot, 43 33I YB 20 ed. I 232 Co. Lit. 384b. 401 2 Hyde v. Dean of Windsor, Crow, Eliz, 552. 401 3 Spencer's case, 5 Co. Rep 16 ACF. Mincehill v. Oakes, 2H, and N 793, 807. 402 1 Hyde v. Dean of Windsor, Crow, Eliz, 552 553, SC IB 457. CF. Bawley v. Wells, 3 Wilson, 25 29. 402 2 Dean of Windsor's case, 5 Co-Rep 24 at SC Moore 399 CF. Bro. Covenant PL 32. CF. Further, Conan v. Chemise W. Jones 245 7 Car. I. 403 1 FNB 181 N. Sir Henry Neville's case, Plowden 377 381. 403 2 Ewer v. Strickland, Crow, Jack 240. CF. Brett v. Cumberland 1 Roll R 359 360 Al Kamenley, SC Crow, Jack 399 521. 403 3 Coxon v. Cock Crow, Jack 125. 403 4 Sale v. Kitchingham, 10 Hod, 158 E12 Ann. 403 5 Supra, pp. 396, 398 400. Cf. However, Lord Wensleydale, in Robotham v. Wilson, 8 HLC 348, 362, and C above p. 391 as to rents. 404 1 4 Kent, 12th ed., 480 N1. 404 2, it is used in a somewhat different sense, is describing the relation between a tenant for life or years and a reversioner. Privity between them follows as an accidental consequence of their being as one tenant and sustaining a single persona between them. 406 1 Robotham v. Wilson, 8 HLC 348, 362, Lord Wensleydale. 406 2 Harbage v. Warwick, 3 Ext, 552, 556. 406 3 Robotham v. Wilson, 8 L and BL. 123, 143, 144. 404 45 Co-Rep 16, A. 407 1 YB 8 ed., Roman 4, 5 6 PL 1 22 ed., Roman 4, 6 PL 18, CF, 5 ed. Roman 4, 7 PL 16. 407 2 CF. Caleway 42B 46B 2BL, Com 329. 408 1 YB 14 Hen, Roman 8, 6 PL 5 CF. Chudley's case 1 Co-Rep 120A 122B SC Nom Dillon v. Frayne, Popham, 7072. 408 2 Lewin Trusts ch. I 7th ed., pp. 1615. 408 34 Inst. 85 Gilb, uses Sugged, 429 N6, Lewin Trusts 7th ed., pp. 15 228. 408 4 Burgess v. Wheat, 1 Eden, 177 203 246. 408 5 Lewin Trusts in Trod, 7th ed., p3. 408 6 1 Rich, Roman 3, c1, cf. Rex v. Holland, Align 14 Maynard's Arg, Bro, Fiefman's Al uses PL 44 Gilb, uses 26 asterisk Sugged ed. 50. 409 1/4 Inst. 85 SC Dyer 869 PL 50 Jenk, Cent. 6 C 30 cf. Gilb, uses 198 asterisk Sugged ed. 399. 409 2 Gilb, uses 35 asterisk Sugged ed. 70. 409 3 Thellels Dig, I16 PL 1. End of project. Gutenberg's The Common Law, by Oliver Wendell Holmes, Jr.